often used to distinguish the moral character of the legitimate rape victim from women who are regarded as morally debased or in some other way responsible for their own victimization. This type of feminist critique of rape law has informed many of the fundamental reform measures enacted in anti-rape legislation, including increased penalties for convicted rapists and changes in evidentiary rules to preclude attacks on the woman's moral character. These reforms limit the tactics attorneys might use to tarnish the image of the rape victim, but they operate within pre-existing social constructs that distinguish victims from non-victims on the basis of their sexual character. Thus, these reforms, while beneficial, do not challenge the background cultural narratives that undermine the credibility of black women. Because black women face subordination based on both race and gender, reforms of rape law and judicial procedures which are premised on narrow conceptions of gender subordination may not address the devaluation of black women. Much of the problem results from the way that certain gender expectations for women intersect with certain sexualized notions of race that are deeply entrenched in American culture. Sexualized images of African Americans go all the way back to Europeans' first engagement with Africans. Blacks have long been portrayed as more sexual, more earthy, more gratification-oriented. These sexualized images of race intersect with norms of women's sexuality, norms that are used to distinguish good women from bad, Madonnas from whores. Thus, black women are essentially prepackaged as bad women in cultural narratives about good women who can be raped and bad women who cannot. The discrediting of black trademark women's claims is the consequence of a complex APAA intersection of a gendered sexual system, 1. that constructs rules appropriate for good and bad women, and a race code that provides images defining the allegedly essential nature of black women. If these sexual images form even part of the cultural imagery of black women, then the very representation of a black female body at least suggests certain narratives that may make black women's rape either less believable or less important. These narratives may explain why rapes of black women are less likely to result in convictions and long prison terms than are rapes of white women. Rape_law_reform measures that do not in some way engage and challenge the narratives that are read onto black women's bodies are unlikely to affect the way that cultural beliefs oppress black women in rape trials. While the degree to which legal reform can directly challenge cultural beliefs that shape rape trials is limited, the very effort to mobilize political resources toward addressing the sexual oppression of black women can be an important first step in drawing greater attention to the problem. One obstacle to such an effort has been the failure of most anti-rape activists to analyze specifically the consequences of racism in the context of rape. In the absence of a direct attempt to address the racial dimensions of rape, black women are simply presumed to 370 the intersection of race and gender. Be represented in and benefited by prevailing feminist critiques. 3. Anti-racism and rape anti-racist critiques of rape law. Focus on how the law operates primarily to condemn rapes of white women by black men. While the heightened concern with protecting white women against black men has been primarily criticized as a form of discrimination against black men, it just as surely reflects devaluation of black women. This disregard for black women results from an exclusive focus on the consequences of the problem for black men. Of course, rape accusations historically have provided a justification for white terrorism against the black community, generating a legitimating power of such strength that it created a veil virtually impenetrable to appeals based on either humanity or fact. Ironically, while the fear of the black rapist was exploited to legitimate the practice of lynching, rape was not even alleged in most cases. The well-developed fear of black sexuality served primarily to increase white tolerance for racial terrorism as a prophylactic measure to keep blacks under control. Within the African American community, cases involving race-based accusations against black men have stood as hallmarks of racial injustice. The prosecution of the Scottsboro Boys and the Emmett Till tragedy, for example, triggered African American resistance to the rigid social codes of white supremacy. To the extent that tape of black women is thought to dramatize racism, JT is usually cast as an assault on black manhood, demonstrating his inability. Rape women, the direct assault on black womanhood is less frequently seen as an assault on the black community. The sexual politics that this limited reading of racism and rape engenders continues to play out today, as illustrated by the Mike Tyson rape/accused of raping them trial. The use of anti-racist rhetoric to mobilize support for Tyson represented an ongoing practice of viewing with considerable suspicion rape accusations against black men and interpreting sexual racism through a male-centered frame. The historical experience of black men has so completely occupied the dominant conceptions of racism and rape that there is little room to squeeze in the experiences of black women. Consequently, racial solidarity was continually raised as a rallying point on behalf of Tyson, but never on behalf of Desiree Washington, Tyson's black accuser. Leaders ranging from Benjamin Hooks to Louis Farrakhan expressed their support for Tyson, yet no established black leader voiced any concern for Washington. Thus, the fact that black men have often been falsely accused of raping white women underlies the anti-racist defense of black men accused of rape even when the accuser herself is a black woman. As a result of this continual emphasis on Polack male sexuality as the core issue in anti-racist critiques of rape, black women who raise claims of rape against black men are not only disregarded but also sometimes vilified within the African American community. One can only imagine the alienation experienced by a black rape survivor such as Desiree Washington when the accused rapist is embraced and defended as a victim of racism while she is, at best, disregarded and, at worst, ostracized and ridiculed. In contrast, Tyson was the beneficiary of the long-standing practice of using anti-racist rhetoric to deflect the injury suffered by black women victimized by black men. Some defended the support given to Tyson on the ground that all African Americans can readily imagine their sons, fathers, brothers, or uncles being wrongly accused of rape, yet daughters, mothers, sisters, and aunts also deserve at least a similar concern, since statistics show that black women are more likely to be raped than black men are to be falsely accused of it. Given the magnitude of black women's vulnerability to sexual violence, it is not unreasonable to expect as much concern for black women who are raped as is expressed for the men who are. Black leaders are not alone in their failure to empathize with or rally around black rape victims. Indeed, some black women were among Tyson's staunchest supporters and Washington's harshest critics. The media widely noted the lack of sympathy black women had for Washington. Barbara Walters used the observation as a way of challenging Washington's credibility, going so far as to press her for a reaction. The most troubling revelation was that many of the women who did not support Washington also doubted Tyson's story. These women did not sympathize with Washington because they believed that she had no business being in Tyson's hotel room at 2:00 a.m. A typical response was offered by one young black woman who stated, "She asked for it, she got it. It's not fair to cry rape." Indeed, some of the women who expressed their disdain for Washington acknowledged that they encountered the threat of sexual assault almost daily. Yet it may be precisely this threat along with the relative absence of rhetorical strategies challenging the sexual subordination of black women that animated their harsh criticism. In this regard, black women who condemned Washington were quite like all other women who seek to distance themselves from rape victims as a way of denying their own vulnerability. Prosecutors who handle sexual assault cases acknowledge that they often exclude women as potential jurors because women tend to empathize least with the victim registered. To identify too closely with victimization may reveal their own vulnerability. Consequently, women often look for evidence that the victim brought the rape on herself, usually by breaking social rules that are generally held applicable only to women. And when the rules classify women as dumb, loose, or weak, on the one hand, and smart, discriminating, and strong, on the other, it is not surprising that women who cannot step outside the rules to critique them would attempt to validate themselves within them. The position of most black women on this issue is particularly problematic, first, because of the extent to which they are consistently reminded that they are the group most vulnerable to sexual victimization, and, second, because most black women share the African American community's general resistance to explicitly feminist analysis when it appears to run up against long-standing narratives that construct black men as the primary victims of sexual racism. See Rape and Intersectionality in Social Science. The marginalization of black women's experiences within the anti-racist and feminist critiques of rape law are facilitated by social science studies that fail to examine the ways in which racism and sexism converge. Gary Lawfree's Rape and Criminal Justice, The Social Construction of Sexual Assault is a classic example. Degree Through a study of rape prosecutions in Minneapolis, Lawfree attempts to determine the validity of two prevailing claims regarding rape prosecutions. The first claim is that black defendants face significant racial discrimination. The second is that rape laws serve to regulate the sexual conduct of women by withholding from rape victims the ability to invoke sexual assault law when they have engaged in non-traditional behavior. Lawfree's compelling study concludes that law constructs rape in ways that continue to manifest both racial and gender domination. Registered Although black women are positioned as victims of both the racism and the sexism that Lawfree so persuasively details, his analysis is less illuminating than might be expected, because black women fall through the cracks of his dichotomized theoretical framework. Racial domination and rape. Lawfree confirms the findings of earlier studies which show that race is a significant determinant in the ultimate disposition of rape cases. He finds that black men accused of raping white women were treated most harshly, while black offenders accused of raping black women were treated most leniently. These effects held true even after controlling for other factors such as injury to the victim and acquaintance between victim and assailant. Compared to other defendants, blacks who were suspected of assaulting white women received more serious charges, were more likely to have their cases filed as felonies, were more likely to receive prison sentences if convicted, were more likely to be incarcerated in the state penitentiary, as Op. 372. The intersection of race and gender. Posed to a jail or minimum security facility, and received longer sentences on the average. Copyright. Lawfree's conclusions that black men are differentially punished depending on the race of the victim do not, however, contribute much to understanding the plight of black rape victims. Part of the problem lies in the author's use of sexual stratification theory, which posits both that women are differently valued according to their race and that there are certain rules of sexual access governing who may have sexual contact with whom in this sexually stratified market. According to the theory, black men are discriminated against in that their forced access to white women is more harshly penalized than their forced access to black women. Lawfree's analysis focuses on the harsh regulation of access by black men to white women, but is silent about the relative subordination of black women to white women. The emphasis on differential access to women is consistent with analytical perspectives that view racism primarily in terms of the inequality between men. From this prevailing viewpoint, the problem of discrimination is that white men can rape black women with relative impunity while black men cannot do the same with white women. Black women are considered victims of discrimination only to the extent that white men can rape them without fear of significant punishment. Rather than being viewed as victims of discrimination in their own right, they become merely the means by which discrimination against black men can be recognized. The inevitable result of this orientation is that efforts to fight discrimination tend to ignore the particularly vulnerable position of black women, who must both confront racial bias and challenge their status as instruments, rather than beneficiaries, of the civil rights struggle. Where racial discrimination is framed by Lawfree primarily in terms of a contest between black and white men over women, the racism experienced by black women will only be seen in terms of white male access to them. When rape of black women by white men is eliminated as a factor in the analysis, whether for statistical or other reasons, racial discrimination against black women no longer matters, since Lawfree's analysis involves comparing the access of white and black men to white women. Yet discrimination against black women does not result simply from white men raping them with little sanction and being punished less than black men who rape white women, nor from white men raping them but not being punished as white men who rape white women would be. Black women are also discriminated against because intraracial rape of white women is treated more seriously than is intraracial rape of black women. However, the differential protection that black and white women receive against intraracial rape is not seen as racist because intraracial rape does not involve a contest between black and white men. In other words, the way the criminal justice system treats rapes of black women by black men and rapes of white women by white men is not seen as raising issues of racism, because black and white men are not involved with each other's women. In sum, black women who are raped are racially discriminated against because their rapists, whether black or white, are less likely to be charged with rape, and, when charged and convicted, their rapists are less likely to receive significant jail time than are the rapists of white women. While sexual stratification theory does posit that women are stratified sexually by race, most applications of the theory focus on the inequality of male agents of rape rather than on the inequality of rape victims, thus marginalizing the racist treatment of black women by consistently portraying racism in terms of the relative power of black and white men. In order to understand, and treat the victim, racism and of sexism, it is necessary to shift the analysis away from the differential access of men, and more toward the differential protection of women. Throughout his analysis, Laufrey fails to do so. His sexual stratification thesis in particular, its focus on the comparative power of male agents of rape illustrates how the marginalization of black women in anti-racist politics is replicated in social science research. Indeed, the thesis leaves unproblematized the racist subordination of less valuable objects, black women, to more valuable objects. A 373. White women, and it perpetuates the sexist treatment of women as property extensions of their men. 2. Rape and gender subordination. Although Laufrey does attempt to address gender-related concerns of women in his discussion of rape and the social control of women, his theory of sexual stratification fails to focus sufficiently on the effects of stratification on women. Laufrey quite explicitly uses a framework that treats race and gender as separate categories, but he gives no indication that he understands how black women may fall between categories, or within both. The problem with Laufrey's analysis lies not in its individual observations, which can be insightful and accurate, but rather in his failure to connect them and to develop a broader, deeper perspective. His two-track framework makes for a narrow interpretation of the data because it leaves untouched the possibility that these two tracks may intersect. Further, it is those who exist at the intersection of gender and race discrimination, black women, who suffer from this fundamental oversight. Laufrey attempts to test the feminist hypothesis that the application of law to nonconformist women in rape cases may serve to control the behavior of all women. This inquiry is important, he explains, because if women who violate traditional sex roles and are raped are unable to obtain justice through the legal system, then the law may be interpreted as an institutional arrangement for reinforcing women's gender role conformity. He finds that acquittals were more common and final sentences were shorter when non-traditional victim behavior was alleged. Thus, Laufrey concludes, the victim's moral character was more important than victim injury, indeed, was second only to the defendant's character. Overall, 82.3% of the traditional victim cases resulted in convictions and average sentences of 43 to 38 months. Only 50% of non-traditional victim cases led to convictions, with an average term of 27.83 months. The effects of traditional and non-traditional behavior by black women are difficult to determine from the information who they are given and must be inferred from Laufrey's passing comments. For example, he notes that black victims were evenly divided between traditional and non-traditional gender roles. This observation, together with the lower rate of conviction for men accused of raping blacks, suggests that gender role behavior was not as significant in determining case disposition as it was in cases involving white victims. Indeed, Laufrey explicitly notes that the victim's race was an important predictor of jurors' case evaluations. Copyright. Jurors were less likely to believe in a defendant's guilt when the victim was black. Our interviews with jurors suggested that part of the explanation for this effect was that jurors are influenced by stereotypes of black women as more likely to consent to sex or as more sexually experienced and hence less harmed by the assault. In a case involving the rape of a young black girl, one juror argued for acquittal on the grounds that a girl her age from that kind of neighborhood probably wasn't a virgin anyway. Lawfrey also notes that other jurors were simply less willing to believe the testimony of black complainants. One white juror is quoted as saying, "Negroes have a way of not telling the truth. They've a knack for coloring the story. So you know you can't believe everything they 71 say." Despite explicit evidence that the race of the victim is significant in determining the disposition of rape cases, Lawfrey concludes that rape law functions to penalize non-traditional behavior in women. Lawfrey fails to note that racial identification may in some cases serve as a proxy for non-traditional behavior. That is, rape law serves not only to parallelize actual examples of non-traditional behavior but also to diminish and devalue women who belong to groups in which non-traditional behavior once perceived as common. For the black rape victim, the disposition of her case may often turn less on her behavior than on her identity. Lawfrey misses the point that although white and black women have shared interests in resisting the Madonna/whore dichotomy altogether, they nevertheless experience its oppressive power differently. Black women continue to be judged by not by what they do. 374 The intersection of race and gender. 3. Compounding the marginalizations of rape. Lawfrey offers clear evidence that racial and sexual hierarchies subordinate black women to white women, as well as to men both black and white. However, the different effects of rape law on black women are scarcely mentioned in Lawfrey's conclusions. In a final section, Lawfrey treats the devaluation of black women as an aside, one without apparent ramifications for rape law. He concludes, the more severe treatment of black offenders who rape white women, or, for that matter, the milder treatment of black offenders who rape black women, is probably best explained in terms of racial discrimination within a broader context of continuing social and physical segregation between blacks and whites. Implicit throughout Lawfrey's study is the assumption that blacks who are subjected to social control are black men. Moreover, the social control to which he refers is limited to securing the boundaries between black males and white females. His conclusion that race differentials are best understood within the context of social segregation, as well as his emphasis on the interracial implications of boundary enforcement, overlook the intraracial dynamics of race and gender subordination. When black men are leniently punished for raping black women, the problem is best explained in terms of social segregation, but in terms of both the race and gender-based devaluation of black women. By failing to examine the sexist roots of such lenient punishment, Lawfrey and other writers sensitive to racism ironically repeat the mistakes of those who ignore race as a factor in such cases. Both groups fail to consider directly the situation of black women. Studies like Lawfrey's do little to illuminate how the interaction of race, class, and non-traditional behavior affects the disposition of rape cases involving black women. Such an oversight is especially troubling given evidence that many cases involving black women are dismissed outright. Over 20% of rape complaints were recently dismissed as unfounded by the Oakland Police Department, which did not even interview many, if not most, of the women involved. Not coincidentally, the vast majority. The anti-racist agenda of the complainants were black and poor, many of them were substance abusers or prostitutes. Explaining their failure to pursue these complaints, the police remarked that those cases were hopelessly tainted by women who are transient, uncooperative, untruthful, or not credible as witnesses in court. For the effort to politicize violence against missions vain women will do little to address the experiences PRID of black and other non-white women until the PRTTAMFTION Valley IEEE ramifications of racial stratification among women are acknowledged. At the same time, suppressing the real intraracial violence against women of color. The effect of both these marginalizations is that women of color have no ready means to link their experiences with those of other women. This sense of isolation compounds efforts to politicize sexual violence within communities of color and perpetuates the deadly silence surrounding these issues. D. Implications. With respect to the rape of black women, race and gender converge in ways that are only vaguely understood. Unfortunately, the analytical frameworks that have traditionally informed both anti-rape and anti-racist agendas tend to focus only on single issues. They are thus incapable of developing solutions to the compound marginalization of black women victims, who, yet again, fall into the void between concerns about women's issues and concerns about racism. This dilemma is complicated by the role that cultural images play in the treatment of black women victims. That is, the most critical aspects of these problems may revolve less around the political agendas of separate racial and gender-sensitive groups, and more around the social and cultural devaluation of women of color. The stories our culture tells about the experience of women of color present another challenge and a further opportunity to apply and evaluate the usefulness of the intersectional critique. 2. Conclusion. His article has presented intersectionality as a way of framing the various interactions of race and gender in the context of Mapping the Margins 375. Violence against women of color. Yet intersectionality might be more broadly useful as a way of mediating the tension between assertions of multiple identity and the ongoing necessity of group politics. It is helpful in this regard to distinguish intersectionality from the closely related perspective of anti-essentialism, from which women of color have critically engaged white feminism for the absence of women of color, on the one hand, and for speaking for women of color, on the other. One rendition of this anti-essentialist critique that feminism essentializes the category woman owes a great deal to the postmodernist idea that categories we consider natural or merely representational are actually socially constructed in a linguistic economy of difference. While the F equals AD. Lescriptive project copyright postmodernism 7 questioning the ways in which meaning is socially constructed is generally sound. This critique sometimes misreads the meaning of social construction and distorts its political relevance. One version of anti-essentialism, embodying what might be called the vulgarized social construction thesis, is that since all categories are socially constructed, there is no such thing as, say, blacks or women, and thus it makes no sense to continue reproducing those categories by organizing around them. Even the Supreme Court has gotten into this act. In Metro Broadcasting Incorporated v. FCG, the court conservatives, in rhetoric that oozes vulgar constructionist smugness, proclaimed that any set-aside designed to increase the voices of minorities on the airwaves was itself based on a racist assumption that skin color is in some way connected to the likely content of one's broadcast. To say that a category such as race or gender socially constructed is not to say that category has no significance in our world. On the contrary, a large and continuing project for subordinated people, and indeed, one of the projects for which postmodern theories have been very helpful, is thinking about the way in which power has clustered around certain categories and is exercised against others. This project attempts to unveil the processes of subordination and the various ways in which those processes are experienced by people who are subordinated and people who are privileged by them. It is, then, a project that presumes that categories have meaning and consequences. This project's most pressing problem, in many if not most cases, is not the existence of the categories but, rather, the particular values attached to them and the way those values foster and create social hierarchies. This is not to deny that the process of categorization is itself an exercise of power. The story is much more complicated and nuanced than that. First, the process of categorizing or _1 and identity terms, naming is not unilateral. Subordinated people can and do participate, sometimes even subverting the naming process in empowering ways. One need only think about the historical subversion of the category black or the current transformation of queer to understand that categorization is not a one-way street. Clearly, there is unequal power, but there is nonetheless some degree of agency that people can and do exert in the politics of naming. Moreover, it is important to note that identity continues to be a site of resistance for members of different subordinated groups. We all can recognize the distinction between the claims "I am black" and the claim "I am a person who happens to be black." "I am black" takes the socially imposed identity and empowers it as an anchor of subjectivity. "I am black" becomes not simply a statement of resistance but also a positive discourse of self-identification, intimately linked to celebratory statements like the black nationalist "Black is beautiful." "I am a person who happens to be black," on the other hand, achieves self-identification by straining for a certain universality. In effect, "I am first a person," and for a concomitant dismissal of the imposed category, black, as contingent, circumstantial, non-determinant. There is truth in both characterizations, of course, but they function quite differently, depending on the political context. At this point in history, a strong case can be made that the most critical resistance strategy for disempowered groups wants to occupy and defend a politics of social location rather than to vacate and destroy it. Vulgar constructionism thus distorts the possibilities for meaningful identity politics by conflating at least _2 separate but closely linked manifestations of power. One is the power exercised. 376 equals the intersection of race and gender seats 5 cis simply through the process of categorization as such, but, rather, the myriadtion, the other, the bt sun eece in which those of us so defined have been zashen to have social and material consequences. Systematically subordinated. With particular while the former power facilitates the latter, guard to problems confronting women of color, the political implications of challenging one when identity politics fail us, as they frequently over the other, matter greatly. We can look at it is not primarily because those politics take debates over racial subordination throughout as natural certain categories that are socially history and see that, in each instance, there was constructed instead. It is because the descripa possibility of challenging either the construct_tive content of those categories and the narration of identity or the system of subordination_tives on which they are based have privileged based on that identity. Consider, for example, some experiences and excluded others. The segregation system in Plessy v. Ferguson. Registered along these lines, consider the controversy at issue were multiple dimensions of domina involving Clarence Thomas and Anita Hill. Including categorization, the sign of race, during the Senate hearings for the confirm on the subordination of those so labeled. Their underscoration of Clarence Thomas to the Supreme Court, were at least two targets for Plessy to challenge. Anita Hill, in bringing allegations of the construction of identity, what is a black, harassment against Thomas, was rhetorically and the system of subordination based on that disempowered in part because she fell between identity, can blacks and whites sit together on the dominant interpretations of feminism and a train. Plessy actually made both arguments, anti-racism. Caught between the competing Neroni against the coherence of race as a category, relative tropes of rape, advanced by feminists, the other against the subordination of those on the one hand, and lynching, advanced by deemed to be black. In his attack on the former, Thomas and his anti-racist supporters, on the Plessy argued that the segregation statutes other, the race and gender dimensions of her application to him, given his mixed race status, position could not be told. This dilemma was inappropriate. The court refused to see this be described as the consequence of anti-racisms as an attack on the coherence of the race system having essentialized blackness and feminisms and instead responded in a way that simply having essentialized womanhood. However, reproduced the black/white dichotomy that recognizing as much does not take us far Plessy was challenging. As we know, Plessy's enough, for the problem is not simply linguistic challenge to the segregation system was not or philosophical in nature, rather, it is successful either. In evaluating various races cali political, the narratives of gender are TAN's strategies today, it is useful to ask which based on the experience of white, middle class of Plessy's challenges would have been best for women, and the narratives of race are based on him to have won the challenge against the experience of black men. The solution does coherence of the racial categorization system or not merely entail arguing for the multiplicity of the challenge to the practice of segregation identities or challenging essentialism generally. The same question can be posed for Brown instead. In Hill's case, for example, it would be Board of Education? Which of two possible have been necessary to assert those crucial arguments was politically more empowering pecs of her location which were erased, even by that segregation was unconstitutional because many of her advocates that is, to state what the racial categorization system on which it was her difference made based was incoherent, or that segregation was as this analysis asserts, history and context unconstitutional because it was injurious to determine the utility of identity politics. How black children and oppressive to their then do we understand identity politics today, nitties? While it might strike some as a difficult especially in light of our recognition of multiple question, for the most part, the dimension of dimensions of identity. More specifically, what racial domination that has been most vexing does it mean to argue that gender identities to African Americans has not been the social have been obscured in anti-racist discourses, just AE on 377. As race identities have been obscured in feminist discourses? Does that mean we cannot talk about identity? Or instead, that any discourse about identity has to acknowledge how our identities are constructed through the intersection of multiple dimensions? A beginning response to these questions requires us first to recognize that the organized identity groups in which we find ourselves are in fact coalitions, or at least potential coalitions waiting to be formed. In the context of anti-racism, recognizing the ways in which the intersectional experiences of women of color are marginalized in prevailing conceptions of identity politics does not require that we give up attempts to organize as communities of color. Rather, intersectionality provides a basis for reconceptualizing race as a coalition between men and women of color. For example, in the area of rape, intersectionality provides a way of explaining why women of color must abandon the general argument that the interests of the community require the suppression of any confrontation around intraracial rape. Intersectionality may provide the means for dealing with other marginalizations as well. For example, race can also be a coalition of straight and gay people of color, and thus serve as a basis for critique of churches and other cultural institutions that reproduce heterosexism. With identity thus reconceptualized, it may be easier to understand the need for and to summon the courage to challenge groups that are after all, in one sense, home to us, in the name of the parts of us that are not made at home. This takes a great deal of energy and arouses intense anxiety. The most one could expect is that we will dare to speak against internal exclusions and marginalizations, that we might call attention to how the identity of the group has been centered on the intersectional identities of a few. Recognizing that identity politics takes place at the site where categories intersect thus seems more fruitful than challenging the possibility of talking about categories at all. Through an awareness of intersectionality, we can better acknowledge and ground the differences among us and negotiate the means by which these differences will find expression in constructing group politics. Punishing drug addicts who have babies, women of color, equality, and the right of privacy. Dorothy E. Roberts. Prologue 4. Former slave named Lizzie Williams recounted the beating of pregnant slave women on a Mississippi cotton plantation. "ISC nigger women dat was fixin' to be confined do something the white folks didn't like. Dey the white folks would dig a hole in the ground just big nuff fo her stomach, make her lie face down and whip her on the back to keep from hurting the child." In July 1989, Jennifer Clarice Johnson, a 23-year-old crack addict, became the first woman in the United States to be criminally convicted for exposing her baby to drugs while pregnant. Florida law enforcement officials charged Johnson with 2 counts of delivering a controlled substance to a minor after her 2 children tested positive for cocaine at birth. Because the relevant Florida drug law did not apply to fetuses, the prosecution invented a novel interpretation of the statute. The prosecution obtained Johnson's conviction for passing a cocaine metabolite from her body to her newborn infants during the 60-second period after birth and before the umbilical cord was cut. *I introduction. Growing number of women across the country have been charged with criminal offenses after giving birth to babies who test positive for drugs. The majority of these women, like Jennifer Johnson, are poor and black. Most are addicted to crack cocaine. The prosecution of drug-addicted mothers is part of an alarming trend toward greater state intervention into the lives of pregnant women under the rationale of protecting the fetuses from harm. This intervention has included compulsory medical treatment, greater restrictions on abortion, and increased supervision of pregnant women's conduct. The intersection of race and gender. Such government intrusion is particularly harsh for poor women of color. They are the least likely to obtain adequate prenatal care, the most vulnerable to government monitoring, and the least able to conform to the white, middle-class standard of motherhood. They are therefore the primary targets of government control. The prosecution of drug-addicted mothers involves two sepsis tensions. First, pun. Nancy pits the state's interest in protecting the future health of a child against the mother's interest in autonomy, over her reproductive life interests that until recently had not been thought to be in conflict. Second, such prosecutions represent one of two possible responses to the problem of drug-exposed babies. The government may choose either to help women have healthy pregnancies or to punish women for their prenatal conduct. Although it might seem that the state could pursue both of these avenues at once, the two responses are ultimately irreconcilable. Far from deterring injurious drug use, prosecution of drug-addicted mothers in fact deters pregnant women from using available health and counseling services, because it causes women to fear that, if they seek help, they could be reported to government authorities and charged with a crime. Moreover, prosecution blinds the public to the possibility of non-punitive solutions and to the inadequacy of the non-punitive solutions that are currently available. The debate between those who favor protecting the rights of the fetus and those who favor protecting the rights of the mother has been extensively waged in the literature. This article does not repeat the theoretical arguments for and against state intervention. Rather, it suggests that both sides of the debate have largely overlooked a critical aspect of government prosecution of drug-addicted mothers. Can we determine the legality of the prosecution simply by weighing the state's abstract interest in the fetus against the mother's abstract interest in autonomy? Can we determine whether the prosecutions are fair simply by deciding the duties a pregnant woman owes? Lean. 1385. To her fetus and then assessing whether the defendant has met them? Can we determine the constitutionality of the government's actions without considering the race of the women being singled out for prosecution? Before deciding whether the state's interest in preventing harm to the fetus justifies criminal sanctions against the mother, we must first understand the mother's competing perspective and the reasons for the state's choice of a punitive response. This article seeks to illuminate the current debate by examining the experiences of the class of women who are primarily affected: poor black women. Providing the perspective of poor black women offers two advantages. First, examining legal issues from the viewpoint of those whom they affect most helps to uncover the real reasons for state action and to explain the real harms that it causes. It exposes the way in which the prosecutions deny poor black women a facet of their humanity by punishing their reproductive choices. The government's choice of a punitive response perpetuates the historical devaluation of black women as mothers. Viewing the legal issues from the experiential standpoint of the defendants enhances our understanding of the constitutional dimensions of the state's conduct. Second, examining the constraints on poor black women's reproductive choices expands our understanding of reproductive freedom in particular and of the right of privacy in general. Much of the literature discussing reproductive freedom has adopted a white middle-class perspective, which focuses narrowly on abortion rights. The feminist critique of privacy doctrine has also neglected many of the concerns of poor women of color. Registered My analysis presumes that black women experience various forms of oppression simultaneously, as a complex interaction of race, gender, and class that is more than the sum of its parts. Registered, it is impossible to isolate any one of the components of this oppression or to separate the experiences that are attributable to one component from experiences attributable to the others. The prosecution of drug-addicted mothers cannot be explained as simply an issue of gender inequality. Poor black women have been selected for punishment as a result of an inseparable combination of their gender, race, and economic status. Their devaluation as mothers, which underlies the prosecutions, has its roots in the unique experience of slavery and has been perpetuated by complex social forces. Thus, for example, the focus of mainstream feminist legal thought on gender as the primary locus of oppression often forces women of color to fragment their experience in a way that does not reflect the reality of their lives. Angela Harris and others have presented a racial critique of this gender essentialism in feminist legal theory. By introducing the voices of black women, these critics have begun to reconstruct a feminist jurisprudence based on the historical, economic, and social diversity of women's experiences. This new jurisprudence must be used to reconsider the more particular discourse of reproductive rights. This article advances an account of the constitutionality of prosecutions of drug-addicted mothers, which explicitly considers the experiences of poor black women. The constitutional arguments are based on theories both of racial equality and of the right of privacy. I argue that punishing drug addicts who choose to carry their pregnancies to term unconstitutionally burdens the right to autonomy over reproductive decisions. Violation of poor black women's reproductive rights helps to perpetuate a racist hierarchy in our society. The prosecutions thus impose a standard of motherhood that is offensive to principles of both equality and privacy. This article provides insight into the particular and urgent struggle of women of color for reproductive freedom. Further, I intend my constitutional critique of the prosecutions to demonstrate the advantages of a discourse that combines elements of racial equality and privacy theories in advocating the reproductive rights of women of color. Although women accused of prenatal crimes can present their defenses only in court, judges are not the only government officials charged with a duty to uphold the Constitution. 386 The intersection of race and gender. Given the Supreme Court's current hostility to claims of substantive equality and reproductive rights, for my arguments might be directed more fruitfully to legislatures than to the courts. Point 2. Robin West, among others, has persuasively recharacterized the progressive interpretation of the constitutional guarantees of liberty and equality, such as the redistributive directive embodied in the 14th Amendment *degree, as political ideals to guide legislation, rather than as legal restraints on legislation. Legislatures may be more receptive than courts to the claim that punitive policies contribute to the subordinate status of black women. They can serve as a forum for presenting both a vision of a community free from racist standards imposed upon motherhood and as a means of collectively implementing that vision. This article translates the dehumanization that black women experience so that lawmakers may understand and reverse, or at least must confront, the injustice of the prosecutions. Registered Part 2 of this article presents background information about the recent prosecutions of drug-addicted mothers and explains why most of the defendants are poor and black. Part 2 sets out the context in which the prosecutions must be understood. The historical devaluation against intervention are inadequate to explain or challenge the criminal charges brought against drug-addicted mothers. Finally, Part 7 argues that punishing women for having babies violates their constitutional right of privacy for two reasons: it violates the right of autonomy of women over their reproductive decisions, and it creates an invidious government standard for childbearing. I discuss two benefits of privacy doctrine for advocating the reproductive rights of women of color: its emphasis on the value of personhood, and its protection against the abuse of government power. I argue, however, that the liberal interpretation of privacy is inadequate to eliminate the subordination of black women. I therefore suggest that a progressive understanding of privacy must acknowledge government's affirmative obligation to guarantee the rights of personhood and must recognize the connection between the right of privacy and racial equality. Background: the state's punitive response to drug-addicted mothers. A. The crack epidemic and the state's response. Crack cocaine appeared in America in the early 80s, and its abuse has grown to epidemic proportions. Crack is especially popular of black women as mothers. I discuss 3 among inner-city women * degree indeed, evidence aspects of this social phenomenon, the control of black women's reproductive lives during / shows that, in several urban areas in the United States, more women than men now smoke the abusive sterilization of black women, crack. Point 3. Most crack-addicted women are of and other women of color during this century, _ childbearing age, and many are pregnant *. This and the disproportionate removal of black j phenomenon has contributed to an explosion in drain from their families. I also describe how a popular mythology denigrating black motherhood has reinforced and legitimate this devaluation. Part 4 characterizes the prosecutions as punishing drug-addicted women for leaving babies. This approach exposes the impact that the government's punitive policy has on the devaluation of black women as mothers. Part V argues that the prosecutions violate the Equal Protection Clause because they are rooted in and perpetuate black subordination. Part 6 examines the legal scholarship opposing state intervention in the lives of pregnant women. I show that the typical arguments advanced. The number of newborns affected by maternal drug use, some experts estimate that as many as 375,000 drug-exposed infants are born every year. In many urban hospitals, the number of these newborns has quadrupled in the last 5 years. A widely cited 1988 study conducted by the National Association for Perinatal Addiction Research and Education, NAPRA, found that 1% of newborns in 36 hospitals surveyed were affected by their mother's illegal drug use during pregnancy. In several hospitals, the proportion of drug-exposed infants was as high as 15 and 25%. C. Babies born to drug-addicted mothers may suffer a variety of medical, developmental, and behavioral problems, depending on the nature of their mother's substance abuse. Immediate effects of cocaine exposure can include premature birth, low birth weight, and withdrawal symptoms *. Cocaine-exposed children have also exhibited neurobehavioral problems, such as mood dysfunction, organizational deficits, poor attention, and impaired human interaction, although it has not been determined whether these conditions are permanent. Congenital disorders and deformities have also been associated with cocaine use during pregnancy. According to NAPRA, babies exposed to cocaine have a tenfold greater risk of suffering sudden infant death syndrome, SIDS. Data on the extent and potential severity of the adverse effects of maternal cocaine use are controversial. The interpretation of studies of cocaine-exposed infants is often clouded by the presence of other fetal risk factors, such as the mother's use of additional drugs, cigarettes, or alcohol, and her socioeconomic status. For example, the health prospects of an infant are significantly threatened because pregnant addicts often receive little or no prenatal care and may be malnourished *. Moreover, because the medical community has given more attention to studies showing adverse effects of cocaine exposure than to those that deny these effects, the public has a distorted perception of the risks of maternal cocaine use. Researchers have not yet authoritatively determined the percentage of infants exposed to cocaine who actually experience adverse consequences. The response of state prosecutors, legislators, and judges to the problem of drug-exposed babies has been punitive. They have punished women who use drugs during pregnancy by depriving these mothers of custody of their children, by jailing them during their pregnancy, and by prosecuting them after their babies are born. The most common penalty for a mother's prenatal drug use is the permanent or temporary removal of her baby *. Registered hospitals in a number of states now screen newborns for evidence of drugs in their urine and report positive results to child welfare authorities. Point 4. Some child protection agencies institute neglect proceedings to obtain custody of babies with positive toxicologies based solely on these tests *. More and more government authorities are also removing drug-exposed newborns from their mothers immediately after birth pending an investigation of parental fitness. In these investigations, positive neonatal toxicologies often raise a strong presumption of parental unfitness. Circumventing the inquiry into the mother's ability to care for her child, which is customarily necessary to deprive a parent of custody. For a second form of punishment is the protective incarceration of pregnant drug addicts charged with unrelated crimes. In 1988, a Washington, D.C., judge sentenced to jail for the duration of her pregnancy a 30-year-old woman named Brenda Vaughn, who pleaded guilty to forging $700 worth of checks. The judge stated at sentencing that he wanted to ensure that the baby would be born in jail to protect it from its mother's drug abuse. Although the Vaughn case has received the most attention, anecdotal evidence suggests that defendants' drug use during pregnancy often affects judges' sentencing decisions. Finally, women have been prosecuted after the birth of their children for having exposed the fetuses to drugs or alcohol. Creative statutory interpretations that once seemed little more than the outlandish concoctions of conservative scholars registered are now used to punish women. Mothers of children affected by prenatal substance abuse have been charged with crimes such as distributing drugs to a minor, child abuse and neglect, manslaughter, and assault with a deadly weapon. This article considers the constitutional implications of criminal prosecution of drug-addicted mothers because, as Part 4 explains, this penalty most directly punishes poor black women for having babies. When the government prosecutes, its intervention is not designed to protect babies from the irresponsible actions of their mothers, as is arguably the case when the state takes custody of a pregnant addict or 388 the intersection of race and gender. Her child. Rather, the government criminalizes the mother as a consequence of her decision to bear a child. b. The disproportionate impact on poor black women. Poor black women bear the brunt of prosecutors' punitive approach. These women are the primary targets of prosecutors, not because they are more likely to be guilty of fetal abuse, but because they are black and poor. Poor women, who are disproportionately black, are in closer contact with government agencies, and their drug use is therefore more likely to be detected. Black women are also more likely to be reported to government authorities, in part because of the racist attitudes of healthcare professionals. Finally, their failure to meet society's age of the ideal mother makes their prosecution more acceptable. To charge drug-addicted mothers with crimes, the state must be able to identify those who use drugs during pregnancy. Because poor women are generally under greater government supervision through their associations with public hospitals, welfare agencies, and probation officers, their drug use is more likely to be detected and reported. Hospital screening practices result in disproportionate reporting of poor black women. The government's main source of information about prenatal drug use is hospitals' reporting of positive infant toxicologies to child welfare authorities. This testing is implemented almost exclusively by hospitals serving poor minority communities. Private physicians who serve more affluent women perform less of this screening for two reasons: they have a financial stake both in retaining their patients' business and securing referrals from them, and they are socially more like their patients. Hospitals administer drug tests in a manner that further discriminates against poor black women. One common criterion triggering an infant toxicology screen is the mother's failure to obtain prenatal care. A factor that correlates strongly with race and income. Worse still, many hospitals have no formal screening procedures, relying solely on the suspicions of health care professionals. This discretion allows doctors and hospital staff to perform tests based on their stereotyped assumptions about drug addicts. Healthcare professionals are much more likely to report black women's drug use to government authorities than they are similar drug use by their wealthy white patients. A study recently reported in the New England Journal of Medicine demonstrated this racial bias in the reporting of maternal drug use. Researchers studied the results of toxicologic tests of pregnant women who received prenatal care in public health clinics and in private obstetrical offices in Pinellas County, Florida. Substance abuse by pregnant women did not correlate substantively with racial or economic categories, nor was there any significant difference between public clinics and private offices. Despite similar rates of substance abuse, however, black women were 10 times more likely than whites to be reported to public health authorities for substance abuse during pregnancy. Although several possible explanations can account for this disparate reporting, both public health facilities and private doctors are more inclined to turn in pregnant black women who use drugs than pregnant white women who use drugs. It is also significant that, out of the universe of material conduct that can injure a fetus, prosecutors have focused on crack use. The selection of crack addition for punishment can be justified neither by the number of addicts nor the extent of the harm to the fetuses. Excessive alcohol consumption during pregnancy, for example, can cause severe fetal injury. Registered degree and marijuana use may also adversely affect the unborn. The incidence of both these types of substance abuse is high as well. Registered. In addition, prosecutors do not always base their claims on actual harm to the child, rather, they base it on the mere delivery of crack by the mother. Registered. Although different forms of substance abuse prevail among pregnant women of various socioeconomic levels and racial and ethnic backgrounds, inner city black communities have the highest concentrations of crack addicts. Degree. Therefore, selecting crack abuse as the primary fetal harm to be punished has a discriminatory impact that cannot be medically justified. Focusing on black crack addicts rather than on other perpetrators of fetal harm serves two broader social purposes. Registered. First, prosecution of these pregnant women serves to degrade women whom society views as undeserving to be mothers and to discourage them from having children. If prosecutors had instead chosen to prosecute affluent women addicted to alcohol or prescription medication, the policy of criminalizing prenatal conduct very likely would have suffered a hasty demise. Society is much more willing to condone the punishment of poor women of color who fail to meet the middle-class ideal of motherhood. In addition to legitimizing fetal rights enforcement, the prosecution of crack-addicted mothers diverts public attention from social ills such as poverty, racism, and a misguided national health policy implying instead that shamefully high black infant death rates 87 are caused by the bad acts of individual mothers. Poor black mothers thus become the scapegoats for the black community's ill health. Punishing them assuages any guilt the nation might feel at the plight of an underclass with infant mortality at rates higher than those in some less developed countries. 8. Making criminals of black mothers apparently helps to relieve the nation of the burden of creating a health care system that ensures healthy babies for all its citizens. Registered. For a variety of reasons, then, an informed appraisal of the competing interests involved in the prosecutions must take account of the race of the women affected. Part 3 examines a significant aspect of black women's experience that underlies the punishment of crack-addicted mothers. Tuesday devaluation of black motherhood. Forfait systematic, institutionalized denial of reproductive freedom has uniquely marked black women's history in America. An important part of this denial has been the devaluation of black women as mothers. A popular mythology that degrades black women and poor 389. Trays them as less deserving of motherhood reinforces this subordination. This mythology is one aspect of a complex set of images that deny black humanity in order to rationalize the oppression of blacks. In this part, I will discuss three manifestations of the devaluation of black motherhood: the original exploitation of black women during slavery, the more contemporary, disproportionate removal of black children from their mother's custody, and sterilization abuse. Throughout this part, I will also show how several popular images denigrating black mothers, the licentious Jezebel, the careless, incompetent mother, the domineering matriarch, and the lazy welfare mother have reinforced and legitimate their devaluation. A. The slavery experience. The essence of black women's experience during slavery was the brutal denial of autonomy over reproduction. Female slaves were commercially valuable to their masters not only for their labor but also for their capacity to produce more slaves. Henry Louis Gates, Jr., writing about the autobiography of a slave named Harriet A. Jacobs, observes that it charts in vivid detail precisely how the shape of her life and the choices she makes are defined by her reduction to a sexual object, an object to be raped, bred or abused. Black women's childbearing during slavery was thus largely a product of oppression rather than an expression of self-definition and personhood. The method of whipping pregnant slaves that was used throughout the South vividly illustrates the slave owners' dual interest in black women as workers and child-bearers. Slave owners forced women to lie face down in a depression in the ground while they were whipped, thus allowing the masters to protect the fetus while abusing the mother. It serves as a powerful metaphor for the evils of a fetal protection policy that denies the humanity of the mother. It is also a forceful symbol of the convergent oppressions inflicted on slave women. They were subjugated at once both as blacks and as females. From slavery on, black women have fallen. 390 The intersection of race and gender outside the scope of the American ideal of womanhood. Slave owners forced slave women to perform strenuous labor, which contravened the Victorian female roles prevalent in the dominant white society. Angela Davis has observed. Judged by the evolving 19th-century ideology of femininity, which emphasized women's roles as nurturing mothers and gentle companions and housekeepers for their husbands, black women were practically anomalies. Black women's historical deviation from traditional female roles has engendered a mythology that denies their womanhood. One of the most prevalent images of slave women was the character of Jezebel, a woman governed by her sexual desires. As early as 1736, the South Carolina Gazette described African ladies as women of strong robust constitution who were not easily jaded out but able to serve their lovers by night as well as day. This ideological construct of the licentious Jezebel legitimate white men's sexual abuse of black women, registered the stereotype of black women as sexually promiscuous helped to perpetuate their devaluation as mothers. The myth of the bad black woman was deliberately and systematically perpetuated after slavery ended. For example, historian Philip A. Bruce's book The Plantation Negro as a Freeman, published in 1889, strengthened popular views of black degeneracy, male and female. 1 degree Bruce traced the alleged propensity of the black man to rape white women to the wantonness of the women of his own race and the sexual laxness of plantation women as a class. 1 degree. This image of the sexually loose, impure black woman, which originated in slavery, persists in modern American culture. 1 Under slavery, black women were also systematically denied the rights of motherhood. Slave mothers had no legal claim to their children. Slave masters owned not only black women but also their children. They alienated slave women from their children by selling them to other slave owners and by controlling child rearing. In 1851, Sojourner Truth reminded the audience at a women's rights convention that society denied black women even the limb. Dignity of Victorian womanhood accorded white women of the time, including the right of mothering. Dat man over dar say dat women needs to be helped into carriages, and lifted over ditches, and to have the best place every war. Nobody ever heap me into carriages, or over mud puddles, or gives me any best place. An arntia woman? Look at me. Look at my arm. I have plowed, and planted, and gathered into barns, and no man could head me. An arntia woman? I could work as much and eat as much as a man, when I could get it, and bear the lash as well. An arntia woman? I have borne 13 children and seen mos all sold off into slavery, and when I cried out with a mother's grief, none but Jesus heard. An arntia woman. Black women struggled in many ways to resist the efforts of slave masters to control their reproductive lives. They used contraceptives and abortifacients, escaped from plantations, feigned illness, endured severe punishment, and fought back rather than submit to slave masters' sexual domination. Free black women with the means to do so purchased freedom for their daughters and sisters. 1 degree Black women, along with black men, succeeded remarkably often in maintaining the integrity of their family life despite slavery's disrupting effects. Degree B. The disproportionate removal of black children. The disproportionate number of black mothers who lose custody of their children through the child welfare system is a contemporary manifestation of the devaluation of black motherhood. This disparate impact of state intervention results in part from black families' higher rate of reliance on government welfare. 1 degree Because welfare families are subject to supervision by social workers, instances of perceived neglect are more likely to be reported to governmental authorities than neglect on the part of more affluent parents. Black children are also removed from their homes in part because of the child welfare system's cultural bias and application of the nuclear family pattern to black families. Black child-rearing patterns that diverge from the norm of the nuclear family have been misinterpreted by government bureaucrats as child neglect. For example, child welfare workers have often failed to respect the long-standing cultural tradition in the black community of shared parenting responsibility among blood-related and non-blood kin. 14 The state has thus been more willing to intrude upon the autonomy of poor black families, and in particular of black mothers, while protecting the integrity of white, middle-class homes. This devaluation of black motherhood has been reinforced by stereotypes that blame black mothers for the problems of the black family. This scapegoating dates back to slavery, when black mothers were blamed for the devastating effects on their children of both poverty and the abuse of black women. When a 1-month-old slave girl named Harriet died in the Abbeville district of South Carolina on December 9, 1849, the census marshal reported the cause of death as smothered by carelessness of her mother. 1 This report was typical of the U.S. Census mortality schedules for the southern states in its attribution of a black infant death to accidental suffocation by the mother. 7 Census Marshal Charles M. Pellet explained, "I wish it to be distinctly understood that nearly all the accidents occur in the Negro population, which goes clearly to prove their great carelessness and total inability to take care of themselves." 8 It now appears that the true cause of these suffocation deaths was sudden infant death syndrome. Black children died at a dramatically higher rate because of the hard physical work, poor nutrition, and abuse that their slave mothers endured during pregnancy. 12 The scapegoating of black mothers has manifested itself more recently in the myth of the black matriarch, the domineering female head of the black family. White sociologists have held black matriarchs responsible for the disintegration of the black family and the consequent failure of black people to achieve success in America too. Daniel Patrick Moynihan popularized this theory in his 1965 report, The Negro Family, The Case for National Action. According to Moynihan, at the heart of the deterioration of the fabric of the Negro society is the deterioration of the Negro family. It is 391. The fundamental cause of the weakness of the Negro community. In essence, the Negro community has been forced into a matriarchal structure which, because it is so out of line with the rest of the American society, seriously retards the progress of the group as a whole. Thus, Moynihan attributed the cause of black people's inability to overcome the effects of racism largely to the dominance of black mothers. See the sterilization of women of color. Coerced sterilization is one of the most extreme forms of control over a woman's reproductive life. By permanently denying her the right to bear children, sterilization enforces society's determination that a woman does not deserve to be a mother. Unlike white women, poor women of color have been subjected to sterilization abuse, 24 for decades. 2 The disproportionate sterilization of black women is yet another manifestation of the dominant society's devaluation of black women as mothers. Sterilization abuse has taken the form both of blatant coercion and trickery and of subtle influences on women's decisions to be sterilized. 2 In the 70s, some doctors conditioned delivering babies and performing abortions on black women's consent to sterilization. In a 1974 case brought by poor teenage black women in Alabama, a federal district court found that an estimated 100,000 to 150,000 poor women were sterilized annually under federally funded programs. Some of these women were coerced into agreeing to sterilization under the threat that their welfare benefits would be withdrawn unless they submitted to the operation. Despite federal and state regulations intended to prevent involuntary sterilization, physicians and other health care providers continue to urge women of color to consent to sterilization because they view these women's family sizes as excessive and believe these women are incapable of effectively using other methods of birth control. 13 Current government funding policy perpetuates the encouragement of sterilization of poor, and thus of mainly black, women. The federal government pays for sterilization services under 392. The intersection of race and gender. The Medicaid program, +1, while it often does not provide or encourage information about or access to other contraceptive techniques and abortion. In effect, sterilization is the only publicly funded birth control method readily available to poor women of color. Popular images of the undeserving black mother serve to legitimate government policy as well as the practices of healthcare providers. The myth of the black Jezebel has been supplemented by the contemporary image of the lazy welfare mother who breeds children at the expense of taxpayers in order to increase the amount of her welfare check. Degree. This view of black motherhood provides the rationale for society's restrictions on black female fertility. It is this image of the undeserving black mother that ultimately underlies the government's choice to punish crack-addicted women. For prosecuting drug addicts as punishment for having babies. Informed by the historical and present devaluation of black motherhood, we can better understand prosecutors' reasons for punishing drug-addicted mothers. This article views such prosecutions as punishing these women, in essence, for having babies. Judges such as the one who convicted Jennifer Johnson are pronouncing, "Not so much I care about your baby as you don't deserve to be a mother." It is important to recognize at the outset that the prosecutions are based in part on a woman's pregnancy and not on her illegal drug use alone. 3-degree prosecutors charge these defendants not with drug use but with child abuse or drug distribution crimes that relate to their pregnancy. Moreover, pregnant women receive harsher sentences than do drug-addicted men or women who are not pregnant. Degree. The unlawful nature of drug use must not be allowed to confuse the basis of the crimes at issue. The legal rationale underlying the prosecutions does not depend on the illegality of drug use. Harm to the fetus is the crux of the government's legal theory. Criminal charges have been brought against women for conduct that is legal but is alleged to have harmed the fetus. 97. When a drug-addicted woman becomes pregnant, she has only one realistic avenue to escape criminal charges: abortion. Thus, she is penalized for choosing to have the baby rather than choosing to have an abortion. In this way, the state's punitive action may coerce women to have abortions rather than risk being charged with a crime. Thus, it is the choice of carrying a pregnancy to term that is being penalized. There is also good reason to question the government's justification for the prosecutions: the concern for the welfare of potential children. I have already discussed the selectivity of the prosecutions with respect to poor black women. Degree. This focus on the conduct of one group of women weakens the state's rationale for the prosecutions. The history of overwhelming state neglect of black children casts further doubt on its professed concern for the welfare of the fetus. When a society has always closed its eyes to the inadequacy of prenatal care available to poor black women, its current expression of interest in the health of unborn black children must be viewed with suspicion. The most telling evidence of the state's disregard of black children is the high rate of infant death in the black community. In 1987, the mortality rate for black infants in the United States was 17.9 deaths per thousand births, more than twice the figure of 8.6 for white infants. 141 in New York City. While infant mortality rates in upper and middle income areas were generally less than 9 per thousand in 1986, the rates exceeded 19 in the poor black communities of the South Bronx and Bedford-Stuyvesant and reached 27.6 in central Harlem. The main reason for these high mortality rates is inadequate prenatal care. Most poor black women face financial and other barriers to receiving proper care during pregnancy. 4 In 1986, only half of all pregnant black women in the United States received adequate prenatal care. Degree. It appears that in the 80s, black women's access to prenatal care has actually declined. 4 Copyright. The government has chosen to punish poor black women rather than to provide the means for them to have healthy children. The cruelty of this punitive response is TTRL. Heightened by the lack of available drug treatment services for pregnant drug addicts. Protecting the welfare of drug addicts' children requires, among other things, adequate facilities for the mother's drug treatment. Yet a drug addict's pregnancy serves as an obstacle to obtaining this treatment. Treatment centers either refuse to treat pregnant women or are effectively closed to them, Because the centers are ill-equipped to meet the needs of pregnant addicts. Point 4 Registered Most hospitals and programs that treat addiction exclude pregnant women because their babies are more likely to be born with health problems requiring expensive care. Asterisk program directors also feel that treating pregnant addicts is worth neither the increased cost nor the risk of tort liability. Moreover, there are several barriers to pregnant women who seek to use centers that will accept them. Drug treatment programs are generally based on male-oriented models that are not geared to the needs of women. Asterisk. The lack of accommodations for children is perhaps the most significant obstacle to treatment. Most outpatient clinics do not provide child care, and many residential treatment programs do not admit children. Asterisk. Furthermore, treatment programs have traditionally failed to provide the comprehensive services that women need, including prenatal and gynecological care, contraceptive counseling, appropriate job training, and counseling for sexual and physical abuse. 1 Predominantly male staffs and clients are often hostile to female clients and employ a confrontational style of therapy that makes many women uncomfortable. Moreover, long waiting lists make treatment useless for women who need help during the limited duration of their pregnancies. Finally, and perhaps most important, ample evidence reveals that prosecuting addicted mothers may not achieve the government's asserted goal of healthier pregnancies. Indeed, such prosecutions will probably lead to the opposite result. Pregnant addicts who seek help from public hospitals and clinics are the ones most often reported to government authorities. The threat of prosecution based on this reporting forces women to remain anonymous. 393. And thus has the reverse effect of deterring pregnant drug addicts from seeking treatment. For this reason, the government's decision to punish drug-addicted mothers is irreconcilable with the goal of helping them. Pregnancy may be a time when women are most motivated to seek treatment for drug addiction and to make positive lifestyle changes. The government should capitalize on this opportunity by encouraging drug-addicted women to seek help and by providing them with comprehensive treatment. Punishing pregnant women who use drugs only exacerbates the causes of addiction: poverty, lack of self-esteem, and hopelessness. Perversely, this makes it more likely that poor black women's children, the asserted beneficiaries of the prosecutions, will suffer from the same hardships. Punishing black mothers and the perpetuation of racial hierarchy. One previous part showed how recent prosecutions have penalized black women for their reproductive choices based in part on society's devaluation of black motherhood. This analysis implicates two constitutional protections, the Equal Protection Clause of the 14th Amendment and the right of privacy. These two constitutional challenges appeal to different but related values. They are related in the sense that underlying the protection of the individual's autonomy is the principle that all individuals are entitled to equal dignity. A basic premise of equality doctrine is that certain fundamental aspects of the human personality, including decisional autonomy, must be respected in all persons. Theories of racial equality and privacy can be used as related means to achieve a common end of eliminating the legacy of racial discrimination which has devalued black motherhood. Both aim to create a society in which black women's reproductive choices, including the decision to bear children, are given full respect and protection. The Equal Protection Clause embodies the Constitution's ideal of racial equality. Registered * state action that violates this ideal by creating classifications based on race must be subjected to 394 the intersection of race and gender. Strict judicial scrutiny. The Equal Protection Clause, however, does not explicitly define the meaning of equality or delineate the nature of prohibited government conduct. As a result, equal protection analyses generally have divided into two visions of equality, one that is informed by an anti-discrimination principle, the other by an anti-subordination principle. The anti-discrimination approach identifies the primary threat to equality as the government's failure to treat black people as individuals without regard to race. The goal of the anti-discrimination principle is to ensure that all members of society are treated in a colorblind or race-neutral fashion. Under this view of equality, the function of the Equal Protection Clause is to outlaw specific acts committed by individual government officials which discriminate against individual black complainants because of their race. Thus, this approach judges the legitimacy of government action from the perpetrator's perspective. The analysis focuses on the process by which government decisions are made and seeks to purge racial classifications from that process. The Supreme Court's current understanding of the Equal Protection Clause is based on a narrow interpretation of the anti-discrimination principle. 8. The Court has confined discrimination prohibited by the Constitution to state conduct performed with a discriminatory intent. 1. State conduct that disproportionately affects blacks violates the Constitution only if it is accompanied by a purposeful desire to produce this outcome. Although recognized violations are not limited to explicit racial classifications, an invidious purpose cannot be inferred solely from the adverse consequences of racially neutral policies. 177. A black complainant, therefore, need not produce a law that expressly differentiates between whites and blacks, but neither can she simply demonstrate that a colorblind law has a clearly disproportionate impact on blacks. As one commentator has noted, the justices have demanded proof that officials were out to get a person or group on account of race. 1/4 black women prosecuted for drug use during pregnancy nevertheless may be able to make out a prima facie case of discriminatory purpose. The court has recognized that a selection process characterized by broad government discretion that produces unexplained racial disparities may support the presumption of discriminatory purpose. 4. In Castaneda v. Partida for example, the court held that the defendant demonstrated a prima facie case of intentional discrimination in grand jury selection by showing a sufficiently large statistical disparity between the percentage of Mexican Americans in the population, 79%, and the percentage of those summoned, 39%, combined with a selection procedure that relied on the discretion of jury commissioners. Similarly, a black mother arrested in Pinellas County, Florida, could make out a prima facie case of unconstitutional racial discrimination by showing that a disproportionate number of those chosen for prosecution for exposing newborns to drugs are black. In particular, she could point out the disparity between the percentage of defendants who are black and the percentage of pregnant substance abusers who are black. 1. The above-mentioned New England Journal of Medicine study of pregnant women in Pinellas County found that only about 26% of those who used drugs were black, registered, yet over 90% of Florida prosecutions for drug abuse during pregnancy have been brought against black women. The defendant could buttress her case with the study's finding that, despite similar rates of substance abuse, black women were 10 times more likely than white women to be reported to public health authorities for substance abuse during pregnancy. In addition, the defendant could show that healthcare professionals and prosecutors wield a great deal of discretion in selecting women to be subjected to the criminal justice system. The burden would then shift to the state to dispel the inference of intentional discrimination by justifying the racial discrepancy in its prosecutions. The anti-subordination approach to equality would not require black defendants to prove that the prosecutions are motivated by racial CE 395 bias. Rather than requiring victims to prove distinct instances of discriminating behavior in the administrative process, the anti-subordination approach considers the concrete effects of government policy on the substantive condition of the disadvantaged. This perspective recognizes that racial subjugation is not maintained solely through the racially antagonistic acts of individual officials. Instead, it views social patterns and institutions that perpetuate the inferior status of blacks as the primary threats to equality. The goal of anti-subordination law is a society in which each member is guaranteed equal respect as a human being. Under this conception of equality, the function of the Equal Protection Clause is to dismantle racial hierarchy by eliminating state action or inaction that effectively preserves black subordination. The prosecution of drug-addicted mothers demonstrates the inadequacy of anti-discrimination analysis and the superiority of the anti-subordination approach. Rather than conform black women's experiences to the intent standard, we can use those experiences to reveal the narrow-mindedness of the Supreme Court's view of equality. First, the anti-discrimination approach may not adequately protect black women from prosecution's infringement of equality, because it is difficult to identify individual guilty actors, who are the government officials motivated by racial bias to punish black women. The hospital staff who test and report mothers to child welfare agencies. The prosecutors who develop and implement policies to charge women who use drugs during pregnancy. Legislators who enact laws protecting the unborn. It is unlikely that any of these individual actors intentionally singled out black women for punishment based on a conscious devaluation of their motherhood. The disproportionate impact of the prosecutions on poor black women does not result from such isolated, individualized decisions. Rather, it is a result of 2 centuries of systematic exclusion of black women from tangible and intangible benefits enjoyed by white society. Their exclusion is reflected in black women's reliance on public hospitals and public drug treatment centers, in their failure to obtain adequate prenatal care, in the more frequent reporting of black drug users by healthcare professionals, and in society's acquiescence in the government's punitive response to the problem of crack-addicted babies. More generally, the anti-discrimination principle mischaracterizes the role of social norms in perpetuating inequality. This view of equality perceives racism as disconnected acts by individuals who operate outside of the social fabric. 18. The goal of the Equal Protection Clause under this worldview is to separate from the masses of society those blameworthy individuals who are violating the otherwise shared norm. The prosecutions of drug-addicted mothers demonstrate how dramatically this perspective departs from reality. It is precisely a shared societal norm, the devaluation of black motherhood, that perpetuates the social conditions discussed above and explains why black women are particularly susceptible to prosecution. The court's vision of equality acquiesces in racist norms and institutions by exempting them from a standard that requires proof of illicit motive on the part of an individual governmental actor. The inability to identify and blame an individual government actor allows society to rationalize the disparate impact of the prosecutions as the result of the mother's own irresponsible actions. Formal equality theory thus legitimates the subordination of black women. In contrast to the anti-discrimination approach, anti-subordination theory mandates that equal protection law concern itself with the concrete ways in which government policy perpetuates the inferior status of black women. The law should listen to the voices of poor black mothers and seek to eliminate their experiences of subordination. From this perspective, the prosecutions of crack-addicted mothers are unconstitutional because they reinforce the myth of the undeserving black mother by singling out intentionally or not black women for punishment. The government's punitive policy reflects a long history of denigration of black mothers dating back to slavery, and it serves to perpetuate that legacy of unequal 396. Spect. The prosecutions should therefore be upheld only if the state can demonstrate that they serve a compelling interest that could not be achieved through less discriminatory means. 18. Although the state's asserted interest in ensuring the health of babies is substantial, prosecution does not advance that interest in a sufficiently narrow fashion. First, as I have noted, the government's punitive course of action is inimical to the goal of healthier pregnancies because it deters women from seeking help. 1. In addition, even if the prosecutions could be proved to further the state's interest in children's welfare, they would not survive the least restrictive alternative standard, which requires that even though the governmental purpose be legitimate and substantial, that purpose cannot be pursued by means that broadly stifle fundamental personal liberties when the end can be more narrowly achieved. A public commitment to providing adequate prenatal care for poor women and drug treatment programs that meet the needs of pregnant addicts would be a more effective means for the state to address the problem of drug-exposed babies. 1. By prosecuting crack-addicted mothers, the government helps to perpetuate the dominant society's devaluation of black motherhood. The anti-subordination analysis better uncovers this institutional, rather than individualistic, mechanism for maintaining racial inequality. The government's policy cannot withstand the scrutiny of an equality jurisprudence dedicated to eradicating hierarchies of racial privilege. Still, the focus purely on equality does not address the unique significance of punishing the decision to bear a child. The remainder of this article examines how the prosecutions violate black women's right of privacy and the relationship between that privacy analysis and the goal of racial equality. 6. A critical assessment of arguments against intervention. Here is now a substantial body of scholarship challenging state intervention in pregnant women's conduct. Yet much of the literature has not sufficiently taken into the intersection of race and gender account the experience of poor black women, the very women who are most affected. In addition, the literature has failed to address adequately the arguments on behalf of fetal protection. In this part, I will critique various reproductive rights theories that have been used to challenge the control of pregnant women and show why they are not helpful in addressing the prosecution of drug-addicted mothers. In Part 7, I will present a privacy argument that more effectively confronts the government's policy. That analysis better explains the constitutional injury caused by the prosecutions because it recognizes race as a critical factor. A. Bodily autonomy and integrity. Much of the discourse challenging state intervention in the decisions of pregnant women has occurred in the context of forced medical treatment. Many commentators have argued that judicial decisions which allow doctors to perform surgery and other procedures on a pregnant woman without her consent violate women's right to bodily autonomy and integrity. 1 degree. It is difficult, however, to transfer the scholarship addressing compulsory medical procedures to the issue of drug-addicted mothers. The interests of the drug-addicted mother appear to be weaker for 3 reasons. First, unlike forced medical treatment, punishing the pregnant drug addict does not require her to take affirmative steps to benefit the fetus. She is not asked to be a good Samaritan, rather, she is punished for affirmatively doing harm to the fetus. Second, the prosecution of drug-addicted mothers involves no direct physical intrusion. Nor do prosecutions deprive women of control over their bodies by directly compelling them to undergo an unwanted biological process, as is the case with the prohibition of abortion. On this level, punishing drug-addicted mothers does not seem to implicate a mother's right to bodily integrity at all. Third, the mother's drug use has potentially devastating effects on the fetus and lacks any social justification. Indeed, forcing a woman to refrain from using harmful drugs through incarceration or court order may be seen as a benefit to the woman herself, whereas forced 397. Medical procedures often aid the fetus only at the expense of the mother's health or her deeply held religious beliefs. It is therefore harder to identify how the government's action infringes on a constitutionally protected interest. Consequently, some commentators who oppose the regulation of some potentially harmful conduct during pregnancy also justify punishment of pregnant drug users. We must therefore draw on another principle of autonomy to describe the infringement caused by these prosecutions: the right to make decisions about reproduction. In this context, this is the choice of carrying a pregnancy to term. In addition, many of the issues raised by forced medical treatment seem disconnected from the experiences of poor women of color. For example, much of the literature focuses on ethical issues arising from treating the fetus as a patient and its impact on the relationship between the pregnant woman and her physician. This debate is largely irrelevant to poor black women, the majority of whom receive inadequate prenatal care. Their major concern is not an ethical conflict with their doctor but, rather, affording or finding a doctor in the first place. The issue of whether intricate fetal surgery may be performed against a mother's will is far removed from the urgent needs of poor women who may not have available to them the most rudimentary means to ensure the health of the fetus. Forced treatment decisions equate women with inert vessels, disregard their own choices, and value them solely for their capacity to nurture a fetus. 2 Although this view of women is reflected as well in the prosecution of drug-addicted mothers, it does not grasp the full indignity of the state's treatment of poor black women. Government control of pregnancy perpetuates stereotypes that value women solely for their procreative capacity, but the prosecutions of crack addicts deny poor black women even this modicum of value. By punishing them for having babies, they are deemed not even worthy of the dignity of childbearing. Thus, The prosecutions debase black women even more than does forced medical treatment's general devaluation of women. B. The right to make medical and lifestyle decisions. A second approach challenges restrictions on maternal conduct during pregnancy by advocating a woman's right to make medical and lifestyle decisions. Degree. Rather than focus on a woman's right to protect her body from physical intrusion, this approach focuses on a woman's right to engage in activities of her choice free from government interference. This argument also loses its force in the context of maternal drug addiction. While the danger of government restrictions on a pregnant woman's normal conduct may be apparent, drug use during pregnancy arguably belongs in a separate category. The pregnant drug addict is not asked to refrain from generally acceptable behavior, such as sexual intercourse, work, or exercise. Rather, society demands only that she cease conduct that it already deems illegal and reprehensible. Arguments based on a woman's right to make decisions about her pregnancy and her fetus also appear weak in the context of maternal drug addiction. Unlike healthy mothers, pregnant drug addicts are not better able to make lifestyle and medical decisions that affect the fetus than is the state or a physician. Nor can we say that a decision to carry a fetus to term automatically demonstrates that a drug-addicted mother cares deeply for it and is in a better position than is the state to monitor her own conduct during pregnancy than is the state. Most would agree that the pregnant drug addict has exercised poor judgment in caring for herself and her fetus. The state should not substitute its judgment for that of the normal mother, but intervention in the case of the drug addict seems more justified. Although the government is arguably better able to make decisions about the care of the fetus than is the drug-addicted mother, it is quite a different matter to allow the government to determine who is entitled to be a mother. State interference in the decision to bear a child is constitutionally more significant than is state control of lifestyle decisions. The approach advocating interference in women's lifestyles also neglects the concerns of poor women of color. A common criticism of 398 the intersection of race and gender. The prosecution of drug-addicted mothers is that the imposition of maternal duties will, over time, lead to punishment for less egregious conduct. Commentators have predicted government penalties for cigarette smoking, consumption of alcohol, strenuous physical activity, and failure to follow a doctor's orders. Although valid, this argument ignores the reality of poor black women who are currently being arrested. The reference to a parade of future horribles to criticize the fetal rights doctrine belittles the significance of current government action. It seems to imply that the prosecution of black crack addicts is not enough to generate concern, and that we must postulate the prosecution of white middle-class women in order for the challenge to be meaningful. See the focus on abortion. Another aspect of the reproductive rights literature that limits our understanding of reproductive choice is its focus on abortion rights. One problem is that this focus provides an inadequate response to a central argument in support of the regulation of pregnancy. John Robertson, for example, has contended that if a woman forgoes her right to an abortion, she forfeits her right to autonomy and choice. If abortion lies at the heart of women's reproductive rights, then state policies that do not interfere with that right are acceptable. 7 degree asterisk. Similarly, if the full extent of reproductive freedom is the right to have an abortion, then a policy that encourages abortion, degree, such as the prosecution of crack-addicted mothers does not interfere with that freedom. Degree. As in the previous approaches, the emphasis on abortion fails to incorporate the needs of poor women of color. The primary concerns of white middle-class women are laws that restrict choices otherwise available to them, such as statutes that make it more difficult to obtain an abortion. However, the main concerns of poor women of color are the material conditions of poverty and oppression that restrict their choices. The reproductive freedom of poor women of color, for example, is limited significantly not only by the denial of access to safe abortions but also by the lack of resources necessary for a healthy pregnancy and parenting relationship. Their choices are limited not only by direct government interference with their decisions, but also by government's failure to facilitate them. The focus of reproductive rights discourse on abortion neglects this broader range of reproductive health issues that affect poor women of color. 7. Addressing the concerns of women of color will expand our vision of reproductive freedom to include the full scope of what it means to have control over one's reproductive life. Asterisk. 7. Claiming the right of privacy. For women of color. A. Identifying the constitutional issue. In deciding which of the competing interests involved in the prosecution of drug-addicted mothers prevails, the state's interest in protecting the health of the fetus or the woman's interest in preventing state intervention, it is essential as a matter of constitutional law to identify the precise nature of the woman's right at stake. In the Johnson case, the prosecutor framed the constitutional issue as follows. What constitutionally protected freedom did Jennifer engage in when she smoked cocaine? Asterisk. That was the wrong question. Johnson was not convicted of using drugs. Her constitutional right to smoke cocaine was never at issue. Johnson was prosecuted because she chose to carry her pregnancy to term while she was addicted to crack. Had she smoked cocaine during her pregnancy and then had an abortion, she would not have been charged with such a serious crime. Thus, the proper question is, what constitutionally protected freedom did Jennifer engage in when she decided to have a baby even though she was a drug addict? Understanding the prosecution of drug-addicted mothers as punishment for having babies clarifies the constitutional right at stake. The woman's right at issue is not the right to abuse drugs or to cause the fetus to be born with defects. Copyrighted is the right to choose to be a mother, which is burdened by the criminalization of conduct during pregnancy. Asterisk. This view of the constitutional issue reveals the relevance of race to the resolution of the competing Inter L. 399. Ests. Race has historically determined the value society places on an individual's right to choose motherhood. Because of the devaluation of black motherhood, protecting the right of black women to choose to bear a child has unique significance. In the following section, I argue that the prosecutions of addicted mothers violate traditional liberal notions of privacy. I also demonstrate how the issue of race informs the traditional analysis and calls for a reassessment of the use of privacy doctrine in the struggle to eliminate gender and racial subordination. B. Overview of privacy arguments. Prosecutions of drug-addicted mothers infringe on two aspects of the right to individual choice in reproductive decision-making. First, they infringe on the freedom to continue a pregnancy that is essential to an individual's personhood and autonomy. This freedom implies that state control of the decision to carry a pregnancy to term can be as pernicious as state control of the decision to terminate a pregnancy. Second, the prosecutions infringe on choice by imposing an invidious government standard for the entitlement to procreate. Such imposition of a government standard for childbearing is one way that society denies the humanity of those who are different. The first approach emphasizes a woman's right to autonomy over her reproductive life. The second highlights a woman's right to be valued equally as a human being. 7 * In other words, the prosecution of crack-addicted mothers infringes upon both a mother's right to make decisions that determine her individual identity and her right to be respected equally as a human being by recognizing the value of her motherhood. Inherent in the thesis of this article is a tension between the reliance on the liberal rhetoric of choice and an acknowledgement of the fallacy of choice for poor women of color. This article also seeks to incorporate liberal notions of individual autonomy while acknowledging the collective injury perpetrated by racism. 7. This tension may be an example of what Mari Matsuda calls multiple consciousness. 77 Matsuda observes that outsider lawyers and scholars must often adopt a dualist approach that incorporates an elitist legal system and the concept of legal rights while seeing the world from the standpoint of the oppressed. Unlike the postmodern critics of the left, outsiders, including feminists and people of color, have embraced legalism as a tool of necessity, making legal consciousness their own in order to attack injustice. 771 This internal struggle between the embrace of legalism and the recognition of oppression characterizes a process of enlightenment. Working through the privacy analysis from the perspective of poor black women uncovers unexplored benefits to be gained from liberal doctrine while revealing liberalism's inadequacies. This process of putting forth new propositions for challenge and subversion will produce a better understanding of the law and the ways in which it can be used to pursue social justice. See the right to choose procreation. Punishing drug-addicted mothers unconstitutionally burdens the right to choose to bear a child. Certain interests of the individual, generally called rights, are entitled to heightened protection against government interference under the Due Process Clause of the 14th Amendment. The right of privacy is recognized as one cluster of such interests, implicit in the liberty that the 14th Amendment protects. The right of privacy has been interpreted to include the interest in independence in making certain kinds of important decisions. This concept of decisional privacy seeks degree to protect intimate or personal affairs that are fundamental to an individual's identity and moral personhood from unjustified government intrusion. 7. At the forefront of the development of the right of privacy has been the freedom of personal choice in matters of marriage and family life. Once an interest has been deemed part of the right of privacy, the government needs a compelling reason to intervene to survive constitutional scrutiny. There is considerable support for the conclusion that the decision to procreate is part of the right of privacy. The decision to bear children is universally acknowledged in the privacy. 400. The intersection of race and gender cases as being at the very heart of these constitutionally protected choices. In Eisenstadt v. Baird, for example, the Supreme Court struck down a Massachusetts statute that prohibited the distribution of contraceptives to unmarried persons. Although the case was decided on equal protection grounds, the court recognized the vital nature of the freedom to choose whether to give birth to a child. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. 7. The right of privacy protects equally the choice to bear children and the choice to refrain from bearing them. The historical experiences of black women illustrate the evil of government control over procreative decisions. Their experiences demonstrate that the dual nature of the decisional right recognized in the privacy cases goes beyond the logical implications of making a choice. The exploitation of black women's foremothers during slavery to breed more slaves and the sterilization abuse that they have suffered reveal society's pervasive devaluation of black women as mothers. Burdening both the right to terminate a pregnancy and the right to give birth to a child violates a woman's personhood by denying her autonomy over the self-defining decision of whether she will bring another being into the world. Furthermore, criminalizing the choice to give birth imposes tangible burdens on women, as well as the intangible infringement on personhood. Punishing women for having babies is in this sense at least as pernicious as forced maternity at the behest of the state. 73. If a woman's decision to bear a child is entitled to constitutional protection, it follows that the government may not unduly burden that choice. In Cleveland Board of Education v. LaFleur, registered the court invalidated mandatory maternity leave policies that had the effect of burdening the choice to procreate. The court viewed the school board's policy of forced maternity leave as a form of penalty imposed on pregnant teachers for asserting their right to decide to have children. 7. Although the court applied a rational basis test to the maternity leave policies in LaFleur, the more drastic burden of criminal punishment should warrant strict scrutiny. Even under the court's current analysis, which distinguishes between direct and indirect governmental interference in reproductive decision-making, government intrusion as extreme as criminal prosecution would unduly infringe on protected autonomy. The court has expressly distinguished, for example, the government's refusal to subsidize the exercise of the abortion right from the infliction of criminal penalties on the exercise of that right. Criminal prosecutions of drug-addicted mothers do more than discourage a choice, they exact a severe penalty on the drug user for choosing to complete her pregnancy. These privacy concepts have two benefits for advocating the reproductive rights of women of color in particular. The right of privacy stresses the value of personhood, and it protects against the totalitarian abuse of government power. First, affirming black women's constitutional claim to personhood is particularly important, because these women historically have been denied the dignity of their full humanity and identity. 7. The principle of self-definition has special significance for black women. Angela Harris recognizes in the writings of Zora Neale Hurston an insistence on a conception of identity as a construction, not an essence. Black women have had to learn to construct themselves in a society that denied them full selves. Asterisk 44 Black woman's willful self-definition is an adaptation to a history of social denigration. Rejected from the dominant society's norm of womanhood, Black women have been forced to resort to their own internal resources. Harris contrasts this process of affirmative self-definition with the feminist paradigm of women as passive victims. Black women willfully create their own identities out of fragments of experience, not discovered in one's body or unveiled after male domination is eliminated. The concept of personhood embodied in the right of privacy can be used to affirm the role of will and creativity in Black women's construction of their own identities. Relying on the concept of self-definition celebrates the legacy 0 EEA 401 of Black women who have survived and transcended conditions of oppression. The process of defining oneself and declaring one's personhood defies the denial of self-ownership inherent in slavery. Thus, the right of privacy, with its affirmation of personhood, is especially suited for challenging the devaluation of Black motherhood underlying the prosecutions of drug-addicted women. Another important element of the right of privacy is its delineation of the limits of governmental power. The protection from government abuse also makes the right of privacy a useful legal tool for protecting the reproductive rights of women of color. Poor women of color are especially vulnerable to government control over their decisions. The government's pervasive involvement in Black women's lives illustrates the inadequacy of the privacy critique presented by some white feminist scholars. Point 2. Catherine McKinnon, for example, argues that privacy doctrine is based on the false liberal assumption that government non-intervention into the private sphere promotes women's autonomy. The individual woman's legal right of privacy, according to McKinnon, functions instead as a means of subordinating women's collective needs to the imperatives of male supremacy. This rejection of privacy doctrine does not take into account the contradictory meaning of the private sphere for women of color. Feminist legal theory focuses on the private realm of the family as an institution of violence and subordination. Women of color, however, often experience the family as the site of solace and resistance against racial oppression. For many women of color, the immediate concern in the area of reproductive rights is not abuse in the private sphere but abuse of government power. The prosecution of crack-addicted mothers and coerced sterilization are examples of state intervention which pose a much greater threat for women of color than for white women. Another telling example is the issue of child custody. The primary concern for white middle-class women with regard to child custody is private custody battles with their husbands following the termination of a marriage. Degree 4. Women of color, though, the dominant threat is termination of parental rights by the state. 7 Again, the imminent danger faced by poor women of color comes from the public sphere, not the private. Thus, the protection from government interference that privacy doctrine affords may have a different significance for women of color. Unconstitutional government standards for procreation, the intersection of privacy and equality. The Equal Protection Clause and the right of privacy provide the basis for two separate constitutional challenges to the prosecution of drug-addicted mothers. The singling out of Black mothers for punishment combines in a single government action several wrongs prohibited by both constitutional doctrines. Black mothers are denied autonomy over procreative decisions because of their race. The government's denial of Black women's fundamental right to choose to bear children serves to perpetuate the legacy of racial discrimination embodied in the devaluation of Black motherhood. The full scope of the government's violation can better be understood, then, by a constitutional theory that acknowledges the complementary and overlapping qualities of the Constitution's guarantees of equality and privacy. 7 8 Viewing the prosecutions as imposing a racist government standard for procreation uses this approach. Poor crack addicts are punished for having babies because they fail to measure up to the state's ideal of motherhood. Prosecutors have brought charges against women who use drugs during pregnancy without demonstrating any harm to the fetus. 2 Moreover, a government policy that has the effect of punishing primarily poor Black women for having babies evokes the specter of racial eugenics, especially in light of the history of sterilization abuse of women of color. 2°. These factors make clear that these women are not punished simply because they may harm their unborn children, rather, they are punished because the combination of their poverty, race, and drug addiction is seen as making them unworthy of procreating. 402. The intersection of race and gender. This aspect of the prosecutions implicates both equality and privacy interests. The right to bear children goes to the heart of what it means to be human. The value we place on individuals determines whether we see them as entitled to perpetuate themselves in their children. Denying a woman the right to bear children or punishing her for exercising that right deprives her of a basic part of her humanity. 7°. When this denial is based on race, it also functions to preserve a racial hierarchy that essentially disregards black humanity. The abuse of sterilization laws designed to effect eugenic policy demonstrates the potential danger of governmental standards for procreation. During the first half of the 20th century, the eugenics movement registered embraced the theory ** trademark that intelligence and other personality traits are genetically determined and therefore inherited. This hereditarian belief, coupled with the reform approach of the progressive era, fueled a campaign to remedy America's social problems by stemming biological degeneracy. Eugenicists advocated compulsory sterilization to prevent reproduction by people who were likely to produce allegedly defective offspring. Eugenic sterilization was thought to improve society by eliminating its socially inadequate members. Registered around the turn of the century, many states enacted involuntary sterilization laws directed at those deemed burdens on society, including the mentally retarded, mentally ill, epileptics, and criminals. In a 1927 decision, Buck v. Bell, the Supreme Court upheld the constitutionality registered of a Virginia involuntary sterilization law. The plaintiff, Carrie Buck, was described in the opinion as a feeble-minded white woman committed to a state mental institution who was the daughter of a feeble-minded mother in the same institution, and the mother of an illegitimate feeble-minded child. The court approved an order of the mental institution that Buck undergo sterilization. Justice Holmes, himself an ardent eugenicist, gave eugenic theory the imprimatur of constitutional law in his infamous declaration, "3 generations of imbeciles are enough." */ The salient feature of the eugenic sterilization laws is their brutal imposition of society's restrictive norms of motherhood. Governmental control of reproduction in the name of science masks racist and classist judgments about who deserves to bear children. It is grounded on the premise that people who depart from social norms do not deserve to procreate. Carrie Buck, for example, was punished by sterilization not because of any mental disability, but because of her deviance from society's social and sexual norms. Explanations of the eugenic rationale reveal this underlying moral standard for procreation. One eugenicist, for example, justified his extreme approach of putting the socially inadequate to death as the surest, the simplest, the kindest, and most humane means for preventing reproduction among those whom we deem unworthy of the high privilege. Dr. Albert Priddy, the superintendent of the Virginia colony, similarly explained the necessity of eugenic sterilization in one of his annual reports. The sexual immorality of antisocial morons rendered them wholly unfit for exercising the right of motherhood. 14 years after Buck v. Bell, the Supreme Court acknowledged the danger of the eugenic rationale. Justice William Douglas recognized both the fundamental quality of the right to procreate and its connection to equality in a later sterilization decision, Skinner v. Oklahoma. Skinner considered the constitutionality of the Oklahoma Habitual Criminal Sterilization Act, registered authorizing the sterilization of persons convicted 2 or more times for felonies involving moral turpitude. An Oklahoma court had ordered Skinner to undergo a vasectomy after he was convicted once of stealing chickens and twice of robbery with firearms. The statute, the court found, treated unequally criminals who had committed intrinsically the same quality of offense. For example, men who had committed grand larceny 3 times were sterilized, but embezzlers were not. The court struck down the statute as a violation of the Equal Protection Clause, declaring the right to bear children to be one of the basic civil rights of man. 78. The court applied strict scrutiny to the classification, asterisk, and held that the government failed to demonstrate that the statute's classifications were justified by eugenics or the inheritability of criminal traits. 7*. Skinner rested on grounds that linked equal protection doctrine and the right to procreate. Justice Douglas framed the legal question as a sensitive and important area of human rights. Registered the reason for the court's elevation of the right to procreate was the court's recognition of the significant risk of discriminatory selection inherent in state intervention in reproduction. Registered the court also understood the genocidal implications of a government standard for procreation. In evil or reckless hands, the government's power to sterilize can cause races or types which are inimical to the dominant group to wither and disappear. The critical role of procreation to human survival and the invidious potential for government discrimination against disfavored groups makes heightened protection crucial. The court understood the use of the power to sterilize in the government's discrimination against certain types of criminals to be as invidious as if it had selected a particular race or nationality for oppressive treatment. Although the reasons advanced for the sterilization of chicken thieves and the prosecution of drug-addicted mothers are different, both practices are dangerous for similar reasons. Both effectuate ethnocentric judgments by the government that certain members of society do not deserve to have children. As the court recognized in Skinner, the enforcement of a government standard for childbearing denies the disfavored group a critical aspect of human dignity. The history of compulsory sterilization demonstrates that society deems women who deviate from its norms of motherhood. In 1941, teenage delinquent girls like Carrie Buck who bore illegitimate children. Today, poor black crack addicts who use drugs during pregnancy unworthy of the high privilege of procreation. 28. The government therefore refuses to affirm their human dignity by helping them to overcome obstacles to good mothering. Rather, it punishes them by sterilization or criminal prosecution and thereby denies them a basic part of their humanity. When this denial, 403, is based on race, the violation is especially serious. Governmental policies that perpetuate racial subordination through the denial of procreative rights, which threaten at once racial equality and privacy, should be subject to the highest scrutiny. Toward a new privacy jurisprudence. Imagine that courts and legislatures have accepted the argument that the prosecution of crack-addicted mothers violates their right of privacy. All pending indictments for drug use during pregnancy are dismissed, and bills proposing fetal abuse laws are discarded. Would there be any perceptible change in the inferior status of black women? Pregnant crack addicts would still be denied treatment, and most poor black women would continue to receive inadequate prenatal care. The infant mortality rate for blacks would remain deplorably high. In spite of the benefits of privacy doctrine for women of color, liberal notions of privacy are inadequate to eliminate the subordination of black women. In this section, I will suggest two approaches that I believe are necessary in order for privacy theory to contribute to the eradication of racial hierarchy. First, we need to develop a positive view of the right of privacy. Second, the law must recognize the connection between the right of privacy and racial equality. The most compelling argument against privacy rhetoric, from the perspective of women of color, is the connection that feminist scholars have drawn between privacy and the abortion funding decisions. Critics of the concept of privacy note that framing the abortion right as a right merely to be shielded from state intrusion into private choices provides no basis for a constitutional claim to public support for abortions. As the court explained in Harris v. McRae 2, although government may not place obstacles in the path of a woman's exercise of her freedom of choice, it need not remove those not of its own creation. McKinnon concludes that abortion as a private privilege rather than a public right only serves to perpetuate inequality. Privacy conceived as a right from public intervention and disclosure is the opposite of the relief that Harris sought for welfare women. State Inter. 404. The intersection of race and gendervention would have provided a choice women did not have in the private realm. The women in Harris, women whose sexual refusal has counted for particularly little, needed something to make their privacy effective. The logic of the court's response resembles the logic by which women are supposed to consent to sex. Preclude the alternatives, then call the sole remaining option her choice. The point is that the alternatives are precluded prior to the reach of the chosen legal doctrine. They are precluded by conditions of sex, race, and class, the very conditions the privacy frame not only leaves tacit but exists to guarantee. This critique is correct in its observation that the power of privacy doctrine in poor women's lives is constrained by liberal notions of freedom. First, the abstract freedom to choose is of meager value without meaningful options from which to choose and the ability to effectuate one's choice. The traditional concept of privacy makes the false presumption that the right to choose is contained entirely within the individual rather than circumscribed by the material conditions of the individual's life. Registered second, the abstract freedom of self-definition is of little help to someone who lacks the resources to realize the personality she envisions or whose emergent self is continually beaten down by social forces. Defining the guarantee of personhood as no more than shielding a sphere of personal decisions from the reach of government, merely ensuring the individual's right to be let alone, may be inadequate to protect the dignity and autonomy of the poor and oppressed. The definition of privacy as a purely negative right serves to exempt the state from any obligation to ensure the social conditions and resources necessary for self-determination and autonomous decision-making. Based on this narrow view of liberty, the Supreme Court has denied a variety of claims to government aid. McKinnon notes that it is apparently a very short step from that which the government has a duty not to intervene in to that which it has no duty to intervene in. An evolving privacy doctrine need not make the step between these two propositions. Lawrence Tribe, for example, has suggested an alternative view of the relationship between the government's negative and affirmative responsibilities in guaranteeing the rights of personhood. Ultimately, the affirmative duties of government cannot be severed from its obligations to refrain from certain forms of control, both must respond to a substantive vision of the needs of human personality. This concept of privacy includes not only the negative proscription against government coercion but also the affirmative duty of government to protect the individual's personhood from degradation and to facilitate the processes of choice and self-determination. This approach shifts the focus of privacy theory from state non-intervention to an affirmative guarantee of personhood and autonomy. Under this post-liberal doctrine, the government is not only prohibited from punishing crack-addicted women for choosing to bear children, it is also required to provide drug treatment and prenatal care. Robin West has eloquently captured this progressive understanding of the Due Process Clause in which privacy doctrine is grounded. The ideal of due process, then, is an individual life free of illegitimate social coercion facilitated by hierarchies of class, gender, or race. The goal is an affirmatively autonomous existence, a meaningfully flourishing, independent, enriched individual life. 9 degrees. This affirmative view of privacy is enhanced by recognizing the connection between privacy and racial equality. The government's duty to guarantee personhood and autonomy stems not only from the needs of the individual but also from the needs of the entire community. The harm caused by the prosecution of crack-addicted mothers is not simply the incursion on each individual crack addict's decision-making, rather, it is the perpetuation of a degraded image that affects the status of an entire race. The devaluation of a poor black addict's decision to bear a child is tied to the dominant society's disregard for the motherhood of all black women. The diminished value placed on black motherhood, in turn, is a badge of racial inferiority worn by all black people. The affirmative view of privacy recognizes the connection between the dehumanization of the individual and the subordination of the group. Thus, the reason that legislatures should OEE 405. Reject laws that punish black women's reproductive choices is not an absolute and isolated notion of individual autonomy. Rather, legislatures should reject these laws as a critical step toward eradicating a racial hierarchy that has historically demeaned black motherhood. Respecting black women's decision to bear children is a necessary ingredient of a community that affirms the personhood of all of its members. The right to reproductive autonomy is in this way linked to the goal of racial equality and the broader pursuit of a just society. This broader dimension of privacy's guarantees provides a stronger claim to government's affirmative responsibilities. Feminist legal theory, with its emphasis on the law's concrete effect on the condition of women, calls for a reassessment of traditional privacy law. It may be possible, however, to reconstruct a privacy jurisprudence that retains the focus on autonomy and personhood while making privacy doctrine effective. Before dismissing the right of privacy altogether, we should explore ways to give the concepts of choice and personhood more substance degree. In this way, the continuing process of challenge and subversion to degree the feminist critique of liberal privacy doctrine, followed by the racial critique of the feminist analysis, will forge a finer legal tool for dismantling institutions of domination. 8. Conclusion. Your understanding of the prosecutions of drug-addicted mothers must include the perspective of the women whom they most directly affect. The prosecutions arise in a particular historical and political context that has constrained reproductive choice for poor women of color. The state's decision to punish drug-addicted mothers rather than to help them stems from the poverty and race of the defendants and from society's denial of their full dignity as human beings. Viewing the issue from their vantage point reveals that the prosecutions punish for having babies women whose motherhood has historically been devalued. A policy that attempts to protect fetuses by denying the humanity of their mothers will inevitably fail degree. We must question such a policy's true concern for the dignity of the fetus, just as we question the motives of the slave owner who protected the unborn slave child while whipping his pregnant mother. Although the master attempted to separate the mother and fetus for his commercial ends, their fates were inextricably intertwined. The tragedy of crack babies is initially a tragedy of crack-addicted mothers. Both are part of a larger tragedy of a community that is suffering a host of indignities, including, significantly, the denial of equal respect for its women's reproductive decisions. It is only by affirming the personhood and equality of poor women of color that the survival of their future generations will be ensured. The first principle of the government's response to the crisis of drug-exposed babies should be the recognition of their mother's worth and entitlement to autonomy over their reproductive lives. A commitment to guaranteeing these fundamental rights of poor women of color, rather than punishing them, is the true solution to the problem of unhealthy babies. Sapphire Bound. Regina Austin. I write us Resistance. Grew up thinking that Sapphire was merely a character on Amos and Andy, a figment of a white man's racist, sexist comic imagination. Little did I suspect that Sapphire was a more generally employed appellation for the stereotypical black bitch, tough, domineering, emasculating, strident, and shrill. Sapphire is the sort of person you look at and wonder how she can possibly stand herself. All she does is complain. Why doesn't that woman shut up? Black bitch hunts are alive and well in the territory where minority female law faculty labor. There are so many things to get riled about that keeping quiet is impossible. We really cannot function effectively without coming to terms with Sapphire. Should we renounce her, rehabilitate her, or embrace her and proclaim her our own? I think the time has come for us to get truly hysterical, to take on the role of professional sapphires in a forthright way, to declare that we are serious about ourselves, and to capture some of the intellectual power and resources that are necessary to combat the systematic denigration of minority women. It is time for Sapphire to testify on her own behalf, in writing, complete with footnotes. To testify means several different things in this context: to present the facts, to attest to their accuracy, and to profess a personal belief or conviction. The minority feminist legal scholar must be a witness in each of these senses. She must document the material legal existences of minority women. Her work should explore their concrete problems and needs, many of which are invisible even to minority lawyers because of gender and class differences. Moreover, a synthesis of the values, traditions, and codes that bind women of the same minority group to one another and fuel their collective struggle is crucial to the enterprise. The intellectual product of the minority feminist scholar should. Sapphire Bound. 427. Incorporate in a formal fashion the ethical and moral consciousnesses of minority women, their aspirations, and their quest for liberation. Her partisanship and advocacy of a minority feminist jurisprudence should be frankly acknowledged and energetically defended. Because her scholarship is to be grounded in the material and ideological realities of minority women and in their cultural and political responses, its operative premises must necessarily be dynamic and primarily immanent. As the lives of minority women change, so too should the analysis. Finally, the experiential is not to be abandoned by the minority female legal scholar. She must be guided by her life, instincts, sensibility, and politics. The voice and vision reflected in her work should contain something of the essence of the culture she has lived and learned. Imagine, if you can, writing a law review article embodying the spontaneity of jazz, the earthiness of the blues, or the vibrancy of salsa. I have given some thought to the tenets that a black feminist or womanish legal jurisprudence might pursue or embrace. We must write with an empowered and empowering voice. The chief sources of our theory should be black women's critiques of a society that is dominated by and structured to favor white men of wealth and power. We should also find inspiration in the modes of resistance which black women mount, individually and collectively, on a daily basis in response to discrimination and exploitation. Our jurisprudence should amplify the criticism and lend clarity and visibility to the positive, transformative cultural parries that are overlooked unless close attention is given to the actual struggles of black women. In addition, our jurisprudence should create enough static to interfere with the transmission of the dominant ideology and jam the messages that reduce our indignation, limit our activism, misdirect our energies, and otherwise make us the producers of our own subordination. By way of an alternative, a black feminist jurisprudence should preach the justness of the direct, participatory, grassroots opposition black women undertake despite enormous material and structural constraints. The mechanics of undertaking a research project based on the concrete material and legal problems of black women are daunting. The problems these projects involve are difficult because they do not begin with a case and will not necessarily end with a new rule. The world with which many legal scholars deal is that found within the four corners of judicial opinions. If the decisions and the rubrics they apply pay no attention to race, sex, and class, and insurance and malpractice cases generally do not, then the material conditions of minority females are nowhere to be found, and the legal aspects of the difficulties these conditions cause are nearly impossible to address as a matter of scholarly inquiry. It is thus imperative that we find a way to portray, almost construct for a legal audience, the contemporary reality of the disparate groups of minority women about whom we write. We really cannot do this without undertaking field research or adopting an interdisciplinary approach, relying on the empirical and ethnographic research of others. The latter route is the one that I have taken in this article and elsewhere. Implementation of an agenda for black feminist legal scholarship, and the expanded study of the legal status of minority women in general, will require the right sort of environmental conditions, such as receptive or at least tolerant non-minority publishers and a network of established academics engaged in similar pursuits. We minority female scholars must devote a bit of our sass to touting the importance of the perspective of minority women and the significance of their concerns to any list of acceptable law review topics. If anyone asks you to talk or write about anything related to your race or your sex, turn the opportunity into one for exploring the legal concerns of women of color. Il. A sapphire named Crystal. He task of articulating and advancing distinctive minority feminist jurisprudential stances will become easier as those of us interested in the status of minority women be. 428 The intersection of race and gender. Gin to analyze concrete cases and legal problems. To substantiate my point that a black feminist perspective can and must be manifest, I have attempted to apply the rough, tentative thesis I advance above to the examination of a particular decision, Chambers v. Omaha Girls Club. Point 4 The plaintiff, Crystal Chambers, was employed by the defendant Girls Club of Omaha as an arts and crafts instructor at a facility where approximately % of the program participants were black. 2 years later, Chambers, an unmarried black woman in her early 20s, was discharged from her job when she became pregnant. Her dismissal was justified by the club's so-called negative role model rule, which provided for the immediate discharge of staff guilty of negative role modeling for girls' club members, including such things as single-parent pregnancies. In her lawsuit, Chambers attacked the role model rule on several grounds. In her Title VI claims, for example, she maintained that the rule would have a disparate impact on black women because of their significantly higher fertility rate. She further asserted that her discharge constituted per se sex discrimination barred by the Pregnancy Discrimination Act of 1978. Although soundness of these arguments was acknowledged, they were effectively countered by the business necessity registered and the bona fide occupational qualification of defenses. The district court ruled against Crystal Chambers because it concluded that the club's role model rule was the product of its dedication to the goal of helping young girls reach their fullest potential. Programmatic concerns provided adequate support for the rule. According to the findings, the club's activities were characterized by a high staff-to-member ratio, extensive contact and close relationships between the staff and members, and an open, comfortable atmosphere. Thus, model behavior by the staff and imitation by the members were essential to the club's agenda. Those closely associated with the Girls' Club contend that because of the unique nature of the Girls' Club's operations, each activity, formal or informal, is premised upon the belief that the girls will or do emulate, at least in part, the behavior of staff personnel. Each staff member is trained and expected to act as a role model and is required, as a matter of policy, to be committed to the Girls' Club philosophy so that the messages of the Girls' Club can be conveyed with credibility. The club's goal was to expose its members to the greatest number of available positive options in life. Teenage pregnancy was contrary to this purpose and philosophy, because it severely limits the available opportunities for teenage girls. Citing plaintiff's expert, the court stated that teenage pregnancy often deprives young women of educational, social, and occupational opportunities, creating serious problems for both the family and society. Registered, the club had several programs that related to pregnancy prevention. In the opinion of the district court, the club established that it honestly believed that to permit single pregnant staff members to work with the girls would convey the impression that the Girls' Club condoned pregnancy for the girls in the age group it serves. Furthermore, while a single pregnant working woman may, indeed, provide a good example of hard work and independence, the same person may be a negative role model with respect to the Girls' Club objective of diminishing the number of teenage pregnancies. The club pointed to the reaction of two members to the earlier pregnancies of other single staffers in accounting for the genesis of the rule. In one case, a member who stated that she wanted to have a baby as cute as that of a staff member became pregnant shortly thereafter. In the second, a member became upset upon hearing of the pregnancy of an unmarried staff member. As painted by the court, there were numerous indications that the operative animus behind the role model rule was paternalistic, not racist or sexist. The North Omaha facility was purposefully located to better serve a primarily black population. Although the club's principal administrators were white, the girls served were black, the staff was black, and Crystal Chambers' replacements were black. Sensitivity was shown to the problems of the staff members, including those who were black. Sapphire bound, pregnant, and unmarried. Plaintiff was even offered help in finding other employment after she was fired. The district court concluded its opinion as follows: this court believes that the policy is a legitimate attempt by a private service organization to attack a significant problem within our society. The evidence has shown that the Girls' Club did not intentionally discriminate against the plaintiff and that the policy is related to the Girls' Club's central purpose of fostering growth and maturity of young girls. The court emphasizes, however, that this decision is based upon the unique mission of the Girls' Club of Omaha, the age group of the young women served, the geographic locations of the Girls' Club facilities, and the comprehensive and historical methods the organization has employed in addressing the problem of teenage pregnancy. 3. There were dissenting views among the Eighth Circuit judges who considered the case. In opposing the judgment in the club's favor, Judge Macmillan demanded hard evidence to support the legality of the negative role model rule. Neither an employer's sincere belief, without more, nor a district court's belief, that a discriminatory employment practice is related to and necessary for the accomplishments of the employer's goals is sufficient to establish a BFOQ, or business necessity defense. The fact that the goals are laudable and the beliefs sincerely held does not substitute for data that demonstrate a relationship between the discriminatory practice and the goals. A. For those who have no understanding of the historical oppression of black women and no appreciation of the diversity of their contemporary cultural practices, the outcome of Chambers might have a certain policy appeal, one born of sympathy for poor black youngsters and desperation about stemming the epidemic of teenage pregnancy that plagues them. According to such an assessment, the clubs hope that its members could be influenced by committed counselors who, by example, would prove that life offers more attractive alternatives than early pregnancy and single parenthood was at worst benign, if it was not benevolent. 429. However, for better informed, more critical evaluators, the opinions are profoundly disturbing. Firing a young, unmarried, pregnant black worker in the name of protecting other young black females from the limited options associated with early and unwed motherhood is ironic, to say the least. The club managed to replicate the very economic hardships and social biases that, according to the district court, made the role model rule necessary in the first place. Crystal Chambers was not much older than some of the club members, and her financial and social status after being fired was probably not that much different from what the members would face if they became pregnant at an early age, without the benefit of a job or the assistance of a fully employed helpmate. On the other hand, she was in many respects better off than many teen mothers. She was in her early 20s and had a decent job. Chambers's condition became problematic because of the enforcement of the role model rule. The material consequences that befell Chambers, which plague other black women who have children despite their supposed role modeling responsibilities, are not inherent byproducts of single pregnancy and motherhood. The condemnation and the economic hardships that follow in its wake are politically and socially contingent. Furthermore, they are not the product of a consensus that holds across race, sex, and class boundaries. Implicit in the Chambers decision is an assumption that the actual cultural practices and articulated moral positions of the black females who know the struggles of early and single motherhood firsthand are both misguided and destructive. The older women are apparently so outrageous that they represent a grave threat to their own daughters. Yet, for some of us, their portrayal in the Chambers' opinions is more flattering than the authors intended. Grounded in a culture that turns bad, pronounced bad, on its head and declares as wily, audacious, and good all conduct that offends the white, male, and middle-class establishments, a black feminist scholar has to wonder whether the villainous black women one discerns lurking in the interstices of the opinions are not doing 430 something right. A black feminist jurisprudential analysis of Chambers must seriously consider the possibility that young, single, sexually active, fertile, and nurturing black women are being viewed ominously because they have the temerity to attempt to break out of the rigid economic, social, and political categories that a racist, sexist, and the class-stratified society would impose upon them. Although the outcome hinged upon it, the opinions are awfully vague about the adverse effect that continued employment of an unmarried pregnant arts and crafts instructor would have had in promoting teenage pregnancy among the young black club members. I want to suggest a few possible relationships whose plausibility is attributable to a deep suspicion of black women's sexuality and an intense desire to control their excessive promiscuity and fecundity. The first is reminiscent of a bad joke. The club and the courts conceivably subscribe to a theory of reproduction, one that can only be termed primitive, which posits that simply seeing an unmarried pregnant woman can have such a powerful impact on adolescent females that they will be moved to imitate her by becoming pregnant themselves. Asterisk, if the girls are poor, and they and the woman are black, such a hypothesis might be given credence in some quarters. Under it, Crystal Chambers' mere pregnant presence at the club would be considered a corrupting influence in light of the club's goals. Surely, the club and the courts do not believe that black teenage pregnancy is the product of social voyeurism or a female variant of reckless eyeballing. It is more likely that unmarried, pregnant Crystal was thought to be a problem because she functioned as an icon, a reminder of a powerful culture from which the club members had to be rescued. The club was supposed to be a wholesome haven where young black girls would be introduced to an alternative array of positive life choices. Crystal Chambers tainted the environment by introducing into it the messy, corrupting cultural orientations that were the target of the club's repress and replace mission. There is a widespread belief that poor black, the intersection of race and gender, women who raise children alone in socially and economically isolated enclaves encourage teenage pregnancy by example, subsidize it through informal friendship and extended family networks, and justify it by prizing motherhood, devaluing marriage, and condoning welfare dependency. Operating on similar assumptions, the club set about exposing, literally, it seems, its young members to counter images that would act as antidotes to the messages they absorbed at home. In a newspaper story concerning Chambers's lawsuit, the attorney for the club stated that while there was no intent to condemn any parent of these girls or any of the parents' life decisions, the club did undertake to introduce the young members to alternatives that were different from those of the girls' home life. The attorney continued, "We're trying to say that at age 14, girls aren't necessarily emotionally mature enough to make the decision to voluntarily get pregnant. Their parents may have been." The Omaha World-Herald ran an editorial in support of the firing which continued the theme. The editorial states, "The absence of strong family structures among many poor blacks has long been identified as a major obstacle to blacks entering the mainstream. A high rate of out-of-wedlock pregnancies among poor blacks contributes both to the perpetuation of the poverty cycle and to the weakness of families caught in that cycle." The editorial further argues that if, as Crystal Chambers asserted, half the girls at the club have mothers who aren't married, then that is one of the reasons the dismissal policy makes sense. 18 This assessment of the danger posed by the ranks of mothers which Crystal was about to join attributes to black teenagers a level of passivity not often associated with adolescence. Looking to their parents' cultural orientations to explain teenage pregnancy may be giving the teens too little credit for attempting to shape the course of their own lives. It also attributes too much power to parents whose economic and social standing renders them impotent to control either their children's life chances or lives. Furthermore, the club's conduct is indicative. Sapphire bound. 431. Of the way in which the battle to curb black teenage pregnancy via the use of role models has become a pretext for continuing and expanding the economic and ideological war on unwed black mothers. This emphasis on the impact on teenage pregnancy of single middle-class role models who opt to have children furnishes continued opportunity to add a new twist to the historical efforts to ridicule and control black women's sexuality and reproduction. Although Crystal Chambers' firing was publicly justified on the ground that she would have an adverse impact on the young club members, it is likely that the club sacked her in part because she resisted its effort to model her in conformity with white and middle-class morality. In its struggles against the culture of the girls' mothers, Chambers, employee and instructor, was supposed to be on the club's side. Like a treasonous recruit, though, she turned up unmarried and pregnant. As such, she embodied the enemy. If the club could not succeed in shaping and restraining the workers whose economic welfare it controlled, how could it expect to win over the young members and supplant their mother's cultural legacy? The requirement that one allow oneself to be modeled in order to keep one's job is not limited to blacks who are young fertile females. To a certain extent, the trouble that Crystal Chambers encountered is a generic infliction suffered by black role models of both sexes and all ages who reject the part and become rebellious renegades or traitors to the cause of black cultural containment. In sum, then, faulty conceptions of role modeling lie at the heart of the policy basis of the Chambers decision. In this article, I explore the contemporary effort to control the sexual and reproductive freedom of those single black mothers who are said to be role models by blaming them for increased black teenage pregnancy. I explore parallels between the parts that model black women are supposed to play and historical stereotypes of black females as workers and sexual beings. I then go on to question the propriety of blacks accepting the guise of model assimilationists. Aside from the occasional piece that accuses black adolescents of absolute perversity, news accounts and academic literature generally portray black teens who are pregnant or already parents as pursuing private, ad hoc solutions to pervasive systemic economic and political powerlessness. Teenage pregnancy is the product of the complex interaction not only of culture and individual adjustment but also of material conditions that present black teens with formidable obstacles to survival and success. Black adolescents whose families are of low socioeconomic status are at greater risk of becoming teenage mothers than their middle and upper-class peers. Teenage pregnancy is correlated with the lack of success these black adolescents experience in dealing with institutions that should provide them with an entree to the society beyond the confines of their Nancy must be shared by an educational system that fails to provide black youngsters with either the desire or the chance to attend college, a labor market that denies them employment that will supply the economic indicia of adulthood, and a healthcare system that does not deliver adequate birth control, abortion, or family planning services. The impact of these structural factors does not make the problems constricting the lives of black adolescents entirely beyond their locus of control, however. The cultures of poor young blacks play a role in the reproduction of their material hardship. Their cultures also have strengths and virtues. Yet even persons sympathetic to black females like the club members, their mothers, and Crystal Chambers may have a hard time identifying anything positive and liberating about the modes and mores that produce black teen pregnancy and single motherhood. The need to highlight the affirmative while conceding the negative is quite pressing. Strong and complex identification with one's culture and community is necessary not only for survival but for a positive sense of self, and for the making of an involved and active community member. To be efficacious, that identification must be critical of all the elements that prevent black teens from improving their 432 The intersection of race and gender. Economic, social, and political circumstances. To the extent that it deserves affirmation from sympathetic supporters. In addition, it is imperative that those who broadly denigrate poor young black mothers be engaged in debate. A critical perspective held by the mothers themselves would provide the strongest possible basis for a counterattack. The condemnation of black unwed motherhood is so deeply embedded in mainstream thought that its invocation in connection with teenage pregnancy may be considered uncontroversial. Single black mothers get blamed for so much that there is little reason not to blame them for teenage pregnancy as well. At bottom, unmarried black women workers who have babies are being accused of carrying on like modern-day Jezebels when they should be acting like good revisionist mammies. Though not totally divorced from reality, Jezebel and mammy were largely ideological constructs that supported slavery. Each pertained to black female slaves' intertwined roles as sexual beings and workers. Each justified the economic and sexual exploitation of black female slaves by reference to their character traits rather than to the purposes of the masters. Jezebel was the wanton, libidinous black woman whose easy ways excused white men's abuse of their slaves as sexual partners and bearers of mulatto offspring. Jezebel was both free of the social constraints that surrounded the sexuality of white women, to whom she represented a threat, and isolated from the men of her own community. In contrast, Mammy was asexual, maternal, and deeply religious. Her principal tasks were caring for the master's children and running the household. 7. Mammy was said to be so enamored of her white charges that she placed their welfare above that of her own children. She was the perfect slave, a loyal, faithful, contented, efficient, conscientious member of the family who always knew her place, and she gave the slaves a white-approved standard of black behavior. She was the personification of the ideal slave, and the ideal woman. An ideal symbol of the patriarchal tradition. She was not just a product of the cultural uplift theory, which touted slavery as a means of civilizing blacks, but she was also a product of the forces that in the South raised motherhood to sainthood. Number 4. Commentators have emphasized the negative implications of the mammy stereotype. Elizabeth Fox Genovese writes, if implicitly the idea of the mammy referred to motherhood and reproduction, it also claimed those privileges for the masters rather than for the slaves themselves. Just as Buck signaled the threat to master-slave relations, mammy signaled the wish for organic harmony and projected a woman who suckled and reared white masters. The image displaced sexuality into nurture and transformed potential hostility into sustenance and love. It claimed for the white family the ultimate devotion of black women, who reared the children of others as if they were their own. Although the image of the mammy echoed the importance that black slaves attached to women's roles as mothers, it derived more from the concerns of the master than from those of the slave. Bell Hooks sounds a similar theme. The mammy image was portrayed with affection by whites because it epitomized the ultimate sexist-racist vision of ideal black womanhood, complete submission to the will of whites. In a sense, whites created in the mammy figure a black woman who embodied solely those characteristics they as colonizers wished to exploit. They saw her as the embodiment of woman as passive nurturer, a mother figure who gave all without expectation of return, who not only acknowledged her inferiority to whites but who loved them. The critique of the images of black women which whites have historically promoted is relevant to the assessment of the treatment accorded contemporary role models. Role models are supposed to forego the vices of Jezebel and exhibit the many virtues of mammy. The case of Crystal Chambers illustrates this quite well. When she refused to subordinate her interest in motherhood to the supposed welfare of the club girls, she essentially rejected the club's attempt to impose upon her the positive stereotype of the black female as a repressed, self-sacrificing, nurturing woman whose heart extends to other people's children because she cannot, or should not, have kids of her own. Instead, like a Jezebel, Crystal Chambers flaunted her sexuality, sapphire-bound, and reproductive capacity, but, unlike her counterpart in slavery, she did so in furtherance of her own ends, in defiance of her white employers, and in disregard of a rule that forbade her from connecting with a man outside of the marriage relationship. As if to resemble the role model that Fox Genovese says mammy could have been, Chambers was supposed to expose the young club members, the beneficiaries of white benevolence, to images congruent with traditional notions of patriarchy which were not entirely consistent with the norms of the black community. She was supposed to be an accomplice in regulating the sexuality of other young black females, in much the same way that she was expected to tolerate the regulation of her own. Theodorts would have us believe that the club acted for the good of the girls who would miss out on a host of opportunities if they became teen mothers, yet the distinction between paternalism and oppression is hardly crisper now than it was during slavery. It may be that the young women of the club set are not fully informed that there is an increasing demand for their labor and are misreading the material landscape. On the other hand, they could be well informed and reaching more negative assessments of their actual economic prospects. If their options are indeed no greater than they imagine, the effort to repress their fertility may stem from its being dysfunctional for the larger society. Declining to live out the myth of the modern mammy, Crystal Chambers refused to accept the yoke of paternalism or of oppression for herself and thereby freed the club girls, to a small extent, from manipulation of their productive and reproductive capacities. She then became valueless to her employers and was, in essence, expelled from the big house and returned to the field. Breaking the hold of ideological shackles that have restricted black women's sexuality and fertility will not be easy. Hortense Spillers, a black female literary critic, has argued that sexual experience among black people is so boundlessly imagined that it loses meaning and becomes, quite simply, a medium through which the individual is suspended. Jezebel and 433. Mammy, harlot and nun, whore and eunuch have acquired mystical attribution, divested of specific reference and dispersed over time and space in blind disregard for the particular agents on which it lands. Spillers likens this process to a mugging degree. She challenges feminist literary critics to find words that embody differentiated responsiveness, words that enable us to imagine women in their living and pluralistic confrontation with experience. Degree 8. Her charge is equally relevant to black feminist jurisprudence. Some of the black women who are not married yet have babies may be young and wise, others may be poor and brave, and yet a third group may be rich and selfish. Whether they confirm or confound the stereotypes, all of them deserve a measure of freedom with regard to their sexuality that the dominant culture withholds. All of them have the potential for being guerrilla fighters in a war that is being waged on three fronts. Struggles to control sexual expression and reproduction pit the combined hegemonic power of whites, males, and the middle class against overlapping constituencies of women, people of color, and ordinary working folks. Black values regarding individual family formation and parenthood decisions, as befits a community under siege, should facilitate, not interfere with, the critical vision that promotes the seeing that negotiates at every point a space for living. In other words, black women who attempt to express their sexuality and control their reproduction should not have to travel through a minefield of stereotypes, clichés, and material hardships with the handicap of a restriction that they keep to the right. Black women must be permitted to exercise their judgments without fear of reprisals from patriarchal, bourgeois, and culturally repressive elements within the black community. There are significant norms that bind and cage a basis for a community of concern among black men and women of various classes and outlooks. They support an agenda of systemic changes to strengthen minority families. Thus, economic resources should be available to both black men and black women who want to maintain families with children. Black teenagers of 434. Both sexes should be given the means and the support required to delay parenthood until the time is best for them. Everybody else should be allowed to do what they want to do, with the admonition that they give their offspring the advantages of the prenatal care, schools, and health programs that an ethical society would make available to assure its future. B. It is hard to think of Crystal Chambers, arts and crafts instructor, as a role model, as powerless and vulnerable as she ultimately proved to be. Her skills and natural behavior were not particularly valued by the people running the club. Rather than being a role model by virtue of doing her job and living her own life, Chambers was supposed to perform the role of model, play a part that was not of her own design. She was a model in the sense that a model is something made in a pliable material, such as clay or wax, that is intended to serve as a pattern of an object or figure to be made in a more permanent material. Degree when she deviated from the club's philosophy and engaged in a practice that was common to the community of black women from which she and the members came, she was fired. Chambers's experience is emblematic of the political significance of the professional black role model, including many of us lawyers and law professors, in this, the post-civil rights, post-black power era. Blacks are deluged with role models. Our attention is constantly being directed to some black person who is, should, or wants to be a role model for others. Many of these role models are black people who have achieved stature and power in the white world because they supposedly represent the interests of the entire black community. Such role models gain capital, literally and figuratively, to the extent that they project an assimilated persona that is as unthreatening to white people as it is, supposed to be, intriguing to our young. They become embodiments of the liberal image of the successful Negro with perhaps a bit of cut-up hate thrown in to keep them credible. By their sheer visibility, they are of service to those left behind, they are functionally useful in the intersection of race and gender. Vidying images for emulation, and their legitimacy should be unquestioned. Because the emphasis on role modeling suggests that motivation and aspirations are the cure for the problems of poor minority people, those who accept the appellation role model help to contain demands from below for further structural changes and thereby assist in the management of other blacks. Insofar as doing more for the poor is concerned, the service that role models perform is regrettably distinguishable from mentoring or power brokering. Role models really do not have very much clout to wield on behalf of other blacks, racial and sexual discrimination and exploitation being what they are. There are conceptions of role modeling that are not quite so alien to the political and cultural heritage of African American women. As far as I am concerned, Crystal Chambers became more nearly a role model when she fought back, when she became a sapphire. Her legal protest brought the club's contempt for the values of the population it served into the open. Her behavior and her lawsuit challenged the hegemony of the club's white, patriarchal, and middle-class orientation. Her single motherhood represented an alternative social form that one might choose deliberately, rationally, and proudly. She made manifest the critique that is life as it is lived by ordinary black single mothers. Refusing to go along with the program, she joined the host of non-white black women who every day mount local, small-scale resistance grounded in indigenous cultural values whose real political potential is often hidden even from those whose lives they govern. Nonetheless, there are times when low-volume defiance must give way to all-out mouthing off. Crystal Chambers's rebellion was ended not because Title VII doctrine could not be manipulated in her favor but because the presiding judges did not respect her normative framework. Her position should have been out there, vocalized affirmatively, coherently, and vehemently by black women and others before she got to court. History suggests that black people's recourse to conventional warfare on the sapphire-bound legal terrain proceeds more smoothly when the positions underlying their claims of entitlement have achieved some positive visibility via skirmishes in the cultural and political domains. Of course, concrete legal cases that prove to be losing efforts may nonetheless provide an opportunity for lawyers and law professors to get their acts together, to engage the enemy, and to refine their arguments. Although the front line may remain in a distant realm, ideas do percolate from one sphere to another, and those of us who are daring may move about as well. Next time we should all be better prepared. Il. For Kanfi and Asia and Fatima. And Rut which is to say, sapphires by another name, in the 60s, when Aretha Franklin demanded respect, respect, and admonished her listeners to think about what you're trying to do me, black people knew she was talking to white America. Times have changed. In 1988, vocal innovator Bobby McFerrin ambiguously sings "Don't Worry, Be Happy" with a Caribbean lilt, and the Bush Quail campaign tries to steal the song for its anthem. Somewhere along the line, we lost confidence in the political efficacy of cultural critique as a basis for the continuing struggle for black liberation. Perhaps we came to doubt the propriety of our distinctive cultural production, or we foolishly thought that we would be better off if we dispensed with social protest for a while and just relied on the law. Poor black women have especially suffered as a result. Their enemies have entrapped them in a quagmire of soft variables by challenging their morals and chiding them for looking to the government for relief from economic hardship instead of relying on individual initiative and self-help. The nonsense has deflected attention from the fact that their material circumstances have eroded degree. The reign of President Reagan was blessed with unusual legal and political quiescence among black women, but the signs of dissent are there. I have often wondered why black women give their daughters the names they do. Names like Kanthi, Asia, Fatima, Rashia. 435. Tamika, Latoya, Chantal, Ebony, and Dejavata, for David. Degree. The mothers, in naming them, and the girls, in being so named, share a bond with other distinctively named black women, a bond that extends backward in time to slavery. Desperation born of material and political powerlessness may be operating here. Perhaps the mothers are trying to give to their daughters a mark of distinction that will otherwise be denied them because they are black and female. Uncommon names can generate hostility that can be a severe handicap. I like to think that the names are in part an expression of group solidarity and self-affirmation, and not the byproduct of the mother's unfamiliarity with and isolation from the dominant culture. Whether the naming practices represent a tactic of opposition, a critique of a society that typically chooses to call its female children Ashley, Jessica, Amanda, and the like, and a form of cultural resistance, I do not know. The possibility should be fully explored. It is my fondest hope, however, that whatever their mother's motivations, the little black girls will grow up to see the positive potential of what their mothers did and relish being sapphires by another name. My Part 7. Race and Postmodernism. 7. Race and Postmodernism. The essays in this concluding chapter are linked by Isaiah Akelson of the intellectual movement commonly called postmodernism. One of the important characteristics of postmodern thought has been its emphasis on site-contingent, indeterminate, and socially constructed nature of the categories with which we perceive and converse about the world. Jane Chong-Soo Lee's essay Navigating the Topology of Race is built around such a sensibility. Her essay challenges the argument of Anthony Appiah that the concept of race, of racial difference, has no ground to give it meaning except in racist motivation. Lee counters that Appiah himself has essentialized the idea of race. Like all linguistic constructs, race has no fixed meaning but instead meaning changes with social context. She argues for progressive, anti-racist deployments of the idea of race rather than its abolition in the boundaries of political geography in legal analysis. Richard Ford uses similar critical tools in service of his argument for a form of cultural pluralism that would focus on the character of the space that we occupy socially. Ford deconstructs the conventional understandings of local government and racial justice. In each discussion, Ford shows the seemingly stable dominant forms of thought. Context: Ford argues for a way out of the contradictions through a new cultural pluralist paradigm for understanding political space and racial justice, a political and social framework built upon the acknowledgement that communities are never homogeneous and ready-made but, rather, always in the process of being created. We close the chapter and this collection with Kendall Thomas's A Popular History of the Angelo Herndon Case. Thomas's essay reflects many of the main critical race theory themes in the context of a close and careful study of Angelo Herndon, a black communist who was convicted in the 1930s of inciting insurrection against the state. As Thomas demonstrates, the dominant legal and historical discourse has reduced the complex story of Herndon's engagement with the legal system to a few abstract and formal legal doctrines. Thomas proposes to recover the neglected cultural history of the case through what he calls popular memory, a critical historical method that would recover the social, cultural, and ideological struggle suppressed by the dominant focus in legal scholarship on institutional concerns. He then demonstrates these theoretical and methodological convictions through his own, alternative reading of the Herndon case and recovery of the SUP actually rests on contradictory premises. In each press story of his struggle. 441. Part 7. Race and Postmodernism. Navigating the Topology of Race. Jane Chong-Soo Lee. A. Appiah's Motifs. Kwame Anthony Appiah is a prominent participant in the debate over the definitions of race and the significance of racial difference. A professor of African American Studies and Philosophy at Harvard University, Appiah has written extensively on African and African American literary criticism. In a recent collection of his essays, In My Father's House, Appiah addresses the construction and mapping of race in his usual comprehensive and controversial manner. For the first time, Appiah gathers several themes that have suffused his writings and presents them as a collection. Layered upon each other, the essays reveal an even greater intricacy than each demonstrates individually. Appiah's discussion of the ontology of race, when considered with his analysis of the universal/particular dichotomy, evolves into a rich argument about the politics of racial particularity. Similarly, his discussion of the legacy of racism and racialism develops an added urgency when seen together with his critique of the premises of the African nativist movement. Often brilliant, sometimes contentious, but always absorbing, Appiah's book elevates the dialogue on race to a new level. Appiah departs from the familiar landscape of statistical and empirical accounts of racial discrimination, and of historical and economic accounts of racial ideology, to probe the very definitions of race itself. He bypasses the empirical question of whether racism exists to ask the theoretical question of what race and racism are. Similarly, he avoids the historical question of who did what, preferring to ask how the who and the what are constituted. By circumventing the typical questions we ask about race, Appiah opens up the impasses that currently constrain the dialogue. By analyzing how racial difference is constructed, he charts the ways in which certain groups are designated as racially distinct. and by asking how racial identity is constructed, Appiah investigates the relationship between racial category and racial subjectivity. Taken as a whole, Appiah's argument does not threaten the possibility of African American identity, as some commentators have argued. Rather, he questions the uncritical use of biological and essential conceptions of race as premises of anti-racist struggles. Copyright. His point is that we cannot analyze racial difference from within frameworks that already assume biological difference. These efforts fail to question the naturalized frameworks or to consider alternatives, for example, the potential of cultural identities. Further, these attempts fail to take seriously the legacy of racist domination. The term race may be so historically and socially overdetermined that it is beyond rehabilitation. Rather than presume biological and essential definitions of race to be solutions to racism, Appiah suggests that we approach these presumptions as problems for anti-racism. He thereby challenges the fundamental tenets of current anti-racist practice. 442 Race and Postmodernism. 2 Tuesday, Possibility of Racial Resistance. A. Race versus culture. Not only does Appiah conclude that biological and essential conceptions of race are falsehoods, but he also determines that they are useless at best and dangerous at worst. The truth is that there are no races, there is nothing in the world that can do all we ask race to do for us. As we have seen, even the biologist's notion has only limited uses, and the notion that W.E.B. Du Bois required, and that underlies the more hateful racisms of the modern era, refers to nothing in the world at all. The evil that is done by the concept, and by easy yet impossible assumptions as to its application. Appiah asserts that talk of race is particularly distressing for those of us who take culture seriously. For where race works in places where gross differences of morphology are correlated with subtle differences of temperament, belief, and intention, it succeeds only as an attempt at metonym for culture, and it does so only at the price of biologizing what is culture, ideology. In other words, any conception of race that is significant is really just culture in disguise. Just what is this culture that Appiah urges us to substitute for race? It is exists out there in the world communities of meaning, shading variously into each other in the rich structure of the social world. One of Appiah's earlier essays suggests that these communities of meaning are groups of people anchored by ethnic identities. Appiah maintains that in a truly non-racist world, ethnic identities based on racial differences would entirely wither away. On the other hand, ethnic identities described as something an African American identity could become seem to Appiah likely to persist. In an ideal world, what we now call a racial identity would become an ethnic identity. Appiah suggests that this notion of ethnic or cultural identity already underlies a progressive view of ostensibly racial identity. He points out, for example, that for those who identify themselves as African American, what matters is almost always not the unqualified fact of that descent, but rather something that they suppose to go with it, the experience of a life as a member of a group of people who experience themselves as and are held by others to be a community in virtue of their mutual recognition and their recognition by others as people of a common descent. Since any meaningful notion of racial community is really one of cultural community, Appiah believes that culture can and should substitute for race. The benefits of substituting the notions of an ethnic or cultural identity for a racial one are many. First, we can move away from the notion that race is a biological attribute possessed only by people of color. Second, we can undermine the racialist premise that moral and intellectual characteristics, like physical traits, are inherited. Third, we can counter the belief that nature, not effort, binds together members of a race. Fourth, we can rebut the idea that the ways in which we act, think, and play are inherited, rather than learned. As Henry Louis Gates, Jr., has instructed us, one must learn to be black in this society, precisely because blackness is a socially produced category. However, the problem with this ethnic or cultural identity is precisely what Appiah cites as its advantage: its independence from race. As Michael Omi and Howard Winant have noted, theories that reduce racial identities to ethnic ones fail to account for the centrality of race in the histories of oppressed groups. Such theories also underestimate the degree to which traditional notions of race have shaped, and continue to shape, the societies in which we live. In doing so, these reconceptualizations of race as ethnicity may actually hinder our ability to resist entrenched forms of racism. 14 Although this criticism of ethnicity may apply more to the particularities of American society, it is also pertinent to African societies. After all, the history of colonialism in Africa cannot be mapped simply through cultural identities. We need race to fully understand what happened. Racial domination, not simply cultural oppression, explains imperialism. Returning to the American context, when race becomes just another ethnic identity, and African Americans, Latinos, Asian Americans, EAE. Navigating the topology of race 443. And Native Americans become ethnic groups, there is a real danger that the oppression faced historically by these groups will not be fully understood or appreciated. The racial experience is not just quantitatively different from the ethnic one, as Ronald Takaki explains, the racial experience is qualitatively different. For example, the immigration experience was dramatically distinct for white ethnics and African Americans. The majority of the latter group were brought to this country in chains and enslaved for 200 years. Analogously, during World War II, German Americans and Italian Americans were not interned, as were Japanese Americans. To the extent that ethnicity models take the white ethnic experience as the norm, these theories blame the victim when they fail to measure up to this norm. For example, conservative observers wonder why African Americans have not progressed socially and economically in the United States as have similarly situated white ethnic groups, such as Italians and Irish. Most seriously, ethnicity theories fail to account for the ways in which race has already been formalized in our institutions, particularly the law. B. Races. The most important weakness of Appiah's dismissal of race is that in declaring biological and essential conceptions of race useless and dangerous, he fails to recognize that race is defined not by its inherent content, but by the social relations that construct it. If race is always dangerous, regardless of its meaning within a specific historical and social context, the result is an abstract and unitary conception of race. Basically, Appiah's conception of race fails to acknowledge that meanings change dramatically with social context. For Appiah, once a conception of race is constructed, the possibility of contesting, redefining, and reappropriating it is limited. Because the meaning of race is so constrained, resistance on racial terms becomes difficult. Our best hope is to abandon race for culture. Whether extrinsic or intrinsic, to Appiah these attitudes are both labeled racism. In designating all uses of race variants of racism, rather than recognizing their potential to be altogether different phenomena, Appiah may presuppose his conclusion that all uses of race are hazardous. Paradoxically, by casting both uses of race as racisms, Appiah's conception of race fails to reflect the changing social contexts that produce race, and through which race can be redeployed as a tool of anti-racist struggle. While whites have historically used conceptions of race to subordinate people of color, some communities of color have successfully reappropriated the categorizations and united around them. They have redeployed race as an affirmative category around which people have organized to assert the power of their group and its identity. To deny the term race any content, as Appiah would have it, is to deny a powerful metaphor to racial groups and to preclude valuable modes of resistance. Focusing on the different ways in which race is defined is more fruitful than concentrating on the common ways in which race is used. Since the meaning of race depends on the specific social contexts in which it is embedded, we will find as many definitions of race as there are social contexts. Registered with this in mind, we can navigate among different definitions of race simultaneously: biological, social, cultural, essential, and political. Rather than determining whether a definition is oppressive based solely on its content, we can instead examine its effects. In perhaps the most penetrating account of the history of race, Michael Omi and Howard Winant explore the construction of racial identities, and trace how race has changed over time. They investigate the ways in which the sign of race has been appropriated and reappropriated, and how contests over definitions of race have shaped, and been shaped by, American social life and history. Omi and Winant argue that we should stop thinking of race as an essence, as something fixed, concrete and objective. They suggest that we instead think of race as an unstable and decentrated complex of social meanings constantly being transformed by political struggle. They highlight the contingent and changing nature of race and racism while recognizing its pervasive and systematic effect on our history. They trace the historical 444 race and postmodernism development of the category of race, labeling this process racialization to signify the extension of racial meaning to a previously racially unclassified relationship, social practice, or group. Similarly, they discuss racial formation, or the process by which social, economic, and political forces determine the content and importance of racial categories, and by which they are in turn shaped by racial meanings. This theory of racial formation captures the concept of race both as a means of analyzing and ordering the world and as a process of historical and social transformation. In this way, Omi and Winant acknowledge that many definitions of race are possible, and acknowledge heterogeneous terrains of the racial landscape. However, current discursive frameworks for analyzing race constrain us to either / or binary structures. We are forced to select biological or social conceptions of race, between supporting all versions of race or no versions of race, between implementing race-neutral or race-specific policies. If, like Appiah, we argue that race is socially constructed, then we often lose any chance to account for biology in defining race. While the argument that physical differences alone do not define race is vitally important, it should not preclude us from investigating how race has morphological features. We can explore how racial categories are created and organized around physical characteristics, how biology and the social contexts interrelate to give meaning to these physical traits. 7 In short, race can explain why, in the real world, differences of color, hair, and bone still matter. Il decacantixere. A. Judicial constructions of race. Racial characterization in the law demonstrates the dangers of continuing to examine solely the content of race, and to endorse unitary definitions of race. In legal discourse, singular notions of race and an either / or binary framework seriously limit the potential of anti-racist struggles, exposing them to racist appropriation. The need to stress how race is constructed in social contexts, and how race has a multiplicity of meanings, is urgent for 2 reasons. First, courts construct definitions of race and racial difference every day, even as they claim to merely reflect pre-existing scientific and social facts. Second, legal discourse tends to formalize definitions within the framework of the law, magnifying their effect. Criteria that we use loosely in daily life can become rigid tests in the courtroom. A recent controversial Supreme Court decision that interpreted racial definitions demonstrates these tendencies. In Shaw v. Reno, the court applied strict scrutiny in evaluating the constitutionality of an electoral reapportionment plan. Shaw marked the first time that the court chose to apply identical legal tests to government action designed to benefit historically disadvantaged racial groups and to measures designed to burden these groups in the voting rights arena. The decision, along with an earlier case striking down an affirmative action program, has stirred considerable criticism. Appiah's critique of the use of unquestioned racial assumptions aptly applies to the Supreme Court's decisions involving racial issues. 7 Registered despite the frequency of Supreme Court cases dealing with race, the court has not precisely identified the role of race in its decisions. The court purports merely to recognize, not to construct, definitions of race. It has shifted between biological and social definitions of race. In Shaw, the court described race in physical terms such as skin color. In other cases, it has characterized race as a social construct, the product of past and present racial discrimination. Degree. A survey of the court's varying definitions of race, however, reveals that focus on content, unitary definitions, and either/or frameworks prevail in judicial attempts to determine the significance of racial difference. This singular framework of these definitions has facilitated the court's invalidation of remedial programs vital to anti-racist efforts. B. Shaw v. Reno, manipulating the biological and the racial. In Shaw, 5 white voters in North Carolina brought a constitutional challenge to a state-enacted reapportionment plan, alleging that the Navigating the Topology of Race plan was an unconstitutional racial gerrymander. Point 3. The court held that the plaintiffs could make a cognizable claim under the Equal Protection Clause of the 14th Amendment by alleging that the legislation, although race-neutral on its face, rationally cannot be understood as anything other than an effort to separate voters into different districts on the basis of race. Degree 2. The level of review on remand was to be strict scrutiny. The lower court was instructed to determine whether the North Carolina plan is narrowly tailored to further a compelling governmental interest. Degree. Writing for the majority, Justice Sandra Day O'Connor constructs a biological conception of race. She points out that the main purpose of the Equal Protection Clause is to prevent states from purposefully discriminating between individuals on the basis of race, *4, and that the individual is important, not his race, his creed, or his color. Degree. While these references to race do not embody a specific definition, when Justice O'Connor says race, she clearly means skin color. Racial classifications of any sort pose the risk of lasting harm to our society. They reinforce the belief, held by too many for too much of our history, that individuals should be judged by the color of their skin. Degree. A reapportionment plan that includes in one district individuals who belong to the same race, but who are otherwise widely separated by geographical and political boundaries, and who may have little in common with one another but the color of their skin, bears an uncomfortable resemblance to political apartheid. In defining race, however, Justice O'Connor exploits the rhetorical power of unitary definitions of race and an either/or binary framework of biological and social definitions of race. She depends on a biological notion of race to argue that the law should not recognize race. Tautologically, she defines race as skin color in order to prove that we should not recognize race, since it means nothing more than skin color. For Justice O'Connor, to acknowledge the significance of skin color is to attribute an array of character traits on the basis of physical features that bear no relevance to those traits. In 445, the Shaw majority's conception, recognizing the relevance of mere skin color is as irrational and insidious as assuming that all members of a racial group share certain moral and cultural traits. For the majority, skin color represents racial essence and negative stereotypes, the racists' assertion that the races possess different natures and moral characteristics and therefore should be valued differently. In its critique of biological race, the majority legitimately objects to the notion that our skin color predicts who we are and what we can be. The problem, however, is that the court does not simply reject this narrowly biological notion of race as a basis for disparate treatment, rather, it assumes that the invalidity of race so characterized leaves no alternative but to reject the political significance of race altogether. Classifications of citizens solely on the basis of race are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. They threaten to stigmatize individuals by reason of their membership in a racial group and to incite racial hostility. Even in the pursuit of remedial objectives, an explicit policy of assignment by race may serve to stimulate our society's latent race consciousness, suggesting the utility and propriety of basing decisions on a factor that ideally bears no relationship to an individual's worth or needs. Degree 8. The court limits race to a biological definition and evokes the opposition between the biological and the social to undermine the validity of race consciousness, and thus of race-conscious remedies. It accomplishes this by recognizing that biological definitions of race lead to racism. Acknowledging only a unitary definition of race, it then concludes that recognizing race leads to racism. While I agree with the assertion that recognizing skin color has in some contexts caused stigmatic harm, I cannot agree with the conclusion that recognizing race must also cause injury. The majority's argument that all racial classifications cause harm depends on the conflation of biology and race, as well as the use of only one definition of race. Further, it invites us to view every acknowledgement of race as racism. 446. One way to undercut this presumption is to assert, as Appiah has done, that race is not simply biology. The two concepts are analytically unconnected and unconnectable. We might also argue that the attribution of race to skin color is always an act of interpretation. Skin color does not equal race unless society recognizes that it does. For example, in Dry Longso, a self-portrait of Black Ameria, John Langston Gwaltney's collection of African American narratives, Jackson Jordan, Jr., a 90-year-old African American man, discusses how people are identified as black. Now, you must understand that this is just a name we have. I am not black and you are not black either, if you go by the evidence of your eyes. Anyway, black people are all colors. White people don't all look the same way, but there are many more different kinds of us than there are of them. Then too, there is a certain stage at which you cannot tell who is white and who is black. Many of the people I see who are thought of as black could just as well be white in their appearance. Many of the white people I see are black as far as I can tell by the way they look. Race cannot be self-evident on the basis of skin color, for skin color alone has no inherent meaning. Shaw epitomizes the gap between the court's professed color blindness and its undeniable role in the construction of race. The opinion seems to rebuke the district court for taking judicial notice of the appellant's white race, a fact omitted from their complaint, degree, and emphasizes that the appellants did not even claim to be white in their pleading. Even in disclaiming the significance of race, however, the majority writes its biologistic conception of race into the law. Because it does not recognize the non-biological dimensions of race, the majority must reject the possibility of a non-stigmatic use of race. Ironically, by doing this, the court adopts a stigmatic biologistic definition of race and does not see its own power to recast the meaning of race into an affirmative use. The court fails to recognize that it does, hence, how it can shape the terrain of racial difference. Shaw makes clear the inadequacy of unitary and either/or binary models of racial difference. Race and postmodernism. And it suggests their potential to cause affirmative harm. Race and racism are fluid. In contrast to the 60s, the concept of liberal colorblindness now undermines anti-racist efforts. Therefore, rejecting all conceptions of biological race and embracing those of social race leaves open the possibility of racist appropriation and precludes the potential for anti-racist struggle. Similarly, rejecting all notions of essential race may dismantle the grounds for affirmative racial solidarity. Because the meaning of race is constructed by the social contexts in which it is located, there can be no consistent content to race. It can always be defined in many different ways, often simultaneously. Because we cannot predict a racist practice from its definition of race, we can never determine beforehand whether a practice will be racist or anti-racist solely from its content. We can only examine the way race is being used and what it is being used to say. Only after examining the context and the effect can we determine whether the practice is racist or anti-racist. If the practice reinforces the subordination of a historically oppressed group, we can label that practice racist. In Shaw, the notion of color blindness was used to undermine an electoral plan designed to benefit a racial group that had historically been deprived of their right to vote. On the other hand, if the practice alleviates subordination, we can label that practice anti-racist. The constantly shifting topology of race requires us to acknowledge that race can be defined in many different ways, and that all of these ways, even biological and essential conceptions of race, have their place in anti-racist struggles. The best that we can do is to navigate this terrain. For conclusion, turning to the themes that motivated this review, I pose the following questions again. How can we recognize racial difference without reinscribing racial stereotypes and subordination? How can we trace the historical construction of race without denying groups the power to define themselves racially? How can we critique dominant norms for excluding racial experiences, without ghettoizing? Navigating the topology of race 447. People of color by the very particularity that we have invoked. I argue that we can start by recognizing that race is always defined by its social context, and never solely by its content. Additionally, we can recognize that race is always multiplicitous because social contexts are multiplicitous. The use of race to stereotype and discriminate against people differs from the use of race as a basis for racial solidarity. Finally, we can refuse to adhere to the unitary, either/or framework that has constrained race discourse. We can have both biological and social definitions of race, we can have both essential and historical notions of race, we can have both race-neutral and race-conscious remedies, we can have both race and culture. Abandoning one set of definitions entirely may deprive us of useful tools in the struggle against racism. Imagine a physical landscape with various distinguishable features: trees, mountains, valleys, and quicksand. An observer on a satellite can see the people below but not the features of the terrain. When she sees people climbing over hills, moving around obstacles, or diving into tunnels, the observer might assume that certain people's attitudes prompt certain kinds of actions, while others might have attitudes that encourage other types of movements. However, if the observer were to move closer, she would be able to see that understanding the people's actions entails analyzing the terrain. And the observer would realize that changing people's behavior would entail contouring the terrain differently. By analogy, race continues to exist as it does because we create and recreate it to fit our own social terrain, even as it becomes a part of that terrain. I end with this image to suggest that the notion of race is not so overdetermined by past and current racial domination that we cannot revive it. Instead of abandoning a terrain twisted by oppression and discrimination, we can try to reshape it with other tools. Instead of referring to a single definition of race, we can refer to multiple definitions of race. Instead of talking about racism, we can talk about racisms. Instead of abandoning certain definitions of race, we can employ each of them when necessary. Biological and essential definitions of race may have their place in this topography. Perhaps Appiah's greatest insight is that we must always self-consciously analyze the tools that we use. Whether these tools harm or heal depends on what we do with them. The choice is always ours. The boundaries of race, political geography in legal analysis. Richard Thompson Ford. During the 70s and 80s a word disappeared from the American vocabulary. The word was segregation. It is now passé to speak of racial segregation. In an America that is facing the identity crisis of multiculturalism, where racial diversity seems to challenge the norms and values of the nation's most fundamental institutions, to speak of segregation seems almost quaint. The physical segregation of the races would seem to be a relatively simple matter to address. Indeed, many believe it has already been addressed. Discrimination in housing, in the workplace, and in schools is illegal. Thus, it is perhaps understandable that we have turned our attention to other problems, on the assumption that any segregation that remains is either vestigial or freely chosen. However, even as racial segregation has fallen from the national agenda, it has persisted. Even as racial segregation is described as a natural expression of racial and cultural solidarity, a chosen and desirable condition for which government is not responsible and one that government should not oppose, segregation continues to play the same role it always has in American race relations: to isolate, disempower, and oppress. Segregation is oppressive and disempowering rather than desirable or inconsequential because it involves more than simply the relationship of individuals to other individuals. It also involves the relationship of groups of individuals to political influence and economic resources. Residence is more than a personal choice, it is also a primary source of political identity and economic security. Likewise, residential segregation is more than a matter of social distance, it is a matter of political fragmentation and economic stratification along racial lines, enforced by public policy and the rule of law. Segregated minority communities have been historically impoverished and politically powerless. Today's laws and institutions need not be explicitly racist to ensure that the state of affairs. 450 Race and Postmodernism continues, they need only to perpetuate historical conditions. In this article, I assert that political geography, the position and function of Poermian Wienernieser T Simpala apte are jurisdictional and trademark quasi-jurisdictional boundaries * helps to promote a facially separate and unequal distribution of political influence and economic resources. Moreover, these inequalities fuel the segregative effect of political boundaries in a vicious cycle of causation, each condition contributes to and strengthens the others. Thus, racial segregation persists in the absence of explicit, legally enforceable racial restrictions. Race-neutral policies, set against a historical backdrop of state action in the service of racial segregation and thus against a contemporary backdrop of racially identified space, physical space primarily associated with and occupied by a particular racial group, predictably reproduce and entrench racial segregation and the racial caste system that accompanies it. Thus, the persistence of racial segregation, even in the face of civil rights reform, is not mysterious. This article employs two lines of analysis in its examination of political space. The first demonstrates that racially identified space both creates and perpetuates racial segregation. The second demonstrates that racially identified space results from public policy and legal sanctions, in short, from state action rather than from the unfortunate but irremediable consequence of purely private or individual choices. This dual analysis has important legal and moral consequences. If racial segregation is a collective social responsibility rather than exclusively the result of private transgressions, then it must either be accepted as official policy or remedied through collective action. Part 1 argues that public policy and private actors operate together to create and promote racially identified space and thus racial segregation. In support of this assertion, I offer a hypothetical model to demonstrate that even in the absence of individual racial animus and de jure segregation, historical patterns of racial segregation would be perpetuated by facially race-neutral legal rules and institutions. I conclude the discussion in Part 1 by arguing that the significance of racially identified political geography escapes the notice of judges, policy-makers, and scholars because of two widely held yet contradictory misconceptions. One assumes that political boundaries have no effect on the distribution of persons, political influence, or economic resources, while the other assumes that political boundaries define quasi-natural and pre-political associations of individuals. As we shall see, these two assumptions lead jurists and policy makers to believe that segregated residential patterns are unimportant to the political influence and economic well-being of communities, and that such residential patterns are beyond the proper purview of legal and policy reform. These beliefs are often unstated, but they inform judicial decisions and the political and sociological analyses underlying those decisions. Part 2 demonstrates how racially identified space interacts with facially race-neutral legal doctrine and public policy to reinforce racial segregation rather than to eliminate it gradually. Legal analysis oscillates between two contradictory conceptions of local political space, which correspond to the two misconceptions of space described in Part 1. One conceives of local jurisdictions as geographically defined delegates of centralized power, administrative conveniences without autonomous political significance. The other treats local jurisdictions as autonomous entities that deserve deference because they are manifestations of an unmediated democratic sovereignty. Both accounts avoid examination of the potentially segregated character of local jurisdictions, the first by denying them any legal significance, the second by reference to their democratic origins, or by tacit analogy to private property rights, or both. Thus, legal authorities that subscribe to either of these accounts never confront the problems posed by the many jurisdictions that are segregated or promote racial segregation and inequality. Two competing normative analyses mirror the doctrinal oscillation between the conception of local governments as agents of state power and the conception of local governments as self-validating political communities. One holds that local governments are powerless creatures of the state and prescribes greater autonomy for local governments, the other, which insists the boundaries of race. That local governments are powerful, autonomous associations, advocates bringing the crazy quilt of parochial localities under centralized control. Part 3 also returns to our original focus on race relations and suggests that the characteristic oscillation in local government doctrine informed by democratic theory is related to a particularly American conflict between the goals of racial and cultural assimilation, on the one hand, and separatism, on the other. Neither assimilation nor separatism is fully acceptable, and race relations theorists tend to waver between the two. The reification of political space thus mirrors a reification of race in American thought. Race is assumed either to be irrelevant, merely the unfortunate byproduct of an ignoble American past and a retrograde mentality, or to be natural and primordial, a genetic or biological identity that simply is unamenable to examination or change. Finally, Part 3 attempts to mediate the characteristic conflicts between local parochialism and centralized bureaucracy, pluralist competition and Republican dialogue, and racial assimilation and racial separatism. In Part 3 one argue that the location of the politics of difference must be the metropolis, the political space in which the majority of Americans now reside, work, and enjoy recreation, and in which individuals confront racial, cultural, and economic differences. Against the nostalgia of the whole and the one, the pure homogeneous community, we should strive for the achievable ideal of the diverse democratic city. I. Conceptions and consequences of space. A. The construction of racially identified space. Segregation once the missing link in prior attempts to understand the plight of the urban poor. As long as blacks continue to be segregated in American cities, the United States cannot be called a race-blind Soctete. Douglas S. Massey and Nancy A. Denton, American Apartheid 3. This article focuses primarily on residential segregation and on the geographic boundaries that. 451. Define local governments. Although these are not the only examples of racially identified space, they are so intimately linked to issues of political and economic access that they are among the most important. Residence in a municipality or membership in a homeowners association involves more than simply the location of one's domicile, it also involves the right to act as a citizen, to influence the character and direction of a jurisdiction or association through the exercise of the franchise, and to share in public resources. Housing, after all, is much more than shelter. It provides social status, access to jobs, education and other services. Residential segregation is self-perpetuating, for in segregated neighborhoods the damaging social consequences that follow from increased poverty are spatially concentrated, creating uniquely disadvantaged environments that become progressively isolated geographically, socially, and economically from the rest of society. Local boundaries drive the cycle of poverty. Actors public and private laid the groundwork for the construction of racially identified spaces and, therefore, for racial segregation as well. Explicit governmental policy at the local, state, and federal levels has encouraged and facilitated racial segregation. The role of state and local policies in promoting the use of racially restrictive covenants is well known. Less well known is the responsibility of federal policy for the pervasiveness of racially restrictive covenants. The federal government continued to promote the use of such covenants until they were declared unconstitutional in the landmark decision Shelley v. Kramer. Federally subsidized mortgages often required that property owners incorporate restrictive covenants into their deeds. The federal government consistently gave black neighborhoods the lowest rating for purposes of distributing federally subsidized mortgages. The Federal Housing Administration, which insured private mortgages, advocated the use of zoning and deed restrictions to bar undesirable people and classified black neighbors as nuisances to be avoided, along with stables and pig pens. Not surprisingly, bejewelers adopted the racially restrictive covenant so their property. 452 Race and postmodernism would be eligible for federal insurance. Registered and private banks relied heavily on the federal system to make their own loan decisions. Thus the federal government not only channeled federal funds away from black neighborhoods but was also responsible for a much larger and more significant disinvestment in black areas by private institutions. Although the federal government ended these discriminatory practices after 1950, only much later did it do anything to remedy the damage it had done or to prevent private actors from perpetuating segregation. Racial segregation was also maintained by private associations of white homeowners who lobbied city councils for zoning restrictions and for the closing of hotels and rooming houses, threatened boycotts of real estate agents who sold homes to blacks, and withdrew their patronage from white businesses that catered to black clients. These associations shaped the racial and economic landscape and implemented by private fiat what might well be described as public policies. Thus, private associations as well as governments defined political space. b. The perpetuation of racially identified spaces, an economic structural analysis. The history of public policy and private action // in the service of racism reveals the context in which racially identified spaces were created. Much traditional social and legal theory imagines that the elimination of public policies designed to promote segregation will eliminate segregation itself, or will at least eliminate any segregation that can be attributed to public policy and leave only the aggregate effects of individual biases, which are beyond the authority of government to remedy. This view fails, however, to acknowledge that racial segregation is embedded in and perpetuated by the social and political construction of racially identified / political space. Trouble in Paradise, an economic model. Imagine a society with only two groups, blacks and whites, differentiated only by morphology. Visible physical differences. Blacks, as a result of historical discrimination, tend on average to earn significantly less than whites. Imagine also that this society has recently, during the past 20 or 30 years, come to see the error of its discriminatory ways. It has enacted a program of reform which has totally eliminated legal support for racial discrimination and, through a concentrated program of public education, has also succeeded in eliminating any vestige of racism from its citizenry. In short, the society has become colorblind. Such a society may feel itself well on its way to the ideal of racial justice and equality, if not already there. Imagine also that, in our hypothetical society, small, decentralized, and geographically defined governments exercise significant power to tax citizens, and they use the revenues to provide certain public services, such as police and fire protection, public utilities, such as sewage, water and garbage collection, infrastructure development, and public education. Finally, imagine that, before the period of racial reform, our society had in place a policy of fairly strict segregation of the races, such that every municipality consisted of two enclaves, one almost entirely white and one almost entirely black. In some cases, whites even reincorporate their enclaves as separate municipalities to ensure the separation of the races. Thus, the now colorblind society confronts a situation of almost complete segregation of the races, a segregation that also fairly neatly tracks a class segregation, because blacks on average earn far less than whites, in part because of their historical isolation from the resources and job opportunities available in the wealthier and socially privileged white communities. We can assume that all members of this society are indifferent to the race of their neighbors, co-workers, social acquaintances, and so forth. However, we must also assume that most members of this society care a great deal about their economic well-being and are unlikely to make decisions that will adversely affect their financial situation. Our hypothetical society might feel that, over time, racial segregation would dissipate in the absence of de jure discrimination and racial. The boundaries of race 453. Prejudice. Yet let us examine the likely outcome under these circumstances. Higher incomes in the white neighborhoods would result in larger homes and more privately financed amenities, although public expenditures would be equally distributed among white and black neighborhoods within a single municipality. However, in those municipalities which incorporated along racial lines, white cities would have substantially superior public services, or lower taxes and the same level of services, than the mixed cities, due to a higher average tax base. The all-black cities would, it follows, have substantially inferior public services or higher taxes as compared to the mixed cities. Consequently, the wealthier white citizens of mixed cities would have a real economic incentive to depart, or even secede, from the mixed cities, and whites in unincorporated areas would be spurred to form their own jurisdictions and to resist consolidation with the larger mixed cities or all-black cities. Note that this pattern can be explained without reference to racism. Whites might be colorblind yet nevertheless prefer predominantly or all-white neighborhoods on purely economic grounds, as long as the condition of substantial income differentiation obtains. Of course, simply because municipalities begin as racially segregated enclaves does not mean that they will remain segregated. Presumably, blacks would also prefer the superior public service amenities or lower tax burdens of white neighborhoods, and those with sufficient wealth would move in. Remember, in this world there is no racism and there are no cultural differences between the races. People behave as purely rational economic actors. One might imagine that, over time, income levels would even out between the races, and blacks would move into the wealthier neighborhoods, while less fortunate whites would be outbid and would move to the formerly all-black neighborhoods. Hence, racial segregation might eventually be transformed into purely economic segregation. This conclusion rests, however, on the assumption that residential segregation would not itself affect employment opportunities and economic status. However, because the education system is financed through local taxes, segregated localities would offer significantly different levels of educational opportunity. The poor, black cities would have poorer educational facilities than would the wealthy, white cities. Thus, whites would, on average, be better equipped to obtain high-income employment than would blacks. Moreover, residential segregation would result in a pattern of segregated informal social networks. Neighbors would work and play together in community organizations such as schools, PTAs, little leagues, Rotary clubs, neighborhood watch groups, cultural associations, and religious organizations. These social networks would form the basis of the ties and the communities of trust that open the doors of opportunity in the business world. All other things being equal, employers would hire people they know and like over people of whom they have no personal knowledge, good or bad. They would hire someone who comes with a personal recommendation from a close friend over someone without such a recommendation. Residential segregation would substantially decrease the likelihood that such connections would be formed between members of different races. Finally, economic segregation would mean that the market value of black homes would be significantly lower than would that of white homes. Thus, blacks attempting to move into white neighborhoods would on average have less collateral with which to obtain new mortgages, or less equity to convert into cash. Inequalities in both educational opportunity and the networking dynamic would result in fewer and less remunerative employment opportunities, and hence lower incomes, for blacks. Poorer blacks, unable to move into the more privileged neighborhoods and cities, would remain segregated, and few, if any, whites would forego the benefits of their white neighborhoods to move into poorer black neighborhoods, which would be burdened by higher taxes or provided with inferior public services. This does not necessarily mean that income polarization and segregation would constantly increase, although at times they would, but, rather, that they would not decrease over time through a process of osmosis. Instead, every successive 454 race and postmodernism generation of blacks and whites would find itself in much the same situation as the previous generation, and in the absence of some intervening factor, the cycle would likely perpetuate itself. At some point an equilibrium might be achieved. Generally better connected and better educated whites would secure the better, higher income jobs and disadvantaged blacks would occupy the lower status and lower wage jobs. Even in the absence of racism, then, race-neutral policy could be expected to entrench segregation and socio-economic stratification in a society with a history of racism. Political space plays a central role in this process. Spatially and racially defined communities perform the work of segregation silently. There is no racist actor or racist policy in this model, and yet a racially stratified society is the inevitable result. Although political space seems to be the inert context in which individuals make rational choices, it is in fact a controlling structure in which seemingly innocuous actions lead to racially detrimental consequences. Two Strangers in Paradise, a complicated model. Even you enter the best of circumstances, segregation undermines the ability of blacks to advance their interests because it provides whites with no immediate self-interest in their welfare. Furthermore, a significant share of whites must be assumed to be racially prejudiced and supportive of policies injurious to blacks. Douglas S. Massey and Nancy A. Denton, American Apartheid ***. If we now introduce a few real-world complications into our model, we can see just how potent the race-space dynamic is. Suppose that only half of all whites in our society are in some measure racist or harbor some racial fear or concern. These might range from the open-minded liberal who remains somewhat resistant, if only for pragmatic reasons, to mixed-race relations, Spencer Tracy's character in Guess Who's Coming to Dinner, to the avowed racial separatist and member of the Ku Klux Klan. Further, suppose that the existence of racism produces a degree of racial fear and animosity of blacks, such that only half of blacks fear or distrust whites to some degree. These might range from a pragmatic belief that blacks need to keep to their own kind, if only to avoid unnecessary confrontation and strife, Sidney Poitier's father in the same film, to strident nationalist separatism. Let us also assume that significant cultural differences generally exist between whites and blacks. In this model, cultural differences and socialization would further entrench racial segregation. Even assuming that a few blacks would be able to attain the income necessary to move into white neighborhoods, it is less likely that they would wish to do so. Many blacks would fear and distrust whites and would be reluctant to live among them, especially in the absence of a significant number of other blacks. Likewise, many whites would resent the presence of black neighbors and would try to discourage them, in ways both subtle and overt, from entering white neighborhoods. The result would be an effective tax on integration. The additional amenities and lower taxes of the white neighborhood would often be outweighed by the intangible but real costs of living as an isolated minority in an alien and sometimes hostile environment. Many blacks would undoubtedly choose to remain in black neighborhoods. Moreover, this dynamic would produce racially identified spaces. Because our hypothetical society is now somewhat racist, segregated neighborhoods would become identified by the race of their inhabitants. Race would be seen as intimately related to the economic and social condition of political space. The creation of racially identified political spaces would make possible a number of regulatory activities and private practices that would further entrench the segregation of the races. For example, because some whites would resent the introduction of blacks into their neighborhoods, real estate brokers would be unlikely to show property in white neighborhoods to blacks for fear that disgruntled white homeowners would boycott them. The boundaries of race. Even within mixed cities, localities might decline to provide adequate services in black neighborhoods, and might divert funds to white neighborhoods in order to encourage whites with higher incomes to enter or remain in the jurisdiction. Thus, although our discussion has focused primarily on racially homogeneous jurisdictions with autonomous taxing power, the existence of such jurisdictions might affect the policy of racially heterogeneous jurisdictions, which would have to compete for wealthier residents with the low tax and superior service homogeneous cities. This outcome would be especially likely if the mixed jurisdictions were characterized by governmental structures that were either resistant to participation by grassroots community groups or were otherwise unresponsive to the citizenry as a whole. A dynamic similar to what I have posited for the homogeneous jurisdictions would occur within such racially mixed jurisdictions, with neighborhoods taking the place of separate jurisdictions. Each of these phenomena would exacerbate the others, in a vicious circle of causation. The lack of public services would create a general negative image of poor, black neighborhoods. Inadequate police protection would lead to a perception of the neighborhoods as unsafe, uncollected trash would lead to a perception of the neighborhoods as dirty, and so forth. Financial institutions would redline black neighborhoods, refuse to lend to property owners in these areas because they would be likely to perceive them as financially risky. As a result, both real estate improvement and sale would often become unfeasible. ICONC.Usion, the implications for racial harmony. Empirical study confirms the existence of racially identified space. The foregoing economic model demonstrates that race and class are inextricably linked in American society, and that both are linked to segregation and to the creation of racially identified political spaces. Even if racism could magically be eliminated, racial segregation would be likely to continue as long as we begin with significant EEZRNN. L455. Income polarization and segregation of the races. Furthermore, even a relatively slight, residual racism severely complicates any effort to eliminate racial segregation that does not directly address political space and class-based segregation. One might imagine that racism could be overcome by education and rational persuasion alone. Because racism is irrational, it seems to follow that, over time, one can argue or educate it away. The model shows that even if such a project were entirely successful, in the absence of any further interventions, racial segregation would remain indefinitely. Contemporary society imposes significant economic costs on non-segregated living arrangements. In the absence of a conscious effort to eliminate it, segregation will persist in this atmosphere, although it may appear to be the product of individual choices. The structure of racially identified space is more than the mere vestigial effect of historical racism. It is a structure that continues to exist today with nearly as much force as when policies of segregation were explicitly backed by the force of law. This structure will not gradually atrophy, because it is constantly used and constantly reinforced. Toward a legal conception of space. A whole history remains to be written of spaces which would at the same time be the history of powers, both these terms in the plural, from the great strategies of geopolitics to the little tactics of the habitat, passing via economic and political installations. Michel Foucault, The Eye of Power SII. There is no self-conscious legal conception of political space. Most legal and political theory focuses almost exclusively on the relationship between individuals and the state. Judges, policymakers, and scholars analogize decentralized governments and associations either to individuals, when considered vis-a-vis centralized government, or to the state, when considered vis-a-vis their own members, yet they consider the development, population, and demarcation of space to be irrelevant. Space is implicitly under. 456 Race and postmodernism. Stood to be the inert context in which, or the deadened material over which, legal disputes take place. Legal boundaries are often ignored because they are imagined to be either the product of aggravated individual choices or the administratively necessary segmentation of centralized governmental power. This representation of boundaries, and hence, of politically created space, allows us to imagine that spatially defined entities are not autonomous associations that wield power. At the same time, space also serves to ground governmental and associational entities. We imagine that the boundaries defining local governments and private concentrations of real property are a natural and inevitable function of geography and of a commitment to self-government or private property. These two views of political geography justify judicial failures to consider the effect of boundaries and space on racial segregation. However, the development, population, and demarcation of space, those characteristics which must be considered irrelevant in order for space to be seen as merely the aggregation of individual choices or the organizing medium of centralized power, are precisely the characteristics that distinguish spaces politically and economically. Localities define spaces as industrial, commercial, or residential. Homeowners associations define spaces according to density and type of development. Zoning and covenanting prescribe who can occupy certain spaces. This spatial differentiation is what I mean by the political geography of space. Features such as these, features that are not primordial or natural but are inherently spatial because they distinguish one space from another, are the product of collective action structured by law. The tautology of community self-definition. Space is a salient characteristic of political entities even as it entrenches that segregation. In order to understand why this is so, consider an association that is not spatially defined. Such an association must be defined by particular criteria that can be examined, criticized, and challenged. These criteria also distinguish the association from the mere aggregation of individual member preferences. Even if members are empowered to alter the criteria through a democratic process, the initial selection of membership will affect the outcome of subsequent elections. Thus, although the governance of such an association may be democratic in form, it may well not be democratic, of the people, in substance if the initial selection of members was highly exclusive. If those excluded from the association claim a right to join, the association cannot justify their exclusion on the basis of democratic rule. Nor can the justification for such an association be that it has a right to self-definition, because the self that seeks to define is precisely the subject of dispute. This tautology of community self-definition is masked when a group can be spatially defined. We are simply the people who live in Area X. Space does the initial work of defining the community or association and imbues the latter with an air of objectivity, indeed, of primordiality. But the tautology is only masked, it is not resolved. Why should Area X be the relevant community, when Area X plus Area Y might provide an equally or more valid definition of community? The answer cannot appeal to the right of community self-determination. If the people in Area Y claim to be part of the larger community X plus Y, then should not their opinion be considered as well as that of the people in Area X? It is the question of how communities are and should be defined that concerns us here. Close attention to spatial construction will help us to break free of established but untenable definitions of political community and thereby to open new avenues for combating entrenched structures of residential segregation. I begin by examining the construction of political space and the consequent construction of racially identified space in both public and private law. To exclusionary zoning and local democracy, the racial politics of community self-definition along with historical de jure segregation, racially exclusionary zoning introduces the racial element into local political geography and the boundaries of race 457. Thereby creates a structure of racially identified space. The zoning power is justified by reference to an internal local political process, hence the polis that votes on local zoning policy is defined and legitimate by an opaque local geography. At the same time, the effect of this political exclusion for the excluded racial group is considered insignificant. The very local geography in question in the challenged zoning policy is rendered transparent. Exclusionary zoning is a generic term for zoning restrictions that effectively exclude a particular class of persons from a locality by restricting the land uses they are likely to require. Today, exclusionary zoning takes the form both of restrictions on multifamily housing and of minimum acreage requirements for the construction of single-family home large-low zoning. Exclusionary zoning is a mechanism of the social construction of space. Local space is defined by zoning ordinances as suburban, family-oriented, pastoral, or even equestrian. The ordinances are justified in terms of the types of political spaces they seek to create. A community that wishes to define itself as equestrian may enact an ordinance forbidding the construction of a home on any lot too small to accommodate stables and trotting grounds, or may even ban automobiles from the jurisdiction. The desire to maintain an equestrian community is then offered as the justification for the ordinance. Courts have generally deferred to the internal political processes of the locality and upheld such exclusionary ordinances. Such a construction of space has a broader political impact than the immediate consequence of the ordinance. By excluding non-equestrians from the community, a locality constructs a political space in which it is unlikely that an electoral challenge to the equestrian ordinance will ever succeed. Registered, the democratic process that produces and legitimates exclusionary zoning is thus very questionable. In many cases, the only significant vote that will be taken on the exclusionary ordinance is the first vote. After it is enacted, exclusionary zoning has a self-perpetuating quality. When local policies are challenged as racially discriminatory, local boundaries may do the discriminatory work. Because these boundaries are left unexamined, it is impossible for plaintiffs to demonstrate discriminatory intent. The discrimination appears to be the result of aggregated but unconnected individual choices or merely a function of economic inequality, and therefore beyond the power of the courts to remedy. In Village of Arlington Heights v. Metropolitan Housing Development Corp., 8, the Supreme Court upheld a village's prohibition of multifamily housing despite demonstrable racially restrictive effects. 1. The court accepted the locality's professed neutral motivation of a commitment to single-family housing and rejected the contention that this commitment could be inextricably bound up with racial and class prejudices. Degree most important for our purposes, the court tacitly accepted the zoning policy as the legitimate product of the local democratic process. It relied on the same conception of space that held sway in Euclid, and accepted local boundaries as the demarcation of an autonomous political unt. But the boundaries, combined with the zoning policy, exclude outsiders from the political processes of the locality. 21 Because it may be the homogeneity of the local political process that is responsible for the racially exclusionary policy, the court's deference to the locality's internal political process is unjustified. It is this very political process, as well as the boundaries that shape that process, that is at issue. Indeed, racial minorities with significant cultural particularities present an especially strong claim for political inclusion in a jurisdiction. If racial minorities are to enjoy equality in an otherwise racially homogeneous jurisdiction, they must have the opportunity to change the character of the political community, and not merely the right to enter on condition of conformity. Furthermore, even if minorities were willing to conform to a homogeneous community's norms, when exclusionary zoning takes on an economic character, the option may simply be unavailable. According to our economic model, the impoverished condition of segregated minorities is, at least in part, a function of their exclusion from the communities that control wealth and employment opportunities. A. 458 Race and Postmodernism. 3. The distributive consequences of spatial education. Millikan and Rodriguez. Racially identified spaces demarcated by local boundaries have distributive as well as political consequences. Our economic model demonstrates that, because localities administer many taxing and spending functions, boundaries that segregate on the basis of wealth or race ensure that taxes are higher and quality of services lower in some jurisdictions than in others. Moreover, because local boundaries are regarded as sacrosanct in the implementation of desegregation remedies, if interlocal rather than intralocal segregation is more prevalent, the remedies will be of little consequence. In Milken v. Bradley, the Supreme Court held that court-ordered school busing designed to remedy de jure racial segregation in the Detroit schools could not include predominantly white suburban school districts. The court found that because there was no evidence that the suburban districts that would be included under the court-ordered plan had themselves engaged in de jure discrimination, they could not be forced to participate in the busing remedy. This rationale is puzzling unless one views cities not as mere agents of state power but as autonomous entities. If cities were mere agents of state power, the state as a whole would be ultimately responsible for their discriminatory actions. Thus, the state as a whole would bear responsibility for remedying the discriminatory practices. An apportionment of blame and responsibility within the state would be arbitrary, and any such apportionment that hindered effective desegregation would be unacceptable. One may object that because Michigan had allocated power and authority to cities, the court correctly allocated blame and responsibility in the same manner. However, the court failed to examine the motivation for the position of local jurisdictional boundaries, and by conceiving of local political space as opaque as defining a singular entity, the court failed to consider the facts that Detroit's racial composition had changed, and that responsibility for historical segregation could no more be confined within Detroit's city limits than could its white former residents. By accepting the municipal boundaries as given, the Millikan court ironically segregated the scope of the remedy to racial segregation and, thereby, may have allowed the historical segregation to become entrenched rather than remedied. The plaintiffs were to be trapped within the city's boundaries, without even an opportunity to demand that those boundary lines be justified as either rational or innocently irrational. A similar pattern and misconception of space prevailed in San Antonio Independent School District v. Rodriguez, in which the court held that a school financing system that was based on local property taxes and produced large disparities in tax burden to expenditure ratios among districts did not violate the Equal Protection Clause. The court reasoned that a commitment to local control obliged it to uphold the Texas school financing scheme. The court also rejected the argument that the Texas system of local funding was unconstitutionally arbitrary, and it asserted that any scheme of local taxation, indeed the very existence of identifiable local governmental units, requires the establishment of jurisdictional boundaries that are inevitably arbitrary. The court's argument here is essentially circular. The appellees began by challenging as arbitrary the use of local boundaries as a means of determining the distribution of educational funds. The court's response asserts that arbitrariness is inevitable if local boundaries are to be respected. This is precisely what was at issue: are local boundaries to be used to determine school finance levels or not? The court's circular reasoning reflects another level of incongruence in its logic. While the court based its refusal to overturn the Texas system on respect for local autonomy and local boundaries, at the same time it justified the arbitrariness of Texas's local boundaries on the grounds that local boundaries are irrelevant. If respect for local government were as important as the court claimed, it seems strange that the court would so casually dismiss the fact that the boundaries of Race 459. The boundaries defining these governments are arbitrary. However, if arbitrariness is inevitable, it seems illogical to accord arbitrarily defined subdivisions such respect. The court's decision rests on two conflicting conceptions of local government and the political space it occupies. On the one hand, the court conceived of local space as transparent and thus viewed localities as mere subdivisions, the inconsequential and administratively necessary agents of centralized power. On the other, it conceived of local space as opaque and thus viewed localities as deserving of respect as autonomous political entities. For conclusion, Autonomy and Association T's Dow's the section has been that political space OA the work of maintaining racially Aries. The role of political space, representing it either as the delegation of state power, and therefore inconsequential, or as natural, and therefore inevitable. Doctrine insists that local governments are merely the geographically defined agents of centralized government. Although such delegation is viewed with great suspicion when the delegate is not geographically defined, courts have shown extreme deference to local political processes. For example, local boundaries become a talisman for purposes of voting rights, even when those denied the right to vote are directly affected by the policies of the jurisdiction. Local boundaries are regarded as sacrosanct even when doing so prevents an equitable distribution of public resources for state purposes or interferes with the constitutionally mandated desegregation of state schools. Thus, the decisions of the court in the foregoing cases rest on a shifting foundation of local sovereignty and local irrelevance. One caveat is in order. My discussion has posed the issue as one that involves localities excluding outsiders with possible rights to inclusion. However, we must remember that local government law reflects a conflict between democratic inclusiveness and the exclusiveness that makes community possible. Indeed, because our focus is on racial minority groups, the related tension between integration and separatism warrants consideration. We must not forget that in order to reject segregation, we need not unreservedly accept integration. Indeed, especially for racial minorities, some degree of separatism may represent the best or only avenue of empowerment and fulfillment. In the cases I have examined, the reification of political space ensured that the conflict between integration and separatism, inclusion and exclusion, was never even addressed. In some cases, however, there may be good reasons to grant a locality the power to exclude. What are we to make, for example, of cases such as Belterra * in which one set of associational rights clashes with another, or associational rights clash with rights to political participation? I have no formula for resolving these issues, but I do submit that we must recognize these conflicts for what they are. If we do so, we may find that often the true conflict is falsely framed in terms of a generic local sovereignty. As Lawrence Tribe notes, the justification of a sectational autonomy is often unpersuasive. Many localities are merely spaces where atomistic individuals sleep and occasionally eat. Hence, our desire for local autonomy is often less an impulse to preserve something that is already there than it is a desire to realize an ideal. In realizing this ideal, we must attend to issues of racial segregation and discrimination, in short, to issues of racially identified space, not only because constitutional principles so guide us, but also because the ideal is debased if we do not. As Iris M. Young has written, the aggregate model reduces the social group to a mere set of attributes attached to individuals. The association model also implicitly conceives the individual as ontologically prior to the collective, as making up, or constituting, groups of six. Just as I criticized ascent-epica/interest group pluralism and republicanism, I have also criticized a liberal sent-ep of political thought above. There are articulations of liberal political theory which are potentially more hospitable to racial group identification and to a recognition of the salience of political geography. Many liberals would argue that racial groups are not inconsist. 460 Race and postmodernism. Tent with but, rather, are assimilable to the general liberal typology that conceives of individuals as ontologically prior to groups. On such a view, liberal pluralists should support racial group identification because it is a precondition to meaningful individual choice. Similarly, liberal Republicans argue that individually based rights to privacy and association are important, though primarily as a means of facilitating the group identification that allows individual citizens to develop views relatively independent of the state. 78 I disagree with the critics who insist that such attempts to combine insights about the necessity of group and cultural membership with pluralist and Republican thought are hopelessly self-contradictory. Such a criticism misses the point that political thought deals in tensions that are an unavoidable feature of the political registered degree. The best of political thought recognizes such conflicts and attempts to mediate them. I believe that my proposals and the analysis herein are largely consistent with these more sophisticated forms of liberalism, pluralism, and republicanism. b. Seeing through but not overlooking space. Statutory and doctrinal recognition of the role of political space. Thus far, we have focused on the general tendency in legal analysis both to overlook the consequences of political space in geographically defined entities and to cede talisman significance to politically created boundaries, thereby at once ignoring and refeeing political space. See cultural desegregation, toward a legal practice of culturally plural political space. I desegregation v integration. My discussion of racially identified spaces has been critical of the political boundaries that define these spaces. I have argued that contemporary society, through the mechanism of law, creates and perpetuates racially identified spaces without doing so explicitly. Thus, no attempt is made to justify the political spaces that are so perpetuated. Many readers may take my critique of racialized space as a call for a planned program of spatial integration, such as the systematic dispersal of inner-city minority populations to the suburbs with mandatory busing to maintain public school integration. But this type of integration assumes the existence of racialized space that needs to be integrated. Through the elimination of racially identified space, we may find that some of the classic centralized methods of racial integration are no longer necessary or desirable. If one accepts the importance of political geography, one might nevertheless object that the reforms proposed in this article will disrupt established communities and introduce elements of uncertainty and instability by removing the system that allowed these communities to come into existence. Political spaces create cultural communities. An implicit part of my thesis is that space, at least as much as time, is responsible for racial and/or cultural identity. Even for those members of a racial group who do not live in a racially identified space, the existence of such a space is central to their identity ***. Hence, to dissent a racially identified space is to some extent to dissent a racial identity. The foregoing analysis should make clear that no political system, including the current one, can remain neutral in the face of the social construction of geography. No system can simply reflect or accommodate individual choice as to residence and geographic association. No system is without some systematic bias. Because a truly neutral system is impossible, we must rewrite the laws to favor, rather than to obstruct, racial and class desegregation. A system of desegregated spaces would certainly result in fewer homogeneous spaces and more numerous integrated ones, but such a system is different from the classic model of integration in two important respects. First, it does not impose a particular pattern of integration, rather, it removes the impediments to a more fluid movement of persons and groups within and between political spaces. Second, this model does not accept the current manifestation of political space and simply attempt to shuffle the demographic deck to produce a statistical integration. Rather, it challenges the mechanism by which political spaces are created. The boundaries of race and maintained, and by extension, it challenges one of the mechanisms by which racial and cultural hierarchies are maintained. Thus, cultural desegregation is both more mild and more radical than classic integrationism. It is more mild because it does not mandate integration as an end. Group cohesion may exist even in the absence of spatially enforced racial segregation, such that no significant increase in statistical integration will occur. Indeed, I imagine that spatially defined cultural communities that have experienced the exodus of many of their wealthier members, many of whom exit not due to a desire to assimilate but for economic reasons, would experience an increase in group cohesiveness, either because the middle and upper classes would return to culturally defined neighborhoods in the absence of economic and political disincentives, or because, as spatial boundaries become more permeable, geography would become a less important part of community definition. Individuals could be part of a political community that is geographically dispersed, even as many are now a part of dispersed cultural committees. Desegregated space would encourage cultural cohesion by rendering racialized political boundaries more permeable, and thus allowing members of culturally distinct communities to act on their cultural connections regardless of where they happen to reside. In this latter sense, though, cultural desegregation is also more radical than integration. Cultural desegregation insists that cultural associations may be respected and encouraged regardless of the spatial dispersal of their members. It rejects both the assimilationist notion that individuals should aspire to become members of some imperial master culture, and leave their cultural identity behind in order to gain acceptance by society at large, and the separatist notion that only through geographic consolidation and cultural anarchy can people of color hope to avoid cultural genocide, or suicide. To desegregated cultural identity. Cultural desegregation aspires to a society in which cultural identity is dynamic in its defining. 461. Shin and cultural communities are fluid but not amorphous. These two ideals are linked in a paradox, because cultural identity is established only in the context of a community or association. The position of cultural associations is critical to the formation of cultural identity. There is no individual cultural identity, for culture implies a community. At the same time, though, cultural specificity must imply an interaction with other cultures. A culture has a specific character only in that it is unlike other cultures with which it compares itself through interaction. However, interaction with other cultures will change a cultural community, and in some sense reduce its specificity. This paradox gives rise to fear of assimilation and inspires some to advocate cultural autarky. The solution to this paradox lies in understanding culture as a context, a community of meaning, rather than as a static entity or identity. A cultural community exists in a symbiotic relationship both with its members and with outsiders. It can neither totally shape its members nor completely exclude outsiders. Yet this does not mean that the community is nothing more than the aggregation of its individual members. A cultural community has autonomy in that it can exert influence over individual members, construct morality, values, and desires, and provide an epistemological framework for its members. One may understand culture to refer to the cultural community, or cultural structure, itself. On this view, the cultural community continues to exist even when its members are free to modify the character of the culturea sgn. If this understanding is correct, then culture is not threatened by internal dissent, outside influences, eventual transformation, nor even by the exit of certain members, just as the character of a democratic government is not threatened by changes in administration. To be sure, some changes are for the better and some for the worse, and some changes may indeed threaten the very structure of the culture, just as McCarthyism and the imperial presidency were thought to threaten the very structure of American democracy. However, the process of change itself is not to be feared. In fact, it is to be. 462 Race and Postmodernism. Welcomed, for it is a part of the life of a culture. Although there are certainly distinct cultural communities, the boundaries between them often are a good deal more permeable than most discussions of cultural pluralism and cultural membership would suggest. 3. Cultural identity in desegregated space. Cultural associations are among the groups that exercise power, both formally and informally, through their control of physical spaces. Although the link between race and culture is not direct or unproblematic, and is beyond the scope of this article, we can identify this link in the creation and maintenance of racially identified spaces, occupied by racial and cultural communities. As the tautology of community self-definition demonstrates, it is impossible for any community truly to determine its own identity. Thus, the desegregation of political space cannot provide an atmosphere of unmediated free choice for racial and cultural identity formation. What desegregation can do is level the hierarchies of racial and cultural identity so that presently disempowered and subordinated communities are no longer systematically deprived of the political and economic resources that would allow them to thrive rather than merely to survive, and so that such communities could more readily interact with American society as a whole. Desegregation will undoubtedly alter the character of all racial communities. White communities are defined in part by their position of privilege, while minority communities are defined in part by their subordination and isolation. However, it is unclear exactly what the result of desegregation will be for established racial and cultural groups. Some groups may experience dispersal and disintegration, as ethnic white communities have in many parts of the nation. Some groups may grow stronger and more cohesive as their members gain greater resources and feel less economic pressure to leave racially identified neighborhoods and cities, while those who do leave will be able to experience group solidarity that does not depend on geographic proximity. New but distinct. Cultural communities may form as permeable political borders allow social, political, artistic, and educational alliances between previously isolated communities to develop. Whatever the result, it will reflect a form of cultural association and pluralism that is more consistent with the best of American democratic ideals. 3. Conc. The Boundaries of Race. His article has attempted to bring several distinct discourses to bear on the persistent issue of race relations and racial segregation in the United States. I have employed political economy and political geography, legal realist analytics, ideal and non-ideal normative political and social theory, critical legal theory and critical race theory, and a light dash of postmodernist social theory as well as urbanist theory. My focus herein has been necessarily sweeping and has, I fear, often sacrificed detail for breadth. Every discourse I have employed has a long academic tradition in which countless scholars have probed many of these issues in much greater depth than this article could allow. My goal here is to bring the insights of these various conversations together in order to demonstrate that racial segregation is a consequence of law and policy, that it can be changed by law and policy, and that there is ample precedent in American legal and political thought for the types of changes that would dramatically decrease the degree of segregation in America and the cities. This article is the beginning of what I hope will be an ongoing project. It probably raises more questions than it answers. I would like to have discussed in much greater detail such questions as the role of political space in the social construction of racial identity and the consequences of political space for identity politics and identity communitarianism, the complexities of all the policy proposals I have advanced, and the importance of changes in the economic structure and cultural logic of late 20th century America for contemporary racial and spatial relations. However, these questions are for another space. A note on methodology may now be in order. One objection to the relentlessly structural anal. The boundaries of race 463. ISIS that I have employed is that it devalues human agency and individual morality, that, by focusing on structures, one downplays the personal responsibility of flesh and blood people for social inequity. Some may well object that I let racists off the hook by proposing that political and economic institutions make racism inevitable. It is not my intention to supplant a strictly moral argument against racist practices, but, instead, to augment such an argument. I do not know what evil lurks in the hearts of men and women, but I do believe that the existing structure of what I have dubbed racially identified political space is likely to encourage even good men and women to perpetuate racial hierarchy. We need moral condemnation of racism, but we also need viable solutions. I do not intend this article to in any way stifle the former. I hope it may contribute to identifying the latter. We need solutions now. The threat of a racially fragmented metropolis and nation looms large on the horizon. The United States is rapidly fulfilling the grim prophecy of the Kerner Commission and becoming AF/East two societies, one black, one white, separate and unequal. Degree race relations are at a low ebb, a circumstance that contributes to the declining desirability of life in racially diverse urban areas. At the same time, though, the 1990 census shows for the first time that more than half of all Americans live in megacities, metropolitan areas of more than 1 million inhabitants. To survive and thrive in the metropolis that is America, we must attend to matters of race and of political space. It is not only space as much as time that hides consequences from us, but it is also location as much as history that defines us. If, as Douglas Massey and Nancy Denton assert, segregation is the missing link in previous attempts to explain the conditions of the underclass, then political geography is the missing element in attempts to reconcile the ideals of majoritarian democracy and private property with those of racial equality and cultural autonomy. The question of political space is not one of narrow concern, the province of cartographers and surveyors. It is also the domain of the democratic idealist, the activist lawyer, and the scholar of jurisprudence. Most of all, it is the domain of every citizen who believes in the experiment of self-government. The study of political space reveals that we the people is not a given but, rather, a contested community in a democratic society. The recognition that political spaces are often racially identified reveals that the boundaries of a democracy share territory with the boundaries of race. Rouge et Noir reread, a popular Constitution, a history of the Angelo Herndon case. Kendall Thomas. Introduction. If the ruling and the oppressed elements in a population, if those who wish to maintain the status quo and those concerned to make changes, had, when they became articulate, the same philosophy, one might well be skeptical of its intellectual integrity. John Dewey. In 1932, Eugene Angelo Braxton Herndon, a young Afro-American member of the Communist Party, USA, PUSA, was arrested in Atlanta and charged with an attempt to incite insurrection against that state's lawful authority. Some 5 years later, in Herndon v. Lowry, Herndon filed a writ of habeas corpus asking the U.S. Supreme Court to consider the constitutionality of the Georgia statute under which he had been convicted. 2 weeks before his 24th birthday, the court, voting 5-4, declared the use of the Georgia political crimes statute against him unconstitutional on the grounds that it deprived Herndon of his rights to freedom of speech and assembly, and because the statute failed to furnish a reasonably ascertainable standard of guilt. Herndon v. Lowry is generally acknowledged as one of the great civil liberties decisions of the 30s, one of the notable success stories of the Supreme Court's First Amendment jurisprudence. It marked the first time the Supreme Court had mentioned the Holmes-Brandeis clear and present danger formula in the 10 years since its decision in Whitney v. California. It was also the first case in which the court used the test to uphold the civil liberties claims of an individual against censorial state action, the first time the court reviewed a sedition conviction from the South, and the first political crimes conviction reviewed by the court that involved an African American defendant. One of the first critical commentaries on the 466 Race and Postmodernism case appeared in the 1941 edition of Free Speech in the United States. Zechariah Chaffee, Jr.'s classic study of First Amendment case law degree in an essay entitled Rouge et Noir, Professor Chaffee noted that in Herndon v. Lowry the Supreme Court was faced for the first time with the possibility that American citizens might be hanged or electrocuted for nothing except expressing objectionable opinions or owning objectionable books. Chaffee approached the arrest, trial, and conviction of Angelo Herndon as a case study in American political justice. Herndon's real crime, argued Chaffee, was that he sought to put the 15th Amendment into wider effect. Those in power in Georgia, Chaffee ironically observed, were afraid, not that the United States Constitution would be overthrown, but that it might be enforced. For Chaffee, two features of Herndon v. Lowry were especially significant. First, the opinion stressed the importance of the procedure in a sedition prosecution. Second, the case had forced the court to take notice, albeit implicitly, of the political use to which Southern states could put their criminal justice systems, crushing not only radical political activity but also moderate dissent and protest as well. Curiously, Chaffee attached little significance to the fact that the 1937 decision marked the third time in as many years that the Supreme Court had been called upon to decide whether the conviction of Angelo Herndon violated the First Amendment. Free Speech in the United States merely points out in a footnote and without comment that the Supreme Court at first refused to consider the case at all. Chaffee does not discuss the court's 1935 decision not to take appellate jurisdiction on the ground that the federal questions raised on appeal had not been properly presented. Nor does he mention the court's decision later that year refusing, without a written explanation, to grant Herndon's petition for rehearing. 1 An interesting and revealing separation and categorization of the Supreme Court's three dispositions of the Angelo Herndon case has followed in the legal literature. On the one hand, the favorable opinion in Herndon v. W. Lowry has been included and discussed in any number of casebooks on constitutional law and political and civil rights. Discussion of the first adverse decision, Herndon v. Georgia, on the other hand, has been confined for the most part to casebooks on federal court jurisdiction and procedure. The court's decision to reject Herndon's petition for rehearing has been ignored altogether. Thus, what is essentially one case has been doctrinally dissected by scholars as though it were made up of three severable, marginally related, or even unrelated parts. This conceptual dismemberment of the Angelo Herndon case has handicapped serious historical examination of one of its central themes: the intersection of race, culture, and politics in American constitutional law. I do not mean to deny the validity of an orthodox doctrinal treatment of the Angelo Herndon case, but I am persuaded that this procedure does not, indeed cannot, allow for more than a partial account of its larger historical meaning. Without a cultural anatomy of the Angelo Herndon case, one cannot hope to attain more than a skeletal picture of its significance as an episode in the history of American constitutionalism during the interwar years. This article, then, offers a remembrance of the case in the form of a cultural history of the political events that led to the court's first response to the case. I believe that the concept of a popular memory can offer us great insight into constitutional history, both as object and as method, and I have made the concept central to this article, not simply at the level of accent and emphasis but also in terms of epistemology and interpretation. American constitutional history remains one of the few disciplines in which the call for the rigorous reconstruction of our national past from the bottom up has for the most part been ignored. The historical treatment of constitutional law and politics in America is, in short, still largely an institutional history. We have yet to move beyond magisterial accounts of great advocates arguing great cases involving great issues decided by great judges sitting on great courts. I believe that American legal Rouget Noir reread 467. Scholarship has paid insufficient attention to the cultural history of constitutionalism in America. The chief task of a cultural history of American constitutionalism is to identify and interpret the records left by those who have experienced the American constitutional order from its underside. A cultural history of constitutionalism from below diverges from institutional history in its object of study as well as in its method and procedures. Its project thus differs from the institutionalist enterprise in at least two respects. First, a cultural history of constitutionalism from the bottom up recognizes the right of un- or misrepresented human groups to speak for and represent themselves in domains defined, politically and intellectually, as normally excluding them, usurping their signifying and representing functions, overriding their historical reality. More is at stake, however, than adding one part of a population, that which has been neglected, to another, that which has provided the traditional information base. Degree constitutional history from the bottom up also seeks to challenge the conceptual order or hierarchy that subtends the exclusion of the common run of human beings and their concerns from the historical study of constitutional law. This project, then, is not directed simply at reversing the long-standing bias against the record of the subaltern in American constitutional history. It also represents an effort to broaden the basis of history, to enlarge its subject matter, make use of new raw materials and offer new maps of knowledge. 1 degree one might anticipate that a popular memory of American constitutionalism will force us to rethink the very terms of constitutional history. The rereading offered here of the Angelo Herndon case should be taken as an illustration of the type of contribution that the quest for the recovery of a popular memory can make. The perspective of popular historical method permits us to see the extent to which the history of constitutionalism in America, viewed from its underside, can be plotted as a story of a body of law born of sustained struggle, the outcome of painful and passionate political and ideology. Contests between subordinate groups and dominant institutions. This is a story that the optic of institutional historiography is by definition unable to see, much less able to view empathetically. In my alternative account and interpretation of the Angelo Herndon case, I hope to show that it is only through the lens of popular memory that we can begin to reach a critical understanding of this and other chapters in the history of American constitutionalism. The method of popular constitutional history does not just recreate a legal case, it recalls a larger, largely forgotten political culture. It permits us to see Angelo Herndon not simply as an issue or problem for constitutional discourse but as a conscious agent in shaping this discourse. In short, popular constitutional historiography refuses to view constitutionalism in American culture as the exclusive preserve of elites and institutions. I begin with a reading of Angelo Herndon's political autobiography, Let Me Live. After placing it within the popular tradition of Afro-American resistance literature, I use it and other contemporaneous texts to offer an alternative account of the Angelo Herndon case from the bottom up. I shall, of course, take up the specific legal issues that were raised, argued, and decided during the course of the case. Thus, much of what I have to say will necessarily be cast in the familiar terms of orthodox constitutional history. However, in my reading of these texts of 30s institutional legal consciousness, I search for traces of popular memory. My central focus is on discovering what the official statements of constitutional doctrine in the Angelo Herndon case tell us about insurgent political consciousness among African Americans at one key moment in our national past. My purpose in this part, as in the rest of this article, is most emphatically not to offer a revisionist doctrinal history of the Angelo Herndon case. Rather, my main interest is in the larger lessons that this episode in our constitutional history conveys about a people's search for political literacy and the obstacles thrown in their way. This lesson is a broad one, of which the doctrinal dimensions of the case are merely one component. 468 Race and Postmodernism. Il. The struggle for an effective political language. And Carmade Hall. Next he read a piece in the Atlanta Georgian that they was $6,000 raised for the unemployed relief after the demonstration at the courthouse on Thursday morning. Anonymous, Handwritten minutes of July 1, 1932, meeting of the Ford and Foster Clubs. A. Popular culture and political consciousness. The Angelo Herndon case powerfully underscores the extent to which the history of the struggle of Afro-American people against an oppressive cultural, social, political, and economic order has also always been the history of a struggle against an oppressive discursive or symbolic order. Lucius Outlaw describes the struggle as a collective effort to embrace where available, to construct where unavailable, those productions and expressions of meaning which serve to reflect the self-affirmations of black people, our views of the world, in concepts and forms which we have projected for these purposes. G. Ivan. The history of enslavement, subjugation, subordination, discrimination, oppressions, which have been, and are, directed against us, the struggle for cultural and political integrity involves a counter-movement away from subordination to independence, from alienation through refutation, to self-affirmation, via a process of reflection which creates a different, and opposing, constellation of symbols and assumptions. 7 degrees. One decisive dimension of the African American struggle for political self-determination has been the practice of symbolic reversal. This term designates a process whereby one moves on the level of symbolic meaning, and, it is hoped, the level of existence, from imposed determination of one's, a people's, existence to those generated by oneself, by the people themselves, in the process of living as affirmations of that existence in its authenticity. 71 Although one may question the adequacy of the larger framework in which it is embedded, Outlaw's basic point is surely correct: the strategic manipulation and reversal of the dominant culture's political symbols is, and has long been, a central feature of African American resistance movements, in both their reformist and their radical incarnations. African Americans have lived by and fought through symbols. We cannot hope to comprehend the history of their collective encounter with the ideology and institutions of American constitutionalism unless we carefully attend to its symbolic aspects, conceived both as an arena and as an arsenal of struggle. This is to acknowledge the centrality of culture as the site in which African Americans have historically sought to make sense of and respond to their experience in the United States. By culture, I mean a broad range of practices, rituals, attitudes, beliefs, doctrines, images, and ideas that traverse or saturate the entire social formation. From this perspective, culture does not stand above or apart from the many other activities and relationships that make up a society, including the socially organized forms of domination, exploitation, and power pervasive in our own society and its history. 7. To note the significance of cultural practices in the history of American constitutionalism is to view culture as formed by, contributing to, and embedded in law and politics. Shortly before the Supreme Court rendered its decision in Herndon v. Lowry, Random House published Let Me Live. The book articulates the cultural foundations of the political struggles waged by African Americans during the Depression. On one level, Herndon's book is an extended meditation, in autobiographical form, on the relationships between language and power and between cultural and political consciousness. The cultural tradition within which Herndon comes to grasp the nature of politics is the religion of the Black Christian Church. Early on in Let Me Live, Herndon describes his childhood religious conversion by an old uncle at a revival meeting. As Herndon tells it, this experience shaped and at the same time circumscribed his perception of the problem of race relations in America. Years after the event, he compares and contrasts the emancipatory potential of religious belief with that of political radicalism after he, Rouge Noir reread 469, is introduced to the work of the Unemployed Councils, a national organization for jobless workers of all colors which had formed in the winter of 1929 to 30.7 degrees. At his first meeting, the unemployed black teenager listens to an old black steel worker explain why he has joined the Unemployed Council. By the end of the meeting, Herndon decides to become one of the Reds, whom the black church had taught him were wicked people blaspheming against God. 78 In a passage that evokes the tradition of spiritual autobiography, Herndon describes his entry into radical politics and consciousness as a second conversion experience. Strange, only once before had I walked up to a speaker who had moved me so deeply and been converted. That was the time when my uncle Jeremiah preached his first sermon. The emotional motivation in both cases was identical, but what a difference in their nature and in their aim. The change of my viewpoint was almost fabulous, emerging from the urge to escape the cruelties of life in religious abstractions into a healthy, vigorous, and realistic recognition that life on earth, which was so full of struggle and tears for the poor, could be changed by the intelligent and organized will of the workers. For the first time, writes Herndon, he comes to see the promise and necessity for the political program of the PUSA, which aimed to forge class alliances across the color line. This recognition entails nothing less than a complete reworking of Herndon's worldview. That night when I went to bed, I couldn't fall asleep. My mind was too excited by the events of the evening to calm down. Something very important had happened to me, I knew, and I lay with wide open eyes staring into the darkness of my room and thinking that it was at last necessary for me to revise my attitude toward white people. I had discovered at last the truth that not all white people were enemies and exploiters of the Negro people. In fact, the same vicious interests that were oppressing Negro workers were doing the same thing to white workers, that both black and white workers could solve their problems only by a united effort against the common enemy, the rich white people, they who owned the mines, the mills, the factories, the banks. Herndon's initiation into a new political language Marxism brings him to consciousness of the power of language itself. He writes, "My education, as I have made clear in this narrative, was practically nil. Throughout all my struggles and vicissitudes hungered for learning. But a new force now entered into my life. It created a revolution in it. The education I longed for in the world I had expected to find it I surprisingly began to receive in my new communist circles. To the everlasting glory of the communist movement may it be said that wherever it is active, it brings enlightenment and culture. Every meeting of the Unemployment Sick Council became a classroom for me. I never left one of them without bearing away with me the discovery of a new idea. Of course, I did not always understand everything that I heard or read, but what of it? It was enough that I understood that they were on the right track. Throughout Let Me Live, Herndon stresses the centrality of education to his political development. At one point, he notes the painful concentration with which he read a copy of the Communist Manifesto which a white worker had given him. To test his understanding of Marx and Engels, Herndon writes a simple account of the text in my own words, **. The worker has no power. All he possesses is the power of his hands and his brains. It is his ability to produce things. It is only natural, therefore, that he should try and get as much as he can for his labor. To make his demands more effective he is obliged to band together with other workers into powerful labor organizations, for there is strength in numbers. The capitalists, on the other hand, own all the factories, the mines, and the government. Their only interest is to make as much profit as they can. They are not concerned with the well-being of those who work for them. We see, therefore, that the interests of the capitalists and the workers are not the same. In fact, they are opposed to each other. What happens? A desperate fight takes place between the two. This is known as the class struggle. The idea, says Herndon, seemed so self-evident that I scolded myself for having been so stupid as not to have recognized it before. Since this moment, Herndon appropriates the grammar and categories of Marxist theory for use as a discursive means and an analytic tool with which to explain his condition and that of people like him. His effort to rewrite the Communist Manifesto in his own language is an attempt to rewrite his own life experience. Herndon's discovery of the language of classes. 470 Race and Postmodernism, the beginning of a decisive transformation of his thoughts and feelings about race in America. The chief theoretical interest of these passages from Let Me Live, from the perspective of popular constitutional history, lies less in the substance of Herndon's Marxist politics than in what they indicate about the cultural process and forms through which Herndon's political consciousness was fashioned. Despite its flaws, and there were many, Degree The political culture of American Marxism enabled Angelo Herndon to acquire what so many young African American men in our time find in the institution of the American prison, a political education providing a basic set of terms, a language with which to interpret their place in society and try to change it. It is easy to say in hindsight that Herndon and his black contemporaries were unwitting pawns in a cynical political game waged by the Soviet Union against the United States, and locally by the American Communist Party against the NAACP. It is equally easy to show that, as a theoretical and practical matter, the PUSA was unwilling or unable to acknowledge that race and culture in American politics could not be subsumed under the language of class struggle. There is some truth in both these claims. In a sense, however, these criticisms are beside the point. We are still left with the task of explaining why blacks like Angelo Herndon chose to join and stay in the PUSA, and why, given all its theoretical and practical shortcomings, an organization like the PUSA was still able to become such an important force within the black community during the first years of the Depression. More fundamentally, these interpretations run the risk of refusing to see Angelo Herndon and those like him as historical actors in their own right and not merely objects or instruments of some other will. Nothing could be more elitist than blithely to dismiss Herndon's narrative of his trial and conviction, whether the dismissal takes the form of a weak claim that Let Me Live is a layman's legal history with which we need not be concerned, or whether it rests instead on a stronger assertion that the book is merely a piece of audacious Communist Party propaganda. The belief that Herndon's purported ignorance makes Let Me Live irrelevant, or that his perceived insolence makes it unreliable, derives from premises that are more ideological than intellectual. For the popular constitutional historian, one of the most interesting aspects of Let Me Live is the fact that it offers an exemplary instance of the way law, politics, and culture articulate at the level of individual consciousness and sensibility. At one point in Let Me Live, Herndon acknowledges that some people may, perhaps, accuse me of preaching or making unnecessary propaganda for the communist cause. After all, they might say, this is only the story of my life and does not call for evangelical outbursts. Degree. Herndon offers the following response. To this I will answer in all earnestness that the story of my life without my reactions to my own problems and to the problems of the world with the communistic viewpoint as its key and guide, without my fervors and indignations, without my hatreds and without my loves, would remain an untrue and distorted narrative, without blood and entrails. Degree. These words provide a concrete illustration of the more abstract points I have made concerning the relationship among law, culture, and politics. Consider the cultural content and connotations of the expressive form in which Herndon defends his reliance on the political language of Marxism. His references to his fervors and indignations, his hatreds and loves, disclose a distinctive structure of feeling, a set of meanings and values as they are actually lived or felt, as opposed to formal ideologies or worldviews. As Herndon tells it, he cannot not make use of the Enlightenment and culture *. He has acquired through his involvement with the PUSA, because they have been woven into his very sensibility. It is only through the template of his cultural and political encounter with Marxism that Herndon can give meaning to his personal experiences in the courtrooms and jailhouses of Georgia. The passage above registers the degree to which Herndon's grasp of legal ideology and institutions emerged from and was embedded in practices and perspectives that were at the same time cultural and political. Rouge et Noir, reread 471. Let Me Live resists the disciplinary and discursive encroachments of an institutionalist constitutional orientation. The story it tells is an episode in our constitutional history whose symbolic significance cannot be captured by the instrumental language of law. While an interpretation concerned solely with the legal issues, questions, rules, holdings, and principles raised by the Angelo Herndon case is important, it cannot begin to address the case's deeper cultural and political foundations. Of course, to say that the account of the Angelo Herndon case offered in Let Me Live eludes the language of conventional constitutional history does not mean that it cannot be told at all. The story of the role that black political insurgency has played in American constitutionalism, the story of which the Herndon case is a part, can indeed be told, So long as we give due regard to the cultural sources from which that insurgent consciousness emerged and to the cultural forms through which it was expressed. Herndon's account of what his experience with the law meant to him in political and cultural terms is a story that a constitutional history of the case from the bottom up holds itself bound to respect. By using Let Me Live as the starting point for my discussion of Herndon v. Georgia, I aim to enact at the level of method something similar to the symbolic reversal that Lucius Outlaw has identified as a defining characteristic of African American political history, and thus to bring the cultural dimensions of the Angelo Herndon case from the margins to the interpretive center of our historical concerns. B. A scrap of paper, The Trials of Angelo Herndon. Let Me Live is a textual record of the inextricable links among law, politics, and culture in the history of Afro-American insurgency. What E. P. Thompson has observed of the literary record left by 18th-century English Puritans is equally true of Let Me Live. Herndon's account may be read as a sign of how men felt and hoped, loved and hated, and of how they preserved certain values in the very texture of their language. Let Me Live may be interpreted as a product of, and a meditation on, one of the central themes in the history of African people in America, the struggle of a people for political literacy and against the political resistance mobilized to frustrate that collective endeavor. Seen in this light, the Herndon case is an important episode in the historical effort of African Americans to find a political language with which to understand their past aspirations and to articulate their future aspirations. Against this thematic backdrop, I turn to an account of the discursive events that brought Angelo Herndon before the bar of the U.S. Supreme Court. Writing and resistance. An anonymous letter set the events in motion. On the night of June 29, 1932, hundreds of copies of a leaflet were distributed in the poor white and black neighborhoods of Atlanta. It read, "Workers of Atlanta. Employed and unemployed Negro and white attention. Men and women of Atlanta. Thousands of us, together with our families, are at this time facing starvation and misery and are about to be thrown out of our houses because the miserable charity handout that some of us were getting has been stopped. Hundreds of thousands of dollars have been collected from workers in the city for relief for the unemployed, and most of it has been squandered in high salaries for the heads of these relief agencies. Mr. T.K. Glenn, president of the Community Chest, is reported to be getting a salary of $10,000 a year. Mr. Frank Neely, executive director of the Community Chest, told the county commission Saturday that he gets $6,500 a year, while at the same time no worker, no matter how big his family, gets more than $2.50 to live on. If we count the salaries paid the secretaries and the investigators working in the 38 relief stations in the city, it should not surprise us that the money for relief was used up and there is no more left to keep us from starvation. If we allow ourselves to starve while these fakers grow fat off our misery, it will be our own fault. The bosses want us to starve peacefully and by this method save the money they have accumulated off our sweat and blood. We must force them to continue our relief and give more help. We must not allow them to stall us any longer with fake promises. The city and county authorities from the money they have already collected, $472 from us in taxes, and by taking the incomes of the bankers and other rich capitalists, can take care of every unemployed family in Atlanta. We must make them do it. At a meeting of the county commissioners last Saturday, it was proposed by Walter S. McNeil, Jr., to have the police round up all unemployed workers and their families and ship them back to the farms and make them work for just board and no wages, while just a few months ago these hypocrites were talking about forced labor in Soviet Russia, a county where there is no starvation and where the workers rule. Are we going to let them force us into slavery? At this meeting Mr. Hendricks said that there were no starving families in Atlanta, that if there is he has not seen any. Let's all of us, white and Negroes, together, with our womenfolk and children, go to his office in the country courthouse on Pryor and Hunter Streets Thursday morning at 10 o'clock and show this faker that there is plenty of suffering in the city of Atlanta and demand that he give us immediate relief. Organize and fight for unemployment insurance at the expense of the government and the bosses. Demand immediate payment of the bonus to the ex-servicemen. Don't forget Thursday morning at the county courthouse. Issued by the Unemployment Committee of Atlanta PO. Box 339. The following morning Angelo Herndon, a 19-year-old black organizer for the PUSA in Atlanta, was among the leaders of a peaceful march to the Fulton County Court building. More than 1,000 people, black and white, participated in the protest. The march was reportedly the largest biracial demonstration the South had seen in decades. County officials called in a group of white marchers to discuss their concerns but refused altogether to talk to any of the black demonstrators. The day after the rally, the Fulton County Commission approved a $6,000 emergency appropriation to buy food for the 23,000 people who had been solely or largely supported by the relief system. The importance of this demonstration lies in the fact that it served both an instrumental and an expressive function. The gathering at the Fulton County Courthouse was simultaneously a political and cultural event. Using forms of popular protest, these hungry and homeless men and women were able to force material, race and postmodernism, concessions from government officials who had ignored their plight. Equally significant, however, was the symbolic challenge this collective action posed to the racial status quo. In refusing to respect the racial boundaries that had separated them for so long, the poor blacks and whites who participated in the demonstration had taken tentative steps toward the creation of a new political and cultural community. For a brief moment, class consciousness trumped color consciousness, creating possibilities for an effective political coalition and collective self-identification across the color line. This extraordinary fact was not lost on the organizers of the gathering. In a leaflet announcing the government's concession, the Unemployed Council boasted of having crammed the lie down the throat of the commissioner who had denied that starving people existed in Atlanta, and it encouraged participants in the rally to help the council force these fakers to give more and regular support to the unemployed. The circular also pointed out that the county commissioners had attempted to divide the demonstrators along racial lines, warning that if we allow the bosses to divide us, they will keep us both starving. The pamphlet urged black and white workers to stick together because that is the only way we can win. The bosses know this, that is why they work so hard to separate us. The privilege of starving separately don't mean anything to any sensible worker these days. *degree The leaflet called on the unemployed to resist any attempt by landlords to try to evict people in their neighborhoods, and it urged the workers of every neighborhood to get together, organize your committees and see that no worker is evicted because he can't pay the rent. *The leaflet ended with a threat that was also a rallying cry: we refuse to starve. Number 8. The Atlanta Police Department immediately assigned a squad of detectives to shadow the suspected leaders of the Unemployed Council. The department instructed detectives to put the city's post office under special surveillance, because both of the leaflets had listed a post office box there as the Unemployed Council's mailing address. Rouge et Noir reread 473. On the evening of July 1, 1932, two Atlanta policemen arrested Angelo Herndon as he was taking mail from P.O. Box 339. Herndon was taken to his apartment, where the policemen seized all of his books as well as bundles of pamphlets published by the PUSA. Herndon was then taken to the Fulton County Jail, where he was held for 11 days without bail on suspicion. On July 21, a local white lawyer and two black lawyers filed a petition seeking the release of Herndon, who still had not been formally charged with any crime. A judge for the Fulton County Superior Court denied the request, but he did order the Fulton County Solicitor General's office to secure an indictment within 24 hours or let Herndon go. The next day, the Fulton County Grand Jury issued a formal indictment against Herndon. 8 accused, in the county of Fulton and state of Georgia, on the 16th day of July, 1932, a date on which Herndon was in the custody of the Atlanta police, with force and arms, did make an attempt to join in combined resistance to the lawful authority of the state of Georgia with intent to the denial of the lawful authority of the state of Georgia and with intent to defeat and overthrow the lawful authority of the state of Georgia by violent means and unlawful acts. To support these charges, the indictment recited a long list of criminal acts that Herndon had allegedly committed. The indictment reads like a register of forbidden speech and transgressive discourse, an index of all the ideas that Georgia authorities feared a disaffected citizen of any class or color might think, hear, utter, read, or write. Herndon, the indictment charged, had called public assemblies and mass meetings in the homes of various persons. Names and addresses are to the grand jurors unknown, and did make speeches to various persons to the grand jurors unknown, degree allegedly to establish a group of persons white and colored under the banner of the courts and to provoke combined opposition and resistance to the state. The indictment further accused Herndon of soliciting persons whose names are to the grand jurors unknown to join the Communist Party and the Young Communist League. Despite the fact that the PUSA and its subsidiary organizations had not been banned by law in Georgia, the indictment stated that Herndon's organizing work was animated by a criminal purpose to create by acts of violence, by unlawful means and by revolution a new government known as the United Soviets, Soviet Russia, SIC, sometimes called and known as the dictatorship of the propertyless people. Asterisk. The indictment also charged Herndon with circulating a number of books and pamphlets that called for insurrection, riots, and armed uprisings against the state. The writings cited included The Life and Struggles of Negro Toilers, which stated that in no other so-called civilized country in the world are human beings treated as badly as these 15 million Negroes. They live under perpetual regime of white terror, which expressed itself in lynchings, peonage, racial segregation and other pronounced forms of white chauvinism. Other writings listed in the indictment included a book called Communism and Christianism, which exhorted its readers to unleash the gods from the skies and capitalists from the earth and make the world safe for industrial communism, and the Southern Worker and the Daily Worker, both PUSA publications. Given the language and history of the statute that formed the basis of the indictment, the Herndon case would likely have been politicized even if the defendant had not been a Communist Party member. Angelo Herndon was indicted under Section 56 of the Georgia Penal Code, which read, "Any attempt, by persuasion or otherwise, to induce others to join in any combined resistance to the lawful authority of the state shall constitute an attempt to incite insurrection." Anyone who reads this provision in the context of its long and infamous history is able to see the fear of racial unrest and radical politics that is reflected in every word. During the 1830s, a number of Southern state legislatures, shaken by the Nat Turner Rebellion and frightened by the increasingly militant posture of the abolitionist movement, enacted criminal laws against insurrection. The purpose of these laws was to guarantee that the full 474 coercive power of the state would suppress not only attempted or actual slave revolts but any public opposition whatsoever to the institution of slavery and its ideology. The Georgia legislature revised its criminal calendar in 1833 to read, "Exciting an insurrection or revolt of slaves, or any attempt by writing, speaking, or otherwise, to excite an insurrection or revolt of slaves, shall be punished with death." The next section of the Penal Code, which was intended to stop the flow of abolitionist literature into the South, made into a capital offense the introduction or circulation within the state of any written text aimed at inciting resistance, revolt, or insurrection among slaves or free blacks. After the Civil War, the Southern states were forced to revise their statutes to acknowledge the new status of their former slave population. Accordingly, in 1866 the Georgia legislature redrafted many of its laws, including the slave revolt provisions. Specific references to slaves were deleted from the text of these laws, but the concept of insurrection remained central. Insurrection was defined as combined resistance to the lawful authority of the state. The Georgia Penal Code was then amended to read that any attempt, by persuasion or otherwise, to induce others to join in any combined resistance to the lawful authority of the state, shall constitute an attempt to incite insurrection. Unless a jury recommended mercy, the statutory punishment for insurrection or attempted insurrection was death. The revised statute set no specific punishment for an attempt to incite insurrection, the crime of which Angelo Herndon was accused many years later. Presumably, the legislature thought that an attempt to incite insurrection would fall within the language of the amended code. The state legislature also changed the accompanying section of the code dealing with insurrectionary texts, substituting a 5 to 20-year prison term for capital punishment. There were 2 recorded prosecutions under the Georgia insurrection laws between 1866 and 1932. The first took place in 1868. John T. Gibson, described in the record as a preacher and a free person of color, degree was charged with inciting 100 blacks to break into a race and postmodernism Georgia jail to rescue a local black man being held there. Under Gibson's alleged direction, armed blacks attempted to enter the jail but retreated after a guard fired a shot into the crowd. No other violence followed. Gibson was sentenced to death following his conviction for attempting to incite insurrection. In 1869, Gibson's attorneys appealed his conviction to the Georgia Supreme Court. They argued that the state's penal code failed to expressly include attempts to incite insurrection, as distinguished from insurrection itself and attempted insurrection. The court found for the defense and ordered Gibson's release, reasoning that the rule that required strict construction of penal statutes rendered the Gibson conviction void because the statute had not specifically included attempts to incite insurrection. The opinion called the attention of the legislature to the omission and expressed a hope that this defect would be cured. The Georgia legislature obliged in 1871, making an attempt to incite insurrection a capital crime. The statute remained unused for nearly 60 years, until Fulton County authorities turned to it in the early 30s. The second recorded use of Georgia's insurrection laws came in the case of the Atlanta Six. The Atlanta Six were 4 men and 2 women, all members of the PUSA, who were accused of attempting to incite insurrection and circulating insurrectionary literature. It was clear from the beginning that the prosecution of the Atlanta Six was based on the group's political ideology, and not on any alleged criminal acts. Through the efforts of Walter Wilson, a member of the ACLU, several state newspapers published a statement during the summer of 1930, signed by 61 prominent Georgians, condemning the political prosecution of the Atlanta Six. Although the statement did not go so far as to endorse communism, it did argue that members of the PUSA, like all Americans, should be protected in their constitutional rights of free speech and assembly. To War of Words William L. Patterson, the black secretary of the International Labor Defense, the PUSA's Rouge Noir reread L. 475. Equivalent of today's NAACP Legal Defense and Education Fund, arrived in Atlanta shortly after Herndon's arrest to organize Herndon's legal defense. Patterson promptly denounced the case as a frame-up and charged that almost every bit of so-called red literature found in Herndon's room after this arrest may be found in books, magazines, and pamphlets at the public library. Why not arrest the librarian? Registered. John H. Hudson, the prosecutor who later argued the state's case against Herndon, had already made Fulton County's position toward the young black radical, and others like him, emphatically clear. You well know that this country cannot survive if people are allowed to go from one end to another of this country preaching, teaching, and working for its destruction, Hudson warned. Communists must be put down or civilization will fail. These remarks were the opening shots in a rhetorical battle that was to escalate rapidly in the months before Herndon's trial, in early January 1933. Viewed in the context in which it was fought, this war of words for control over the political interpretation of the Angelo Herndon case was not at all surprising. At the time, there were mounting racial tensions in Atlanta, growing discontent among the city's unemployed in the worst year of the longest, deepest economic depression in modern American history, a perceived need among those in power to crush any and all signs of political insurgency among poor white and black communities, and a single-minded determination on the part of the PUSA and the International Labor Defense to make the Angelo Herndon case a symbol of racial injustice in America. All this, together with the fact that the arrest and conviction of Angelo Herndon followed closely upon the success of the Unemployment Council's June 1932 demonstration, made for a classic political trial. A publication from the period shows the degree to which the intertwined issues of race, radical politics, and political repression had come to occupy an important place in mainstream political discourse in America. The Crisis, a publication of the NAACP, asked 14 editors of leading black newspapers their opinion of communism registered and printed their responses in its April and May issues. The editor of a Maryland newspaper, The Afro-American, wrote, "The communists appear to be the only party going our way. They are as radical as the NAACP were sick 20 years ago. Since the abolitionists passed off the scene, no white group of national prominence has openly advocated the economic, political, and social equality of the black folks." Although the editor of Virginia's Norfolk Journal and Guide did not think communism offered the way out for the Negro which shall be most beneficial and lasting in the long run, he predicted that the PUSA would continue to gain adherents in the black community because traditional American conditions with their race prejudice, economic semi-enslavement, lack of equal opportunity, and discrimination of all sorts have made the Negro susceptible to any doctrine which promises a brighter future, where race and color will not be a penalty. The editor of the New York Amsterdam News noted that since America's 12 million Negro population is so largely identified with the working class, the wonder is not that the Negro is beginning, at least, to think along communistic lines, but that he did not embrace that doctrine en masse long ago. The editor of the Philadelphia Tribune argued that while hopeful Negroes may reason that the philosophy and economic theories of communism are unsound and will not obtain for them a more equitable distribution of the products of their labor, or a larger degree of justice, a drowning man will grab at a straw. When it is considered that equality is the theory of communism, and that inequality is the result of the present system, it is amazing that millions of Negroes have not joined the followers of the red flag, instead of a few thousands. The editor of the Atlanta World argued that the Negro as a whole fears communism probably because white America has not accepted it. Some frankly believe red promises would be forgotten were they in power, for aren't they white men too? The editor did admit, however, that if enough of us would go 476 red, 12 million black communists would be too big a group to deal with by force. 10 years before, such openly positive views on the Communist Party from leading figures in the black establishment press would have been unthinkable. The year 1932 also saw the publication of Georgia Nigger, a thinly fictionalized account of life in a Georgia prison camp, written by a white journalist named John Spivak. Spivak had been given permission from the state prison commissioner to tour the Georgia convict camps in preparation for a study of the state's penal system. Spivak's study turned out to be a scathing expose of the state's brutal prison system, complete with powerful documentary photographs. Although Spivak took care to note that Georgia does not stand alone as a state lost to fundamental justice and humanity, this did little to mollify state officials when they learned that a resolution had been introduced in the U.S. Senate calling for an immediate and thorough investigation of the charges that Spivak had made. Although Georgia Nigger never directly addressed the political ramifications of a penal system dominated by a largely black population, the PUSA and the International Labor Defense took full advantage of the propaganda value of Spivak's book and used its image of racial injustice to bring the Angelo Herndon case into the national political consciousness. Race, radicalism, and rights. Such was the complex political backdrop against which the trial of Angelo Herndon took place. Although the trial lasted a mere 3 days, during its course issues were raised and argued that went far beyond the technical legal question of whether Herndon was guilty beyond a reasonable doubt of attempting to incite insurrection. These issues opened onto the whole history of the black experience in the American South, the exclusion of blacks from petty and grand juries in Georgia, the treatment of black prisoners in Georgia jails, the long-standing taboo against black lawyers arguing cases as politically charged as Herndon's, the ideology of Southern law and order, laid bare when death threats were made against Herndon, his race and postmodernism. Attorneys, and anyone else who was bold enough publicly to support or participate in the effort to build a defense movement around the case, the myth of white supremacy, which trumpeted the racial superiority of even the poorest, most illiterate white worker and demonized the class-color alliance of the unemployed council as an offense against God and nature, and the meaning of the Marxist theory of revolution generally and the theoretical platform of the PUSA in particular. By the time the case reached the U.S. Supreme Court, these explosive issues of race, class, and radicalism would be submerged from view. At the trial stage, however, each of these issues provided a site of fierce ideological contestation. It was the issue of race, though, that served as the most potent conductor for white Georgians' fear of Angelo Herndon and what they took him to represent. Two characteristic passages from the trial record provide an index of the centrality of racial ideology in the Herndon case. One hotly contested question had to do with how Herndon's race would be referred to during the trial proceedings. At one point, T.J. Stevens, an assistant in the Fulton County Solicitor General's office and the prosecution's main witness, referred to Herndon as the Starkey. The following exchange ensued between Lee B. Wyatt, the trial court judge, and Ben Davis, the black lawyer and recent Harvard Law School graduate who represented Herndon. Attorney Davv is, Mr. Stevens refers to the defendant as Darkey. Your Honor, we wish to remind the prosecution if they insist on using such opprobrious terms to the defendant, we will have to ask for a mistrial, because it is prejudicial to our case. The court, I don't know whether it is or not, but suppose you refer to him as the defendant witness. Your Honor, I wish to state that Negro is the name this man referred to his race by in his conversation with me. These are capt eus objections. Attorney Davis, but he says Darkey. The court, well, refer to him as the defendant then. Witness, I will refer to him as Negro, which is better. He gave the name of Alonzo Hearn. Rouge Noir reread 477. Don Angelo Herndon, he is the darky with the glasses on. 7. A second heated exchange took place during the prosecution's cross-examination of T.J. Corley, an assistant professor of economics at Emory University, whom the defense sought to have qualified as an expert witness on the Marxist theory of the state. The subject under exploration was the Black Belt doctrine of the PUSA, which called for black self-determination and political control over areas of the South in which African Americans constituted a majority. After trying unsuccessfully to paint the witness as a communist sympathizer, if not an outright member of the PUSA, the prosecution introduced a motif that it was to play upon throughout the trial. A. Equal rights for the Negroes, self-determination in the Black Belt. You're able to tell us what that means, aren't you, Doctor? No sir. I did not testify that I understand the planks in the communist platform. I said I was familiar with the party platform. As to whether I will now swear that I understand it, the question which you raise, I should say, is a question of opinion and not of fact. There are some questions of opinion. I could give you my opinion of what it means. As to whether it takes an opinion to tell the court and jury the ordinary Decatur Street meaning of self-determination, I think it is a matter of opinion. There are several techniques by which self-determination might be expressed. For instance, there might be a plebiscite vote, or there might be an election for representatives to a body. There are a number of ways in which self-determination would assert itself, and I think it is a matter of opinion. I have not read this little pamphlet entitled The Communist Position on the Negro Question. One would be glad to give the court and jury my understanding of the expression equal rights for Negroes. The meaning of the phrase, as I see it, it is these rights are equal rights under the law. A. You understand that to mean the right of a colored boy to marry your daughter, if you have one? Attorney Davis, we object to that question on the ground that it is irrelevant and immaterial and calls for a conclusion of the witness. The court, he has him on cross-examination and that's a part of the language in the platform. Attorney Davis, there is nothing whatever in the platform about intermarriage. The court, the same quotation he is reading there is in the platform, as I understand. Attorney Da6 is, you overrule my objection, Your Honor? The Cour RT, I overrule the objection, go ahead. A. A Negro doesn't happen to have the right to marry my daughter. under the laws of this state. I don't know how many states there are in the Union where they do have that right. A. Did you know there are 20 states in the United States where the two races can intermarry? A. No, I didn't know that. I knew there was a number, I didn't know how many. Attorney Davis, I don't see what that has to do with this particular case, Your Honor, we object to it as irrelevant and immaterial. The court, he has the witness on cross-examination, and he has testified that he knows what that phrase means, and he has a right to determine how much he knows about it. On cross-examination it isn't his witness. From our contemporary perspective, it one's tempting to laugh at these dialogues, which seem at times to parody themselves. Yet a proper historical reading of the trial record must remain mindful of the fact that these comic exchanges might well have had a tragic, deadly denouement. Herndon's life hung in the balance. If we viewed Herndon v. Georgia through the optic of an institutionally oriented constitutional history, we might well be tempted to discount these portions of the trial record on the ground that they have no bearing on the way the procedural and substantive issues raised by the case were discussed before the Supreme Court. As I shall argue presently, however, when viewed through the lens of popular memory, these apparently marginal moments from the Herndon trial record present cultural images and arguments the impact of which was decisive to the outcome of the Herndon prosecution. My interest at this juncture is in the content of these interrogative exchanges. These Ks. 478 race and postmodernism questions and answers, and the ensuing verbal volleys between the prosecution and defense counsel, carry a twofold significance. First and most obviously, they indicate that the legal issues raised in the Herndon prosecution were immediately translated into questions of race and cultural power. The cultural meanings attached to the fact that Herndon was black quickly and definitively eclipsed the issues of free speech and radical politics raised by the case, quite literally coloring each and every aspect of the trial proceeding. A second and more complicated issue is the degree to which the Herndon case was invested with a sexual dimension. The intersected histories of race and sex in America tell an unseemly story beyond the scope of the present discussion. Nonetheless, some attention to the ideology of sexual racism * is indispensable in order to understand the precise cultural inflections of the Angelo Herndon case. This is so because at the core of the heart of the race problem is the sex problem. For one prominent and recurrent theme in the Black American experience is whites' defensive resort to sexual mythology as a source of ideological resistance to demands for racial justice. The ideology of white supremacy has rarely failed to find a dark and dangerous sexual motive behind the assertion of black political and civil rights. This almost reflexive ascription of sexual meanings to black political militancy is surely one of the most constant and curious features of our national history. In this respect, the Herndon trial record provides a historical case study of the effects of sexual racism on the administration of law generally and the protection of black political speech in particular. From the outset, the legal and political issues raised by the Herndon case were distorted by the sexual fears and fantasies projected onto Herndon by a cultural mentality in which power and dominance were shot through with passion and desire. For the men who controlled the government of Fulton County, the most effective way to control, if not crush, the emerging political discontent that Herndon and the local PUSA had successfully tapped was to evoke the racist mythologies of rapacious black male sexuality. The language I have quoted from the Herndon trial record thus provides a vivid textual instance of how deeply the cultural norms, practices, and protocols of the racially stratified society in which Herndon lived were inscribed in the workings of the law. At base, the legal question of Herndon's guilt or innocence could not be separated from either the cultural meanings attached to the idea of race or from the political relations of white supremacy and black subordination of which those cultural meanings were both a cause and consequence. Once drawn, the connection between race and radicalism meant that contested notions of cultural identity and ideology would constitute the chief terms in which the legal questions raised in the Herndon case would be described, discussed, debated, and decided during the trial proceedings. No one doubted that the outcome of the case would thus depend as much on who Herndon was as if not more than on what he had done. Prosecutor Hudson sought to make the perceived threat that Herndon posed to the local racial order the pivotal issue in the case. He made every effort during the trial to ensure that the racial implications of the events leading up to Herndon's arrest would be brought to the attention of the all-white jury. As the passages from the trial record indicate, the prosecution lost no opportunity to exploit the symbolism of Herndon's race. During the course of the proceedings, the language of race was used both to degrade Herndon, as in the dispute about what to call him, and to demonize him, as in the exchanges about the presupposition on interracial marriage. Given the prosecution's mobilization of racial meanings and metaphor, Herndon's lawyer had to choose between two equally untenable options. Benjamin Davis could either admit that Herndon's race was in fact a central issue in the case and respond directly to the prosecution's race baiting, or he could downplay the racial aspects of the case and address the issue only when the racist tactics of the prosecution forced him to do so. He took the latter, defensive posture. Davis's defense of Angelo Herndon had two components. First, Davis tried to establish the Rouge Noir reread 479 technical insufficiency of the evidence introduced by the prosecution. During his cross-examination of Stevens, the Assistant Solicitor General, Davis successfully pressed the prosecution's key witness to admit that he had no personal knowledge of any of the acts that have been alleged to be committed in the indictment by the defendant. In addition to Professor T.J. Corley, whose cross-examination allowed the prosecution to raise the specter of interracial marriage, Davis called Mercer G. Evans, a professor of economics at Emory University. Although Judge Wyatt refused to qualify Evans as an expert witness, Davis did use Evans's testimony to show that the same Marxist literature found in Herndon's possession could be read at the Emory University Library. The second component of Herndon's defense was more straightforwardly political. The prosecution had sought to shape the meaning of the events leading to Herndon's arrest by resorting to racial rhetoric. Davis sought to transcend the issue of race by depicting the charges against Herndon as a campaign against the working class. This counter-strategy became clear when Angelo Herndon took the stand in his own behalf. Under Georgia criminal procedure, a defendant could make only an unsworn statement. This statement was not subject to questions by either prosecution or defense lawyers. It was a direct address from the defendant to a jury made up of his peers. In this case, Herndon's peers were all white. Herndon began by describing the closing of Fulton County relief agencies in June 1932 and explained the purpose behind the public rally that was organized by the Unemployed Council a few days after the termination of relief was announced. He stressed the power and potential of a class coalition such as that symbolized by the biracial demonstration at the Fulton County Courthouse, ending his statement with a prediction that the alliance between poor whites and blacks forged by the Unemployed Council would not be destroyed by silencing its leaders. The capitalist class teaches race hatred to Negro and white workers and keeps it going all the time, tit for tat, the white worker running after the Negro worker and the Negro worker running after the white worker, and the capitalist becomes the exploiter and robber of them both. It is in the interest of the capitalist to play one race against the other, so greater profits can be realized from the working people of all races. At the present time there are millions of workers in the United States without work, and the capitalist class, the state government, city government, and all other governments, have taken no steps to provide relief for those unemployed. And it seems that this question is left up to the Negro and white workers to solve, and they will solve it by organizing and demanding the right to live, a right that they are entitled to some of the things that they have produced. Not only are they entitled to such things, but it is their right to demand them. When the state of Georgia and the city of Atlanta raised the question of inciting to insurrection and attempting to incite insurrection, or attempting to overthrow the government, all I can say is, that no matter what you do with the Angelo Herndons in the future, this question of unemployment, the question of unity between Negro and white workers cannot be solved with hands that are stained with the blood of an innocent individual. You may send me to my death, as far as I know. I expect you to do that anyway, so that's beside the point. But no one can deny these facts. Degree. One student of the case has suggested that Herndon's undiplomatic and inexpedient speech, with its simplistic Marxist interpretations, did little to aid his cause. As one reporter who covered the case wrote, Herndon had really talked himself into jail. It seemed to me that he wanted to make a martyr of himself, and he did. 8. These observations are undoubtedly true. The position Herndon took in his courtroom address to the unseen jury of the working class the world over provides ample evidence of his willingness to be enlisted as a sacrificial goat, to use the words of W.E.B. Du Bois, registered, on the altar of international communism. The immediate goal, however, was clear. Herndon hoped to awaken the class consciousness of the jurors. The closing statements continued the strategies that the prosecution and defense had followed throughout the trial. The prosecutor predictably played on the jurors' racial solidarity, arguing that they were duty-bound as white men to crush Herndon's plan to attack homes, take our property, rape our women, and murder. 480. Race and postmodernism are children. The final words of Herndon's attorney to the jury were that anything short of Herndon's acquittal would be making a scrap of paper out of the Bill of Rights, the Constitution of the United States and the state of Georgia. Taking Herndon's lead, however, he spent the greater portion of his summary of the evidence trying to discredit Hudson's use of the race card as a cynical diversion from the real issues in the case. Davis accused the prosecution of seeking to conjure up the basest passion of race prejudice in the jury. He appealed to the jurors not to let the prosecution's racist tactics blind them to the class interests that they shared with Herndon. Gentlemen of the jury, just as starvation, want and suffering knows sick no color or race line, neither does injustice and exploitation. What happens to Herndon today as you ponder his fate in the jury room is going to determine what is going to happen to you when the sharp pains of hunger tug at the helpless emaciated forms of your loved ones tomorrow. 4. By the time the case went to the jury, the ideological battle lines between defense and prosecution could not have been more starkly drawn. At base, the choice between the two competing characterizations of Herndon's political activities would turn on the jurors' choice between competing claims of class and color. Although Judge Wyatt had not hidden his hostility toward Herndon during the trial, his instructions to the jury were remarkably restrained and, from Herndon's perspective, generally favorable. Wyatt's charge to the jury was based on a much more generous interpretation of Section 56 than the interpretation placed on it when the case was appealed to the Georgia Supreme Court. After reminding the jury that Herndon was entitled to a legal presumption of innocence until proven guilty beyond a reasonable doubt, Judge Wyatt went on to read the indictment. He noted that mere advocacy of insurrection, however reprehensible morally, would not warrant a guilty verdict unless the state had met its burden of proving that the advocacy was intended to be acted upon immediately. In order to convict the defendant, Gentlemen, it must appear clearly by the evidence that immediate serious violence against the state of Georgia was to be expected or was advocated. Registered degree. Judge Wyatt added that the mere possession of radical literature alone is not sufficient to constitute the crime of attempting to incite insurrection. Degree. After admonishing the jury that the object of all legal investigations is the discovery of the truth, registered the judge sent the 12 white men off to decide the fate of Angelo Herndon. After deliberating just 2 hours, the jury returned to announce its verdict. It found Angelo Herndon guilty of attempting to incite insurrection but also recommended that the state grant him mercy, as the jury had the power statutorily to do. This meant that instead of being sentenced to die, Angelo Herndon would be condemned to 18 to 20 years of what John Spivak had described in Georgia Nigger as the living death of a chain gang. A review of the record leaves little doubt that the prosecution of Angelo Herndon was a classic political trial. Politics figured in the Herndon case in at least 2 discrete senses. First, the Herndon trial can be called political because of the nature of the formal charges against him. As the language of the Georgia Penal Code and the indictment made clear, the attempt to incite insurrection was deemed a political crime against the lawful authority of the state of Georgia. However, the Herndon prosecution discloses a second political aspect that is best understood in cultural rather than legal terms. Attention to the language used at Herndon's trial indicates the degree to which the courtroom struggle over the legality of Herndon's political activities took place within a larger field of cultural contestation over racial meanings. It is not simply that the ideological disputes over race and culture that took place during the Herndon trial were intimately linked to ideological arguments about the legal control of political dissent. Rather, the legal debates at the Herndon trial about the competing claims of state power and individual rights were at the same time debates. Rouge et noir reread. About the cultural politics and the political culture of white racism. To state the point in slightly different terms, it was in the language of race that the courtroom clashes about the proper legal interpretation of Herndon's PUSA activities found their most potent cultural signifiers. To use a term of G. Edward White, racial rhetoric inscribed itself alongside and within legal argument. The language of race served as an instrument and a symbol of cultural contention over radical politics and state power. When the U.S. Supreme Court was asked to review the constitutional issues raised by the Angelo Herndon case, its response betrayed no sign that this had been what one contemporary observer termed one of the most spectacular trials in the annals of Fulton Superior Court. By that time, the heated disputes over race, culture, and power which had figured so prominently at the trial had apparently disappeared without a trace. With the passage of time and the change of judicial venue, the political passions and prejudices that had led to the trial and conviction of Angelo Herndon were obscured, though not utterly erased, by the cool logic and language of the law. That court or history, Herndon. And the constitutional historians. A rationale of history one's the first step whereby the dispossessed repossess the world. Kenneth Burke registered. A. Herndon and the escape from history. This section considers the fate of the Angelo Herndon case in American constitutional historiography. My intention in what follows is not to offer an exhaustive descriptive account and analysis of mainstream American legal scholarship on the case. Rather, my goals are decidedly selective and critical. I want to review three typical historical views of the Angelo Herndon case, developed in the work of Wallace Mendelsohn, Paul Murphy, and David Curry. More precisely, I want to advance an argument about the rhetorical forms in which these inter. 481. Pretensions are cast. I begin with a brief description of the main outlines of what each of these authors has to say about the Angelo Herndon case. Herndon and the History of an Ideal. In an article entitled Clear and Present Danger from Schenck to Dennis, Wallace Mendelsohn traces the evolution of the clear and present danger doctrine from its initial use by Justice Holmes. Although Mendelsohn concedes that the doctrine has embodied a deeply democratic instinct favoring the free expression of ideas, he suggests that it has been more significant as a pervasive atmospheric pressure, than as a reliable standard for the decision of a specific case or as a rationale for a line of cases. The burden of the article is to show how and why clear and present danger has remained more of a great ideal than an effective guide to decision. Mendelsohn's main reference to the Angelo Herndon case appears in a brief discussion of the use of the clear and present danger doctrine between 1930 and 1940. According to Mendelsohn, the decade of the 30s far surpasses all prior decades in the number of Supreme Court decisions vindicating civil liberties. And yet, he observes, the danger rule was mentioned only twice, once as an oblique underpinning for the court's position and once in a dissent by Mr. Justice Cardozo. Both references, we find in Mendelsohn's footnotes, involve judgments by the court on the issues raised in the Angelo Herndon case. In charting the fortunes of the clear and present danger test during the 30s, Mendelsohn aims to paint a picture in which the Hughes Court, unlike its predecessors, courageously assumed the role of guardian and protector against efforts by state and federal authorities to make inroads on the freedom of expression guaranteed under the First Amendment. The Chief Justiceship of Mr. Hughes, writes Mendelsohn, clearly marks a new dispensation. He concludes that the primary contribution of the Hughes Court is that it kept Holmes's great ideal alive, albeit obliquely, until a. 482 Race and Postmodernism. It could be revived by a virtually unanimous court. In the next decade. 2. Herndon and the History of an Agenda. Another discussion of the history of the Herndon case is found in Paul Murphy's The Constitution in Crisis Times, 1918-1969.1 For Murphy, the Herndon case is most profitably understood as a product of a decisive ideological shift on the Supreme Court. Under Murphy's interpretation, the social and economic dislocation of the Depression engendered a corresponding crisis in predominant conceptions of the nature of the judicial function in particular as well as in the relationship of law to society in general. For Murphy, Herndon must be set against the backdrop of this fundamental ideological transformation. Murphy thinks of the First Amendment decisions of the Hughes Court as part of a new judicial campaign that sought to undermine irresponsible state or state-sanctioned action. Copyright These decisions reflected the Supreme Court's acceptance of the increasingly influential idea advanced by the legal realists that government had an obligation to eliminate legal strictures that prevented the constructive use of personal liberty. In Murphy's reading, however, the Herndon case also demonstrated that the court's new commitment to the protection of individual freedom did not represent a complete break with old understandings. For Murphy, the clearest evidence of this underlying continuity is the fact that the court did not rush to judgment in the Herndon case. The court, on the other hand, clearly had no intention of upholding every vague challenge to local authority simply because local citizens felt that their rights were in one way or another being abrogated. It rejected, in 1935, the plea of a Negro communist organizer in Georgia that an ancient insurrection statute under which he had been arrested deprived him of his constitutional rights. Its denial was based on the fact that he failed to specify which rights were being violated. Only when, in subsequent appeal, specific charges of free speech violation were leveled did the justices consider the issue. Then, speaking through Justice Roberts, they held that the statute as construed and applied was repugnant to the 14th Amendment in that it furnished no sufficiently ascertainable standard of guilt and that it interfered unduly with speech and assembly, not demonstrably creating a clear and present danger of the use of force against the state. 1 In Murphy's account, the court's refusal to disregard its procedural requirements was an attempt to reconcile its respect for established principles of constitutional federalism with its increased receptivity to First Amendment claims against the states. 3. Herndon and the History of an Institution. A third and more recent historical treatment of the Herndon case appears in David Kay's The Constitution in the Supreme Court, Civil Rights and Liberties, 1930-1941. Like Mendelssohn and Murphy, Curry characterizes the 30s as a period in which the decisions of the court evidenced its increasing inclination toward stricter scrutiny of punishment for allegedly subversive expression. Of the court's three considerations of the Herndon case, Curry mentions only Herndon v. Lowry. That case stands out because it is the least revolutionary of the court's three main decisions regarding the federal constitutional protection against state invasions of civil liberties. In Kay's analysis, the constitutional significance of Herndon v. Lowry lies in the fact that it evinced the court's willingness to examine and assess the nature of the evidence on which a challenged conviction for subversive speech was based. For Curry, the court's new spirit of aggressiveness in reviewing judicial findings affecting expression 1. In Herndon v. Lowry was a sign that a majority of the court had come to accept the orientation toward First Amendment analysis that Justices Oliver Wendell Holmes and Louis Brandeis had staked out in earlier decades. See Making History. The indifference exhibited by Mendelssohn, Murphy, and Curry to other texts and other narratives materials from which they might have Rouge Noir reread 483. Derived. A very different account of the Angelo Herndon case appears to be driven by largely unacknowledged investments. I do not mean to suggest that the relationship between their interpretations and the ideological investments that inform them is indefensible. Rather, I believe that the combined force of their interpretive models and ideological affiliations forecloses lines of historical inquiry that might call their approaches and results into question. More fundamentally, what Murphy, Mendelssohn, and Curry have to say about the Angelo Herndon case reflects something more than mere intellectual interest. Ultimately, the belief that the case and the court's First Amendment jurisprudence as a whole reflect a striving for fidelity to a true line of progress * is just that, a belief. It is this article of faith more than any other feature of their work that forces the recognition that their accounts of Herndon are not disinterested scholarly analyses but rather interested interventions in a contested ideological field. In short, each of these works resonates with ideological affiliations and implications that a popular counter-memory of the Herndon case aims, in the strongest sense of the term, to expose. There is a sense that the belief in the inexorable laws of development driving the historical work we have examined actually reflects a certain contempt for ordinary people, such as Herndon. A popular constitutional history of the Herndon case is skeptical of any historical practice that forces the events that led to Herndon v. Georgia and Herndon v. Lowry into the interpretive model of foreordained progress. A popular constitutional history is unwilling to impose a teleological framework on the raw material that constitutes its object of study. The source of this agnosticism is a realization that the progressivist vision of constitutional history is both an interpretive structure of memory and remembering and, at the same time, an ideological strategy of organized forgetting : degree what is forgotten, though, is the lived experience of those whose stories disrupt the ordered image that the historical narrative of constitutional progress imposes on an unruly past. It is precisely this aspect of organized forgetting that I have aimed to identify and interrogate in my critical readings of the rhetorical and narrative dimensions of the accounts of Mendelssohn, Curry, and Murphy. History does not always have a happy ending. When one considers the cultural context in which Herndon v. Georgia arose and was adjudicated, it was at the time far from obvious that the defeat in that case would become the success story of Herndon v. Lowry. This is probably the main reason for the doctrinal and historical segregation of the two cases from each other, for the events leading up to the court's decision in Herndon v. Georgia tell a story of repression and resistance, a story that is crucial to an understanding of the case from the bottom up. A subaltern perspective on the Angelo Herndon case discloses an alternative historical vision of the 30s, in which First Amendment law was a contested terrain, scarred and cracked by a bleak and often bloody political past. In my view, Let Me Live and the decision in Herndon v. Georgia are important textual sources for recounting this counter-memory of repression and resistance. As such, they should not be cordoned off in a separate historical field. The heart of my argument is that the questions of race, power, and culture are no less central to Herndon's significance in our constitutional history than the aspects of the case around which institutional histories have revolved. I believe, with W.E.B. Du Bois, that the subaltern's view of Herndon v. Georgia tells a story of which constitutional history has saved all too little of authentic record and tried to forget or ignore even the little saved. 1 degree in reading the record of the case left by Herndon himself, I have sought to highlight features of the case which seem to be outside the interpretive horizon of institutional history. The themes of resistance and repression sounded in Let Me Live must be accorded their rightful place, alongside the theme of progress which has so captured the institutionalist's historical imagination. A history of the Angelo Herndon case that ignores his subaltern account of its significance is a history, in Herndon's words, without blood and entrails. 7. Herndon's account is valuable because it provides a perspective on the 484 race and postmodernism case from below, from the point of view of those for whom history is what hurts. 8. I am not endorsing a historical practice that uncritically siphons off Herndon's subaltern experience from the larger historical current of which it was a part. The two are inextricably related. Their separation is neither possible nor desirable. However, I do contend that Herndon's subaltern experience, or, more precisely, the recorded remains of it, is as fundamental and significant an index of American constitutionalism as that found in official legal texts. My insistence on reckoning the constitutional meanings into the cultural record left by the historically dispossessed is not merely an effort to replace the current hegemony of institutional history with that of a hegemonic popular memory. It is an attempt, rather, to retrieve the buried and subjugated knowledges bequeathed to us by Americans who lived out their lives at the bottom of our constitutional order. My discussion has been guided by three main concerns. First, I have tried to show that the complex ebb and flow of the events that make up American constitutional history is likely to remain obscure unless the experiences of individuals like this young black coal miner are brought to its surface. Second, I have tried to indicate why, when those experiences are brought to the surface of constitutional history, they expand like a ripple in a pond. What Herndon has to say about his experience sheds light on the cultural foundations of legal ideology and institutions and, thus, it calls our attention to the ways that law and culture have intersected in American constitutional history. Third, in urging that the subaltern record of the Herndon case left in Let Me Live must be taken seriously, I have tried to clear the ground for a fresh reading of the text of Herndon v. Georgia itself. The interpretive model I have developed for reading Herndon's non-official account of the case also provides a framework for rereading official legal texts. The historiographical interest of such an undertaking, as I presently show, is that it permits us to see traces of subaltern political consciousness inscribed in the very terms and texture of the judicial discourse, through which the court tried to avoid both the constitutional issues raised in Herndon v. Georgia and the broader conflicts regarding race, culture, and power for which these issues were a site of intersection. D. The rhetoric of resistance. A rhetorical reading of Herndon v. Georgia might most profitably proceed by attending to the politics of discourse that informs the court's analysis of when, how, and to whom it may speak the law. Viewed in these terms, the court's opinion reveals itself to be an instance of the very power that it claims merely to address. I take the conception of rhetoric as the politics of discourse from Paulo Valesio, degree, who argues that it is no more possible to speak without being rhetorical than it is to live without breathing. 7. All communication is in this sense rhetorical. Valesio maintains that even discourses like the discourse of law, which pretend a plain, forthright opposition to rhetorical ornament, embody a subtle and deceitful form of rhetoric, what he calls the rhetoric of anti-rhetoric. 7. Valesio argues for a technique of political reading that delves beneath a discourse's apparent subject matter to reveal the rhetorical structures that are its bones and sinews, indeed its very biological structure. Rhetoric, in this perspective, constitutes the real politics of the text, the only kind of politics that is really relevant to its interpretation. 73-74 Few would disagree that the judicial opinion can be placed squarely within the tradition of the literature of legal persuasion, degree and conviction. As Anthony Kronman puts it, legal discourse represents, in essence, the construction of a convincing or persuasive argument. 17 degrees. Similarly, Mark Tushnet has broadly defined judicial opinions as structures of thought, fixed in documents designed to convince by linking specific results to general assumptions. 127. What is most striking about the opinion in Herndon v. Georgia, however, is the degree to which the suasive work of the text relies on Rouge Noir. Reread 485. Silence and strategic omission. The structured absences in the text of the court's opinion can nonetheless be forced to yield up their meaning. A group of contemporaneous Supreme Court decisions, whose connections to Herndon seem to have eluded most students of the case, help to show that while the court's opinion in Herndon v. Georgia claims to be and appears to be about radical politics, it is in fact best understood as a case about the politics of race. The starting point for such a reading is the very first line of Justice Sutherland's opinion for the court. Appellant was sentenced to a term of imprisonment upon conviction by a jury in a Georgia court of first instance of an attempt to incite insurrection by endeavoring to induce others to join in combined resistance to the authority of the state, to be accomplished by acts of violence, in violation of Section 56 of the Penal Code of Georgia. The Supreme Court of the state affirmed the judgment. On this appeal, the statute is assailed as contravening the Due Process Clause of the 14th Amendment in certain designated particulars. We find it unnecessary to review the points made, since this court is without jurisdiction for the reason that no federal question was seasonably raised in the court below or passed upon by that court. 178. This opening passage serves a double function. One commentator has suggested that a substantial part of legal discourse is not even particularly legal, but is merely descriptive of the facts to be dealt with. This suggests that the mere description of the facts in legal discourse cannot be said to be part of its ideological composition. It is, rather, a neutral statement of what happened. In my view, it is precisely the conservatism of the statement of the facts what it does not say that alerts us to the form of the discursive politics of Herndon v. Georgia. The opening passage provides an exemplary instance of the rhetoric of anti-rhetoric. Degree its substantive function is to limit the scope of the questions which the court will address to its narrowest possible range. Note how little information is given about the appellant or about the substantive constitutional issues the court is being asked to address. We find it unnecessary to review the points made to support the appeal. Note, 2, the passivity of the language of the final sentence of the paragraph. The problem of jurisdiction, the power of the court to speak law, is rhetorically framed as something that is found or vested or conferred, not something that is taken. In Sutherland's view, the court, through no fault of its own, is without jurisdiction. This presumption of powerlessness shapes the court's subsequent discussion and guides us toward the political core of the text. Let us compare the passive language of Justice Sutherland with the statement of the facts in Justice Benjamin Cardozo's dissent 3. Cardozo begins by noting that the appellant has been convicted of an attempt to incite insurrection in violation of the Penal Code of Georgia. Although the language in which Cardozo frames his statement of the facts is, like Sutherland's opinion, rigorously technical, it stands in subtle but significant contrast to Sutherland's opening lines. Cardozo approaches the facts of the case in terms of the events that led to Herndon's conviction. Sutherland, on the other hand, begins by noting that the appellant was sentenced to a prison term. By itself, Sutherland's focus on the consequences of the conviction, as opposed to the legal processes that led to the conviction, may not mean much. However, Sutherland's emphasis on punishment is resonant with political meaning, especially when one remembers just who the appellant was, a fact that the opinion very carefully avoids mentioning. The exclusionary force of the bloodless factual language Sutherland uses to set up his legal analysis becomes clear when one compares it to the opening lines of Sutherland's opinion in Powell v. Alabama, the 1932 decision in which the court first took up the constitutional issues presented in the Scottsboro cases. The petitioners, hereinafter referred to as defendants, are Negroes charged with the crime of rape, committed upon the persons of two white girls. The crime is said to have been committed on March 25, 1931. The indictment was returned in a state court of first instance on March 31, and the record recites that on the same day the defendants were arraigned and entered pleas of not guilty. No counsel had been employed, and aside from a 486 race and postmodernism statement made by the trial judge several days later, the record does not disclose when or who was appointed. It is perfectly apparent that the proceedings, from beginning to end, took place in an atmosphere of tense, hostile, and excited public sentiment. During the entire time, the defendants were closely confined or were under military guard. The record does not disclose their ages, except that one of them was 19, but the record clearly indicates that most, if not all, of them were youthful, and they are constantly referred to as the boys. They were ignorant and illiterate. 1%. This passage is also a statement of the facts of a case, but the differences between the two texts, written by the same author, are remarkable. In Powell, Sutherland is keenly aware of the concrete circumstances in which the court is intervening. His rhetoric captures the socio-political drama behind the legal questions to which the court's judgment is addressed. It notes the convergence of race, gender, age, and class, and it uses the statement of facts to presage the outcome. The stark contrast between the rhetorical politics of Powell and the textual strategy of Herndon is startling. In Herndon, Sutherland does not note even once that Angelo Herndon, the appellant, never even the defendant, was black, or that he was only 19 at the time of his arrest and conviction. But for the pronoun he, the reader would have no clue even as to Herndon's gender. Nor does Sutherland discuss at all the extent to which Herndon's trial, like that of the Scottsboro defendants, took place in a tense, hostile atmosphere. The court cannot have been unmindful of these omitted facts. The constitutional relevance of race in Herndon is underscored in the evidentiary record and in Herndon's brief, which describes Sutherland's accused as a Negro. 1%. The marked exclusion from Sutherland's opinion of the language of race, degree is the most significant textual indication of the court's determination to avoid the constitutional issues in Herndon v. Georgia, and with them the political realities in which these issues were lodged. To make the point another way, the court's silence on the politics of race must be read symptomatically. My choice of that term is deliberate. Sigmund Freud identified the essence of repression as simply turning something away, and keeping it at a distance, from the conscious. The court's omission of the fact that Herndon was an African American criminal defendant appealing a conviction from a Southern court is a textualized instance of such a psychic gesture. I shall consider in more depth the meaning of the court's silence on Herndon's race, because it highlights the need to pay close attention to the political unconscious 7 of the judicial discourse in Herndon. However, first I will discuss Sutherland's other rhetorical silences so that we may consider his silence on Herndon's race against this broader constellation. We have seen that the inaugural gesture of Sutherland's opinion is one of exclusion, omission, and silence. This rhetorical strategy sets the analytic itinerary of the rest of the opinion. It is true that there was a preliminary attack upon the indictment in the trial court on the ground, among others, that the statute was in violation of the Constitution of the United States, and that this contention was overruled. But, in addition to the insufficiency of the specification, the adverse action of the trial court was not preserved by exceptions pendent light or assigned as error in due time in the Bill of Exceptions, as the settled rules of the state practice require. In that situation, the state Supreme Court declined to review any of the rulings of the trial court in respect of that and other preliminary issues, and this determination of the state court is conclusive here. John v. Paulin, 231 U.S. 583, 585, Atlantic Coast Line Arco v. Mims, 242 U.S. 532, 535, Nevada, California, Oregon Rev. Burris, 244 U.S. 103, 105, Brooks v. Missouri, 124 U.S. 394, 400, Central Union Telephone Co. v. Edwardsville, 269 U.S. 190, 194 to 195, Erd-RR. Co. v. Purdy, 185 U.S. 148, 154, Mutual Life Inns. Co. v. McGrew, 188 U.S. 291, 308. The federal question was never properly presented to the state Supreme Court unless upon motion for rehearing, and that court then refused to consider it. The long-established general rule is that the attempt to raise a federal question after judgment, upon a petition for rehearing, comes too late, unless the court actually entertains the question and decides it. Texas and Pacific C. Re. Co. v. Southern Pacific Co., 137 U.S. 48, 54, Lober v. Schroeder, 149 U.S. 580, 585, Godshall Co. v. Estopanal, 251 U.S. 179, 181, Rooker v. Fidelity Trust Co., 261 U.S. 114, 117, Tidal Oil Co. v. Flanagan, 263 U.S. 444, 454 to 455, and cases cited. 138. Rouge et Noir reread. The conceptual infrastructure of this passage argues that a judicial decision can be justified only if it is authorized by an already existing rule of law, that is, by precedent. I need not enter here into a full-fledged discussion of theories of legal precedent, rather, I want to approach the dialectical relay between assertion and appeal to authority set up in this passage in terms of what might be called the politics of spatialization. As law, the thrust of the passage is clear enough: the Supreme Court cannot reach the merits of Herndon v. Georgia because the case's constitutional question was not raised in the trial court and because the state Supreme Court declined to consider it. As discourse, the passage links the past and the present in space, on the page, joining them in a conceptual and doctrinal identity. The unstated assumption behind the citations is that the court is only doing here what it has done many times before, that this case is the same as the past cases cited in the text. The court has no choice but to decline jurisdiction, because like cases must be treated alike. Thus, the discussion of Angelo Herndon's unsuccessful attack on his conviction is situated in an appeal to the authority of the past. He settled rules of state practice and a long-established general rule dictate the result. Yet this passage is no less ideological than the omission of all information that would have humanized the accused or brought to light the social and political circumstances of his case. This becomes clearer in the next paragraph of the opinion. Petitioner, however, contends that the present case falls within an exception to the rule, namely, that the question respecting the validity of the statute as applied by the lower court first arose from its unanticipated act in giving to the statute a new construction which threatened rights under the Constitution. There is no doubt that the federal claim was timely if the ruling of the state court could not have been anticipated and a petition for rehearing presented the first opportunity for raising it. Saunders v. Shaw, 244 U.S. 317, 320, Odio v. Akron Park District, 281 U.S. 74, 79, Missouri v. Jenner, 281 U.S. 313, 320, Brinkerhoff Ferrisco v. Hill, 281 U.S. 673, 677 to 678, American Surety Co. v. Baldwin, 287 U.S. 156, 164, Great Northern Re v. Sunburst Oil Co., 287 U.S. 358, 367. The whole point, therefore, is whether the ruling here assailed 487, that is, that of the Georgia Supreme Court, should have been anticipated. In the discussion of the trial proceedings, I note that Judge Wyatt instructed the jury that mere advocacy of insurrection, however reprehensible morally, would not justify a guilty verdict unless the jury found that Herndon had intended his advocacy to be acted upon immediately. In order to convict the defendant, gentlemen, it must appear clearly by the evidence that immediate serious violence against the state of Georgia was to be expected or was advocated. 4 Although Herndon's counsel objected to this charge, it was in fact stricter than the test they argued should be applied, the clear and present danger test. The Supreme Court had applied the clear and present danger test to statutes, such as Section 56 of the Georgia Penal Code, that did not criminalize specific language but merely prohibited certain acts. When the acts were verbal, the court had held that a conviction could stand only when the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress and the state legislatures had a right to prevent. From Herndon's point of view, then, the critical question on appeal to the Georgia Supreme Court was not whether the trial court had given an unfavorable jury charge, it had not, but whether the evidence warranted a conviction under the jury instruction the trial court had given. However, the state Supreme Court ruled that the trial court had been wrong in its charge. Section 56, the court said, did not require that violence should follow Herndon's words immediately, or even at all, nor, presumably, that the violent consequences be serious or widespread. Rather, it would be sufficient that Herndon intended violence to happen at any time, as a result of his influence, by those whom he sought to incite. On that reading, the court refused to overturn Herndon's conviction. This expansive, to say the least, reading smacks of the old bad tendency test the Supreme Court had, apparently, rejected in favor of the clear and present danger test, for as Chaffee points out in Free Speech in the United I. 488 Race and Postmodernism. States, the state Supreme Court's test was so wide as to be fatal to open discussion, degree or even moderate disagreement and dissent. It was this radically open-ended bad tendency interpretation that Herndon's counsel challenged for the first time on a motion for rehearing, a motion the state court rejected on the rather capricious ground that it had not literally meant at any time, but only any reasonable time. #degree. Similarly, it was this unanticipated interpretation of Section 56 that was the basis of the argument made on Herndon's behalf before the Supreme Court. That Herndon's case fell within the recognized exception to the rule that the Supreme Court could not take jurisdiction of cases in which the constitutional issues the court was being asked to decide had been raised for the first time on a motion for rehearing in the highest state court after that court had heard and decided the case upon Appeal 46. As Sutherland analyzes the case, the whole point in Herndon v. Georgia is not that the state court rejected the trial court's jury charge, but rather that Herndon's counsel should have known that the trial court's charge was wrong. The verdict of the jury was returned on January 18, 1933, and judgment immediately followed. On July 5, 1933, the trial court overruled a motion for new trial. The original opinion was handed down and the judgment of the state Supreme Court entered on May 24, 1934. The case having been in that court since the preceding July. On March 18, 1933, several months prior to the action of the trial court on the motion for new trial, the state Supreme Court had decided Carr v. State, 176 GA 747, 169 SE 201. In that case Section 56 of the Penal Code, under which it arose, was challenged as contravening the 14th Amendment. The court in substance construed the statute as it did in the present case. In the course of the opinion it said, p. 750, the state cannot reasonably be required to defer the adoption of measures for its own peace and safety until the revolutionary utterances lead to actual disturbances of the public peace of imminent and immediate danger of its own destruction, but it may, in the exercise of its judgment, suppress the threatened danger in its incipiency. Manifestly, the legislature has authority to forbid the advocacy of a doctrine designed and intended to overthrow the government without waiting until there is a present and imminent danger of the success of the plan advocated. If the state were compelled to wait until the apprehended danger became certain, then its right to protect itself would come into being simultaneously with the overthrow of the government, when there would be neither prosecuting officers nor courts for the enforcement of the law. The language contained in the subquotation is taken from People v. Lloyd, 304 ill 23, 35, 136 NE 505, and is quoted with approval by this court in Gitlow v. New York, 268 U.S. 652, 669. In the present case, following the language quoted at an earlier point in this opinion to the effect that it was sufficient if the defendant intended an insurrection to follow at any time, etc., the court below, in its original opinion, 178 GA 855, added it was the intention of this law to arrest at its incipiency any effort to overthrow the state government, where it takes the form of an actual attempt to incite insurrection. 47. Earlier in my discussion, I contrasted the texture and tone of Justice Sutherland's statement of the facts in Herndon with his statement of the facts in Powell v. Alabama. In Herndon, Sutherland recites an antiseptic procedural account, but in Powell, he painstakingly situates his discussion of the constitutional issues in a concrete social and political context. What is interesting is that Powell, not Herndon, is the norm. Of the court's decisions from this period that invalidated the convictions of African American defendants on constitutional grounds, all except Herndon follow Powell's rhetorical strategy with respect to the politics of race. Consider, for example, the language of the court's opinions in Norris v. Alabama Registered and Patterson v. Alabama, decided a bare month before Herndon v. Georgia. Writing for the court in Norris, Chief Justice Hughes begins by noting that the petitioner, Clarence Norris, is one of 9 Negro boys who were indicted in March, 1931, in Jackson County, Alabama, for the crime of rape. Degree in Patterson, another opinion by the Chief Justice, the race of the defendant and the location of his alleged crime also introduce the court's analysis of the relevant constitutional issues. A year after Herndon, in Brown v. Mississippi the court invalidated several murder convictions because they were based solely on Rouge et Noir reread 489. Confessions procured by physical torture. Chief Justice Hughes again wrote the opinion, quoting extensively from the Alabama Supreme Court's opinion in the case. The quoted passages refer to the defendants as all ignorant Negroes registered 3 and describe in meticulous detail the torture of these helpless prisoners at the hands of a white mob. 1 degree in each of these cases, the court placed the brute facts of racism and power in the foreground of its constitutional analysis. The opinions in Brown, Norris, Powell, and Patterson emphasize these realities of race and region even though, on the face of it, none of the cases required it. Indeed, in Patterson, sensitivity to racial politics led the Chief Justice to address the substantive constitutional issues even though the state of Alabama claimed that the court could not properly take jurisdiction. Significantly, the jurisdictional question in Patterson was whether the defendant had lost his right to Supreme Court review by failing to take timely action in the state courts to preserve his federal claim. In Herndon, Hughes agreed with Sutherland that Angelo Herndon had forfeited his right to Supreme Court jurisdiction, but here, he had no time for too fastidious a concern for the procedural difficulties of the case, given what he describes in constitutional terms as a serious situation. In Brown, Norris, Powell, and Patterson, the Supreme Court acted to protect African Americans against the most egregious uses of the criminal process as an instrument of racial domination. I believe that the court was able to justify these interventions to the country and to itself by showing that the defendants in those cases fit contemporary cultural images of African Americans. These defendants, as Justice Sutherland writes in Powell, were ignorant and illiterate Negroes and thus fit objects for a jurisprudence of mercy. 1 degree Herndon confronted the court with an altogether different sort of black defendant. The Angelo Herndon case marked the first occasion on which the Supreme Court was forced to come to terms so directly with the concept of political crime in a case in which the alleged criminal was a black American. If Angelo Herndon was a political criminal, what of the white Southerners who, if the court upheld his conviction, stood ready to punish him? The court had to face harsh historical and contemporary realities that it could neither ignore nor openly acknowledge. If it intervened, it would have to decisively condemn the racial and political culture that Herndon too had fought. This was a step that ideology and cultural experience did not yet allow the court to take. Indeed, shortly before it decided Herndon v. Georgia, it also declared that the Texas Democratic Party's exclusion of blacks was not state action, registered showing its willingness to tolerate all but the most visible, formal exclusions of black Americans from the political process. In 1937, 2 years after Herndon v. Georgia and 1 year after its denial of a motion for a rehearing in the case, the Supreme Court issued its third, final, favorable judgment on Angelo Herndon's constitutional claim. The court's ultimate vindication of Angelo Herndon's First Amendment rights marks an important moment in the history of free speech jurisprudence. As a doctrinal matter, it can and should be viewed as a landmark First Amendment decision. What I have tried to show here, however, is that the history of the Herndon case is more than a story about the constitutional politics of the First Amendment. There is another story behind the case, and that story is about the constitutional politics of race. Properly understood, the Herndon case must be placed at the intersection of 2 jurisprudential axes. The Herndon case marks the beginnings of the modern Supreme Court's hesitant and halting efforts to address the dissonance in American legal and political consciousness between 2 competing images of the African American community generally and of the black male in particular as an ignorant and helpless victim, on one hand, and a dangerous insurgent, on the other. In the 30s, these two contradictory images of the black American still weighed like a nightmare on the white American mind. In Herndon v. Georgia, the Supreme Court found itself caught between these two warring cultural images, which held 490 race and postmodernism. Decidedly different political and constitutional implications. Rather than choose between them, the court decided not to decide. Conclusion. Avid Lubin has recently argued that legal discourse is neither analytic nor empirical, but rather historical. The life of the law is not a vision of the future but a vision of the past. 1° legal argument may thus be understood as a struggle for the privilege of recounting the past. To the victor goes the right to infuse a constitutional clause, or a statute, or a series of prior decisions with the meaning that it will henceforth bear. 1° What Professor Lubin says of legal argument and its outcome holds equally true for argument and interpretation in legal history. This article has undertaken a historical rereading of the Angelo Herndon case from below. I have focused on the events leading up to the Supreme Court's decision in Herndon v. Georgia. Have done this not because I believe that Herndon v. Lowry was not an important constitutional victory, but rather because the story of the constitutional failure in Herndon v. Georgia is an equally important part of the historical record. As we have seen, the great weight of historical scholarship has focused on the court's decision in Herndon v. Lowry. The absence of Herndon v. Georgia in most histories of the case suggests that some 50 years later, the Angelo Herndon story is still not a fully citable episode in our constitutional history. Revisiting that history from the bottom up, I have aimed to show that we cannot remember only one part of that story without forgetting them both.